Hey, so just to let everybody know what we're doing. So we had talked about kind of in the YouTube chat earlier. So Denise watched the 2008 trial. She watched a bunch of it, and she was pretty convinced at that time that Mark Jensen was guilty. Now she's come back and she's watching the retrial of Mark Jensen, and she's been with us for a while since the start here and following on, and she's been kind of taking notes. So tell us about the trial that you watched in 2008. What made you really think that Jensen was guilty in 2008?
Well, the first thing I would say is the letter, was a big thing. And then when I didn't hear that long ago that the letter had gotten thrown out and that it was retrying. I didn't hear about that a year ago. I didn't hear about it anywhere. And I was just on my phone at work and I was looking for a trial or something to watch. And I was like, what is this? So I was like, there's no way. This has to be the letter that they're throwing out. So I went and I did a little research. And I'm like, holy smokes, I can't believe this. And so it was hugely convincing. But even then, I was like, if they throw this letter out, there's still so much circumstantial evidence that was in that case between the neighbors and, not knowing what they were going to allow in. But the computer stuff was a huge thing. The Klugs were a huge thing. It wasn't just that Klug, because he's a weasel, right? I mean, we all know he's a weasel. He's like the wormtail, of this. If this was Harry Potter, he's the wormtail, But I would say, but his wife was so convincing. You know what I mean? I'm like, why would his wife lie for him? So then with this trial, when the wife came on, I was like, okay, now they're divorced. So, if she thought that he was bullshitting back then, unless she did it to save her own face or the fact that she would have gotten in trouble for, testifying in a court of law and not being honest,
right?
What reason would she have to lie for her weasel husband now, But then when he said he went back to the Appleton branch, right, and they had gotten a call there, and when there was the woman that they had gone back and forth without the presence of the jury about the excited utterance, I believe the woman was a secretary, her name was Stephanie maybe, and she said, oh shit, he killed her. He also went back to that same branch. I believe it was Appleton that Klug was in. Klug, sorry. When he went back there after that, what did they call that conference? The summit or whatever they did. I can't remember the name of it now. But when he went back there, he was talking shit in the office. Allegedly, he was talking shit in the office. He was going up to anybody who would listen to him talk and saying, oh my God, Mark Jensen told me he was going to kill his wife. I don't doubt that the two of them, if the conversation did happen, that they were both hypothetically talking about it, which I think was probably a reason why he didn't come forward. So that's kind of like what I always thought. Like that would be the reason why he didn't come forward, because he would incriminate himself and he was trying to work things out with his wife, and they had renewed their vows and all that crap, But now I would really like to see, and I don't remember because like we're going back 14 years and, I have COVID. Okay. So like I have COVID brain right now. So the fact that I can't even remember all this stuff in detail is kind of crazy to me. But, if there was a corroborating witness from back in the day in 1998 that could come forward and say, yeah, he came back and he was telling everybody by the water cooler or at lunch or wherever that Mark said he was going to poison his wife with antifreeze, that would change things for me. But at this point, as it stands, the defense case hasn't even started their case in chief yet. That's what's crazy. They are annihilating their witnesses.
Website visitors bouncing? Stress less. Convert more. Try Hotjar.
Yeah.
Right?
Yeah, I think they absolutely are. I mean, we've seen the pathologist, Michael Chambliss, that was a big one because he was a key witness back then. And I think Attorney Perry absolutely demolished him. And then the very end there, where he gets him to say, he starts talking about the antifreeze and asks him about it. And Chambliss is like, I don't even know. I don't want to speculate on anything. I'm not an expert. I don't know the chemical compounds of it. I don't know anything. And then I think that pretty much shut down Perry's whole line of questioning. And he just jumped right to the end and said, so if you testified about this in 2008, do you wish you hadn't? And Chambliss says, yeah, I wish I hadn't. And I went, oh my God.
Yeah, I would have tapped out right there too. I'd been like, thank you, sir.
Right.
It's been a pleasure. Grab a t-shirt on the way out. Bye.
Yeah, exactly. What else? So like we hear that. And then what other things kind of stuck out to you that like made you kind of go from this guy is 100% guilty to, oh shit, now I'm not sure?
Well, you know what? It was a little hard for me to get sold on the fact that she was doing this gone girl thing. You know what I mean?
I like how you put that. If you guys haven't seen that movie with Ben Affleck, Gone Girl, watch that. And then I want you guys to watch that. All right. Watch that over the weekend. And then seriously tell me that
it's like the basic instinct of our generation. It's terrifying.
Right.
That somebody could do that. So then you think about this woman. That stuff's not even out. The fact that she could think of that, she would have to be one of the most diabolical criminals. You know what I mean? I mean, even though, the only thing that now I buy, because the defense has changed what they're saying. They're not saying she tried to kill herself, saying she attempted to feign suicide, right? That he would get away for attempted murder. And I'm thinking, okay, as a mom, she doesn't want her husband, father of her children, going to jail for murder. She doesn't want to die and leave her children. But okay, I could see her being like, you know what, you little son of a bitch, you fucking torture me with these pictures all the time, and your penis fetish or whatever else you got going on. I'm gonna fix your ass. So maybe she did sit there at home like the good little woman and just, come up with this shit. Maybe there's a book that she read. Who the hell knows? But like, I thought it was weird about the neighbors, because she was so close with all her other neighbors. She honestly wasn't that close with the two that she had entrusted the letter and the rolls of film to.
Right.
And all that stuff. And I'm like, why all of a sudden is she trusting these people over the last 6 months? You know what I mean? She's known them and been basically just say hi and wave neighbors for 7 years, or since they bought the property across the street and then went up buying the property next door to them and building the house and all that stuff. And the guy had done work in their house too. He redid the office. He did work there in their home, and she still wasn't close with them. And then all of a sudden, the last 6 months. So all of this stuff that's coming out in this trial is, I'm just paying more attention to those details now. So, I tried not to take anything from 2008 and carry it over with me, because anytime I watch a trial, I go in there and I'm like, I'm going to pay attention to what the jury is getting. If the jury is not in the room, I'm not going to carry any of that stuff with me to form an opinion about it. But I've been trying, but the damn jury's been out of the room so freaking much of this trial. I'm like, Jesus Christ, it's going to take 6 months to get through this thing.
Right.
And but the computer kid, what's his name? Ruff?
Yeah.
He was fantastic. That was fantastic. I mean, I said, if they could, what was it yesterday? I think I said, if they could show me that Julie, if they could show me a way to make it that Julie lied about being computer savvy, then there's nothing she couldn't lie about. And she was out there spilling that to everybody. And that's what she did. She went and peppered that shit everywhere.
Yes. Yes.
She went and peppered the drinking, the computer stuff. She went and sprinkled that shit everywhere. And not just to anybody, the two neighbors who really didn't talk to anybody else, right? Just the two of them for the last 6 months. I'm surprised she didn't talk to a priest, because she talked to the cops. She talked to these two neighbors who were like freaking saints, right? The school teacher, the school principal knew about it. Like, You know, I'm surprised they didn't come up with a priest too. You know, maybe
Yeah.
she wasn't religious. I don't know. But she really did pepper that shit everywhere. You know, and I was like, "Ooh, yeah, okay, Kevin, I see your point here."
Yeah, see, that's the thing for me. So, you know, I saw the letter. So I knew, so again, transparency. So again, one of the legal counsel is our company counsel.
Mhm.
But again, she can't talk about the details of the case. I told you guys, I texted her, I tried to get her on to, you know, just give us background, not tell us about like the juice, you know what I mean, but give us background about what it is and maybe things we should pay attention to. But she said she can't make media comments. So she's never said anything to me about the case other than, did you hear that the Jensen case is coming back? And I was like, no, I had no idea. And they said, yeah. She goes, yeah, they're not allowing the letter this time. So for me, I focused on the letter and I read the letter and I was like, I'm like, oh, Jesus, this is a damning letter, right?
Mhm.
Like
Yeah.
this is a big deal. So, and then as we like started doing all the background, and I was doing stuff prior, you know, to showing even you guys, but as we were doing the background stuff with you guys and we were playing this old footage and going through the history and case details and background of the confrontation clause, all these things, and listening to the old footage, I was like, man, something's wrong with the I don't drink, something's wrong with the I don't take pills. And I've said that from day one, that I didn't trust that letter to begin with.
Yeah, it's a weird thing to say. I mean, I have a very similar personal background to her as far as having a mother that was an alcoholic. I don't drink very often. I know I joked about it a lot the first day I was on there. But like, I'm very OCD. I plan that shit like it's an event. You know what I mean? When I'm actually going to do it, like it has to be the wind has to be going the right direction. My children have to be accounted for. You know, there has to be nothing that's out of my control when that happens. But everybody around me knows that. And I definitely would never say, oh, I have one or two a week. I don't have one or two a week. I'm lucky if I have one or two every 6 months, you
Right.
know, one or two a week, you're drinking. You know, my background is drug, alcohol, and, you know, criminals with mental health issues. So, you know, an alcoholic is, 3 drinks a night. You know, you have a drinking problem.
Yeah.
It's part of the standardized, system. You know, at least it is, but in the state of New York, and as far as Oasis goes, which is the state agency that oversees all drug and alcohol programs, you know.
Yeah.
So
Wisconsin likes to say if you have a couple of drinks a week, you're an alcoholic. They're kind of psychotic out here.
yeah, it would
But
it would be considered if you're drinking 1 to 2 a night. It's okay. You're drinking a lot, but you're not dependent on alcohol. If you're drinking 3 drinks a night or more, you're dependent. You
yeah,
know.
yeah. What did you think about so is in regards to the forensic kid, DCI guy
Yeah.
from the Fusion Center. So when
And also the I'm sorry to interrupt you. The recordings that you put on last night, those other things, I know they were behind jury stuff that was going on and different things, but those pre-hearing things, I was like, holy shit, this guy is so fucking crooked. Jam Boy and his wife sitting over his shoulder. It's creepy as fuck.
yeah, there's definitely something around Jamboy that I don't trust. And that's why I said, like let's say the cocaine thing, if like let's say that was the only
Oh,
allegation, right?
yeah.
It seems far-fetched. They have put holes in that theory, right? So I mean it could go either way. They definitely put holes in it. So if that was the only thing, I'd be like,
Yeah,
I
but
don't.
I'm sorry, but I don't care what your position in life is. If you don't want anyone, he knows 2 hours away, but that's not a big deal. If you're going to go score coke, you're going to drive 2 hours away, so no one's going to know you. If you're the freaking DA
Yep.
of Kenosha County,
Yep.
why wouldn't he drive 2 hours away? I hope he would, or he's a fucking idiot.
Right. And All right. Good morning. Good morning. Good morning, everybody. Trial is starting up finally. Make sure you guys share this out. Potter, I call everybody baby birds. Men as well. Well, sorry you feel that way. It's like the mama bird feeding all the baby birds. So we feed you guys information. It's a metaphor. All right, welcome everybody. Thanks for tuning in this morning. We have another interesting trial day, day 9 of the Mark Jensen antifreeze murder trial. The medical examiner, Mary Mainland, is expected to testify.
All rise for the jury. All right, we're going to go on a record. It is January 24th, 2023. We're on the case of State of Wisconsin versus Mark D. Jensen, 2002 CF 314. So have the appearances, please.
Good morning, Your Honor. The State of Wisconsin appears by Special Prosecutor Robert Jamboys, Deputy District Attorney Carly McNeil, and Public Service Special Prosecutor Beverly Jamboys.
Attorneys Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen, who appears in person. Good morning, Judge.
Good morning. The jury's back in the courtroom. Thank you for coming on time, folks. We're still in the state's case in chief with that. Who's your next witness, Mr. Jamboys?
Dr. Mary Mainland.
All right, let's have her come up.
Judge, before Dr. Mainland starts testifying, I just, and I mentioned this at the end of yesterday, I do want to, I've marked exhibits 80 and 81. They're the transcripts that correspond to the telephone calls that were played for defense exhibit 72, and I'd like to admit those into evidence, offer those into evidence.
Any objection?
No objection.
All right, 80 and 81 are received. Doctor, raise your right hand. I'll swear you in. You solemnly swear the testimony is meant to be the truth, whole truth, nothing but the truth, help you God.
I do.
Thank you. Get as close as you can to the microphone. And if you could spell your first and last name for the reporter.
First name Mary, Mary. Last name Mainland, Mainland.
Thank you. Go ahead, Mr. Jamboys.
Thank you, Your Honor. Good morning, Dr. Mainland. Could you please tell the jury how you're presently employed?
I'm retired.
When did you get retired?
November of 2020.
When you retired, what were you doing?
I was, well, I still am, but I was serving as a medical examiner for Hillsborough County in Tampa, Florida. So by profession, I'm a forensic pathologist.
Exhibit S82. I'm going to ask you some questions about that.
Yes, sir.
What is Exhibit S82?
This is a copy of my curriculum vitae, also known as a resume.
And how current is this curriculum vitae?
I think I updated it in October of last year.
So any changes since October of last year?
No.
So can you first of all tell the jury about your education?
Sure. Starting with college, I received my bachelor's degree from the University of Wisconsin, Milwaukee. I went to medical school in Milwaukee at the Medical College of Wisconsin, received my MD degree there in 1995. After that, I did a 5-year residency in anatomic and clinical pathology, also in Milwaukee. Following that, I did a 1-year fellowship, which is specialized training in forensic pathology in Richmond, Virginia.
So you have a doctor of medicine?
Yes, sir.
And are you board certified in any specialties?
Yes, I'm board certified in anatomic, clinical, and forensic pathology.
Now, can you tell the jury what the difference is between an anatomic pathologist and a forensic pathologist?
Sure. When you think of a pathologist, you're probably most likely thinking of an anatomic pathologist. Those are the doctors who work in a hospital or for a hospital. Say you have something, you go have a biopsy of something. The pathologist is a person who actually looks at the tissue, reads it, and determines if there's disease there, and if so, what type of disease. So, you know, if you have a breast lump or a colon cancer or whatever, that's what a pathologist deals with. Forensic pathology is a little bit, it's very specialized. It goes into kind of where medicine meets the law. There are certain types of deaths in the entire United States that are specified by law that need to be investigated. When you are born, you get a birth certificate. When you die, you get a death certificate. And these certain types of deaths can only be signed. Certain death certificates can only be signed by somebody who is legally allowed to. So this would be a forensic pathologist, a coroner. You might have heard the term a medical examiner, somebody who has that special training and permission by law. So practically speaking, a forensic pathologist does a lot of autopsies and determines cause and manner of death.
So when you're looking at, can you tell the jury what the difference is between a cause of death and a manner of death?
Sure. The cause of death is pretty simple. The cause of death is either a disease or an injury. It's what killed the person, you know, so gunshot wound to the head, breast cancer, stomach ulcer, whatever. The manner of death is more like the how. There are 5 different manners. There's natural, which is the most common. Most people die a natural death. Then there's suicide, homicide, accident, and finally undetermined. And, I'm sorry.
No, so then I'm going to ask you some more questions then about your employment history. So after you served your fellowship, or in which office was that you served your fellowship?
Richmond, Virginia.
Okay, and how long was that fellowship?
A year.
And when did you complete your fellowship in Richmond, Virginia?
In 2000.
And so what did you do after completing your fellowship in Richmond, Virginia in 2000?
I returned to Milwaukee, to the Milwaukee area, and my first job was at the Milwaukee County Medical Examiner's Office, and I was employed as an assistant medical examiner.
And what did you do as an assistant medical examiner at the Milwaukee Medical Examiner's Office?
Mostly, as I was describing to you, autopsies in order to determine the cause and manner of death.
Now, when you're looking at the manner of death, determining whether it's a homicide, a suicide, accidental, natural causes, or undetermined, what are the factors that you look at outside the autopsy?
Well, there are so many. It's just like when you go to a doctor, the doctor doesn't jump in and start listening to your heart and lungs right away. The doctor will ask you, hey, what's going on? Is there a problem? What's the problem? How are you feeling? What is there pain? What's the pain like? Does it get better? Does it get worse? So that's called taking a history. The doctor takes an extensive history, usually. And so for a forensic pathologist, we obviously can't take any kind of history from the body. So we rely on reports from friends, neighbors, family, witnesses, police records, medical records, etc. So we'll use all of that stuff in some cases in order to help figure out how did this person come to be found dead, and ultimately what killed this person and how.
Now, which comes first, the autopsy or that other analysis of the evidence that was accumulated during law enforcement's investigation?
Well, ideally, it would be all the evidence first and then the autopsy, but it doesn't always work out that way. Sometimes it takes a while to get information.
So how long did you work at the Milwaukee County Medical Examiner's Office?
3.5 years.
Do you have any idea how many autopsies you did in that 3.5 years?
About 250 a year.
250 a year.
250 to 300.
And how many did you do when you were serving your fellowship in Virginia?
241. I'll never forget.
So 241 in that first year, and then 250 to 300 a year thereafter in the Milwaukee Medical Examiner's Office?
Yes.
And you worked there 3.5 years?
Yes.
And then when you left the Milwaukee Medical Examiner's Office, where did you go?
I went to Kenosha, Wisconsin.
Oh, right where we're at today.
Been in this courthouse.
And when you came to Kenosha, how were you employed?
I was the medical examiner for Kenosha County.
When did you start here?
In February of 2005.
And how long did you stay here?
3.5 years.
So when did you leave?
When did I leave?
Yeah, when did you leave?
I think it was like in about the summertime of 2008.
And that's when, and then where did you go after that?
I went to Tampa, Florida.
And you've been working in Florida until your retirement?
Yes.
So when you were working for the Kenosha County Medical Examiner's Office as the Kenosha County Medical Examiner, how many autopsies did you perform each year in that capacity?
It's hard to remember. I've broken it down, but probably under 200 a year at that time.
And when you were working as the Kenosha County Medical Examiner, did you also take cases for other counties at that time?
Yes,
So when you were doing about 200 a year, they were some were for Kenosha County and some were for other counties.
correct.
And when you left the Kenosha County Medical Examiner's office, when you went to Tampa, what was your job title at when you arrived in Tampa?
I started out there as an associate medical examiner.
And how long were you employed as an associate medical examiner?
About 3 years.
And in that first 3 years that you were working in Tampa as an associate medical examiner, about how many autopsies a year would you perform?
A good 200.
200 a year?
Probably more than that, probably about 250.
And then after you'd been the associate medical examiner for 3 years, what was your next job title?
Deputy chief medical examiner.
And how long did you serve as deputy chief medical examiner?
A little over a year.
And then what was your next job title?
Chief medical examiner.
So chief medical examiner for Tampa, Florida.
Yes.
How big a city is Tampa, Florida?
Well, it's about the size of Milwaukee. The county is Hillsborough County. So the Tampa office is responsible for the surrounding county, Hillsborough County. And I would say Tampa and Hillsborough County are pretty comparable to Milwaukee and Milwaukee County. Maybe a little bit bigger, probably somewhat bigger by now.
So, and how long do you serve as chief medical examiner for Hillsborough County?
6 years.
And what was your next job title after serving as chief medical examiner?
I stepped down to become a deputy chief medical examiner.
And why did you do that?
I could see my retirement coming up, and I knew I had like a couple of years to go, and I wanted the next person in line to be prepared, for the chief job. I also wanted to go back to what I really liked doing, which was doing autopsies. And as chief, you don't get as much of an opportunity.
So when you were chief medical examiner for 6 years, how many autopsies did you do then?
Probably less than 100 a year. Well, no, less than 150 a year.
But you also reviewed the work of other other associate medical examiners?
Yes.
And how many medical examiners altogether worked in that office?
At that time, there were 5. There are 6 now.
So you did your own autopsies and you reviewed the work of the autopsies of other forensic pathologists that were working for you.
That's correct.
And as deputy, when you went back to being deputy medical examiner again, how many autopsies were you doing in a year?
About 200.
And you said you served as deputy medical examiner for about 2 years?
Yes.
And then what did you do?
Then I retired.
And since you retired, you haven't done any autopsies?
No, I haven't.
But you reviewed cases for other parties?
Yes.
Altogether, do you have an estimate of how many autopsies you did in the course of your career?
Just a little bit shy of 4,000.
Now, you did not perform the autopsy on Julie Jensen, did you?
No.
You started in February of 2005?
Correct.
And you knew that Mark Jensen had been charged with murder of Julie Jensen since March of 2002.
Correct. I learned that. Mm-hmm.
So when you came on board as the medical examiner for Kenosha County, were you asked to review the case and the circumstances pertaining to Julie Jensen's death?
Yes.
Were you given any directions or were you just simply asked to review it?
I was asked to review it and give an opinion as to the cause and manner of death.
So tell the jury what you did when you were reviewing. What did you look at when you were evaluating, trying to determine the cause and manner of Julie Jensen's death?
Well, I looked at everything I could, everything that was provided to me, including medical records, scene investigation, police reports, various interviews of witnesses, et cetera, et cetera. I, of course, reviewed the autopsy findings and the toxicology findings. There's probably more. that I'm not remembering at the moment.
I'm going to show a document that was previously submitted as a part of Exhibit S10, and this is the autopsy report for Julie Jensen. Now, as indicated, that had been previously admitted into evidence. Looking at this report, do you recall reviewing this report?
Yes,
And this is one of the documents that you examined during the course of your evaluation of this case?
yes,
And you said you also looked at other records that were maintained in the medical examiner's office?
yes,
Did that include autopsy photos?
yes,
And you said you also examined police reports?
yes,
Did that include crime scene photos?
yes,
Now, you've testified twice before about the death of Julie Jensen. Is that true?
yes,
The first time was at a hearing in August of 2007,
correct.
and then the second time was at a hearing sometime in January or February of 2008.
At the trial, yes.
And now, at the time that you testified at the first hearing, you're looking at one body of information, but by the time you testified at the second hearing, you'd come across or you'd been made aware of an additional body of evidence. Is that true?
Yes.
So let's talk about the body of information that you were looking at before you testified at the forfeiture hearing, at the first hearing. So at the first hearing, tell the jury the things that you remember looking at before testifying.
Pretty much everything I've listed, witness statements to exclude the new witnesses who came forward after the hearing, witness statements, toxicology findings, autopsy report, police report, interviews, I believe some phone conversations between the defendant and others. And again, I'm probably leaving something out.
Well, if so, we'll go through it. So
Right.
you looked at lab reports, correct?
Yes.
And do you remember, as you're sitting here today, what you gleaned from the laboratory reports?
There were a number of substances in Julie Jensen's system. The most important being ethylene glycol, which is the ingredient in antifreeze.
Without looking at the, you remember which lab had produced reports concerning ethylene glycol?
There were several. May I refer to my notes?
If necessary, if that'll assist you.
Thanks. Two laboratories that determined that there was ethylene glycol in Julie Jensen's system. The first one was the St. Louis University Toxicology Laboratory. And after that, other laboratories became involved, including the Wisconsin State Lab of Hygiene, National Medical Services, University of Kentucky, and even a couple more.
Okay, just, Your Honor, may counsel approach for just a moment? Sure.
Morning break, folks.
Yeah.
Please don't talk about the case. Right, the jury's outside the courtroom. The issue that I see, and the attorneys can correct me, she's reviewing documents that she brought with her.
That's not the issue, Your Honor.
That's a separate issue, but
You don't have a problem with that?
I do, unless there's an indication that she needs that to refresh her memory.
Well, she just indicated that would be helpful for her to be able to do that. Let's take up this issue first that Mr. Perry brought to my attention, and that's the reason I'd asked for the sidebar,
Right.
and then we'll take up that second issue.
Okay.
Okay. The first issue is that as I was doing my direct examination of Dr. Mainland, Mr. Perry came over and he said that he would prefer that I not refer to the first hearing as the forfeiture hearing, and I not refer to the second hearing as the trial. I understand his concerns about the second part. I mean, referring to it as a trial, but I didn't do that. The witness did. I guess I didn't tell her not to, but I could tell her maybe should refer to it as a second hearing. I don't see a problem with referring to the first hearing as the forfeiture hearing. So I didn't.
You think the jury knows what a forfeiture hearing is?
I don't know, but I think it's also very easy, since it has a title in it, to refer to it as the 2007 hearing or the first hearing at which she testified. I think it doesn't have to have this label on it because it does. I don't know what everyone's understanding of it, but forfeiture, I mean, people do understand that word. I don't know if they understand the legal.
What if we would have said preliminary hearing?
That's fine.
Well, except
all
that'd be-
preliminary hearing.
That would be incorrect because it wasn't a preliminary hearing.
Well, it's not capital.
Well, I'm just saying as an example.
Sure, I understand.
I mean, I don't think 9 out of 10 people in this courtroom know what a forfeiture hearing was. It was so unique at that time. I think it was the first one.
Well, it was the first.
It was the first one in the state of Wisconsin when it was held.
It's my request. If it's, I don't know that it's such a difficult request to avoid putting the title on what these earlier hearings were, especially considering, we're really trying to avoid discussion about first trial, prosecution, all of that stuff, and
Right.
just refer to it as earlier testimony and the
Well,
dates.
Mr. Jambos, just say first hearing, second hearing.
Your Honor, I will do that, and so will Dr. Mainland. I will say this about the forfeiture hearing. That's what I've been referring to it as for 15 years. So it's hard this is the second or third time I've referred to it as a forfeiture hearing in the course of this trial. And I have to acknowledge that Mr. Perry has asked me in each of the previous times not to refer to it as a forfeiture hearing. It's just, it's not like I'm intentionally trying to upset Mr. Perry. This is just
Maybe
the
we
way
could
I refer
ask,
to it as.
we could have Miss McNeil kick you in your shins or something. When you say that.
She'd be anxiously happy to do that, I'm sure. But I will.
It's hard to.
My wife from behind too, but I will try to refer to it as the first hearing and the second hearing, and I'd ask Dr. Mainland to do the same thing.
It's hard.
What's the second issue now?
Well, then you'd propose that, well, it's a problem with her using these documents and she had indicated that it would be helpful to her in the course of her testimony to review the documents that she brought with her. And let's remember, we had this discussion about what the proponent of an expert witness, what they can get in as far as hearsay, and which is really, we can't. I mean, when I'm as the proponent of the expert testimony of Dr. Mainland, I can't seek to admit hearsay evidence through her. The defense can on cross, but I can't on direct. And I think we all recognize that at some previous hearing in this matter. And of course, that's what the law of the land is in the state of Wisconsin. So some of these prior reports there's been testimony and it's been admitted in evidence. The reports that Joe Crafassi prepared at the St. Louis Forensic Toxicology Lab, that's been admitted into evidence. And so she could testify about that and it wouldn't be a problem. The State Lab of Hygiene test report has not been received into evidence, nor has the NMS report been received into evidence. So I'm going to ask her about those reports, but I'm not going to offer them into evidence. And though it's common for a forensic pathologist, of course, to rely upon forensic toxicology reports that from outside laboratories. It's done all the time. And in the state of Wisconsin, a forensic pathologist can testify at a trial about the cause and manner of death based upon outside forensic toxicology lab reports, because there's a Wisconsin Supreme Court decision that says so. I forgot what that is. I'm sure Ms. McNeil is probably looking it up as I'm speaking, but there is a Wisconsin Supreme Court case that expressly says that forensic pathologists can testify about lab reports, or at least base their opinions upon lab reports.
The only issue I had, and if she's looking at reports that she brought, I don't know if the defense has an opportunity to know what she's looking at.
Well, I'd be happy to have Dr. Mainland.
I'm just trying to do a record, because obviously we're on Jensen 3.
Yes.
And the lawyers understand what I'm saying.
Yes.
So if she's looking at something and then it's not part of the record.
I'd like a brief opportunity to see what she has with her.
All right.
I don't have a problem with her testifying, with the exception of course, testimonial things that we've talked about.
And that goes for your witnesses, experts too.
That's right. And our expert witnesses, I expect, are going to the same standard being applied to talk about the things that they reviewed to come to their conclusions. So that's fine, but I would ask for a short time to look at what
You want to do it right now?
Dr. Mainland has.
Right.
Yeah.
Well, and just I will say this on the record in the presence of the witness, Dr. Mainland, I don't want you to mention the letter that Julie Jensen wrote a week and a half before she died. You're not supposed to mention that. Even if it entered into your analysis of this case, I don't want you to reference it.
I'm aware of that.
And so if I ask you a question, it seems like I'm asking you about that. I'm not asking you about that. Okay.
Got it.
Thank you.
And I won't be asking you about that either.
Okay.
Also, that includes voicemails that were left for Officer Cosman. That's
okay.
part of it all.
Okay. Okay.
Okay, why don't you take a look at what she has?
I just made myself kind of.
All right, chat. Welcome, welcome, welcome. Thanks everybody for tuning in. Make sure you guys share the stream out. If you're on YouTube, hit that thumbs up. Don't forget, like the stream on Facebook. spam the chat with likes and hearts. That helps with the algorithm and pushes our stream out a lot more. We had a bunch of people in here yesterday because some streams were messing up on some other platforms, which kind of helped us a bit. But let's try to get all those people back. They were a fun little group. There is a lot of controversy surrounding all of these doctors, all the pathology reports. So because we have Mary Mainland testifying today, we'll play some of those clips. We have exhausted those clips, but we're going to play them again for the new people that are coming in and for some people that may have missed some crucial pieces to all of that. A lot of controversy surrounding everybody's findings. Multiple doctors are saying different things. Multiple doctors saying different levels of antifreeze.
Can't read to the judge, right?
So we'll see what Dr. Mary Mainland says. We didn't play her 2008 testimony because it's a lot. I didn't want to bore you guys. But we may have to play her testimony over the weekend and compare it to what we hear today.
You're on the way to the court reporter.
Already.
All rise for the jury.
All right, we're back on the record on Mark D. Jensen, 2002 CF 314. The appearances are the same. The jury's back in the courtroom. Thank you for your patience this morning. Ladies and gentlemen, Dr. Malin is still on the stand. She's still under oath, and you can continue, Mr. Jambois.
Thank you, Your Honor. And just to get us all oriented, I was asking you about the quantum and the nature of the information that you had available to you in advance of your testimony at the first hearing. So to that end, I was asking you about the toxicological results that you'd reviewed. So can you tell the jury about the toxicological reports that you reviewed in preparation for making a determination as to cause and manner of death in this case?
That before the first hearing, I saw toxicological results from the St. Louis University laboratory.
The St. Louis Forensic Toxicology Laboratory?
Yes.
And what was the blood test result that was provided with regard to ethylene glycol?
There was ethylene glycol in the blood. And do you want the quantity?
Yes.
At 50 micrograms per milliliter.
And then there's another one listing here, GCFD, 55 micrograms per milliliter. What's that about?
That was I'm sorry. See, I confused the two already. The other one came later. The GCFID was the first specimen that was analyzed, and that came back at 55 micrograms per milliliter.
And what does GCFID mean?
It has to do with the instrument and the method of analysis for these drugs. They put them through an instrument called a gas chromatograph. And what it does is it separates different drugs and different ion parts of drugs out. And then there's a thing, FID is called a flame ionization detector, and that will tell you what you have. Don't ask me any more detail, please.
But that's something that you routinely rely upon as a forensic pathologist.
Yes.
But you're not a lab rat. You don't do that kind of stuff.
No, I don't.
Okay. But then there was another test that was done later, and that refers to GCMS, and it's 50 micrograms per milliliter. Is that correct?
Yes.
And what's GCMS stand for?
Again, they use the same machine, a gas chromatograph, but the method of analysis of detection is mass spectroscopy.
Now, so that's a pretty close, though. I mean, 55 milligrams per milliliter versus 50 micrograms per milliliter, correct?
Yes.
But, you know, there'd also been a test at National Medical Services, and they indicated what? With regard to the blood.
They indicated that the blood was negative for ethylene glycol.
And they'd also tested the urine, an NMS that also tested for urine, correct?
Yes.
And they tested for ethylene glycol.
Yes.
And they came back what?
They came back negative.
Now, NMS was the first set of tests that were done at the request of the Kenosha County Medical Examiner's Office. Is that true?
As far as I understand, yes.
But then at a later time, samples were submitted to the St. Louis Forensic Toxicology Lab. Is that what you're finding? Is that what you discovered when you looked through this reports?
Correct.
And do you know why the medical examiner sent these items out to have them tested at a different laboratory?
The medical examiner found some microscopic findings, particularly in the kidney tissue, that were very worrisome for ethylene glycol poisoning. And so that's why another lab was used.
So then the reports were sent to the St. Louis Forensic Toxicology Lab. You've described the blood test results. What did the St. Louis Forensic Toxicology Lab find about the urine content?
The first test came back at 720 micrograms per milliliter. And then the second test with the GCMS came back at 549 micrograms per milliliter.
But the National Medical Services somehow come back with nothing.
Yes.
So in addition to the blood and the urine, what other substance or aspect or something recovered from Julie Jensen's body was tested for ethylene glycol?
The stomach contents.
And who tested the stomach contents?
For ethylene glycol, it was St. Louis University.
And what did the St. Louis University Forensic Toxicology Lab find with respect to the gastric contents?
The first test that they did, the flame ionization detector test, came back at 3,940 micrograms per milliliter. And the second test came back at 4,121 micrograms per milliliter in the stomach contents.
So, Doctor, we're going to get back to ethylene glycol a little bit, but now I want to talk about some of the other substances that were found to be present in the various systems of Julie Jensen. First of all, was ethylene glycol found elsewhere in Julie Jensen's system?
Yes.
Where else was it found?
In the liver and in the brain.
And which test was it that found them in the liver and the brain?
Again, it was the GCMS, GC mass spectroscopy.
So the GC, the gas chromatograph flame ionization detector did not discover the presence or reveal the presence of ethylene glycol in either the liver or the brain?
That's correct.
But then subsequently, the gas chromatograph mass spectrometer was used, and it found what?
It found in the liver 51 micrograms per gram of ethylene glycol, and in the brain 16 micrograms per gram.
Now, looking at all the toxicology screens that were done by the various laboratories, were there other substances found within the body of Julie Jensen?
Yes.
So tell me what other items were found in the body of Julie Jensen before the first hearing?
Before the first hearing, honestly, I don't recall if certain labs were before or after. If the Wisconsin State Lab of Hygiene was before the first hearing, I believe it was.
What did this Wisconsin State Lab of Hygiene find?
They found zolpidem in the blood, which is just the generic name for Ambien. They also found it in the stomach. Let's see, they found paroxetine or Paxil in the stomach. And they found, this is a long one, chlordiazepoxide, also known as Librium, in the stomach.
Now, I'm going to show you these lab reports and see if that refreshes your recollection as to whether they'd come before or after the first hearing.
'99.
April 7th of 1999.
Yes.
Yes. So long before you started with the Kenosha County Medical Examiner's Office.
Correct.
So again, the zolpidem, which is the generic name for Ambien, was how much of it was found and where was it found?
It was in the blood at 82 nanograms per milliliter. And it was in the stomach. They measured 1.5 milligrams total.
And was diphenhydramine found anywhere?
Yes.
Where was diphenhydramine found?
That's the generic name for Benadryl, and that was found, excuse me. That was found by a different lab. That was found by AIT.
And how much was found to be in the gastric content by AIT?
113 nanograms per milliliter.
And diphenhydramine was also found to be present by NMS. Is that true?
Yes, in blood.
And diphenhydramine again is the generic name for
Benadryl.
Now, was any paroxetine found anywhere within the body of Julie Jensen?
Paroxetine was found in the stomach contents and was not found in the blood.
And who found it which labs found it in the stomach contents?
The Wisconsin State Lab of Hygiene and AIT.
And you also said that chlordiazepoxide was found to be present by the Wisconsin Lab of Hygiene in her gastric contents.
Yes.
And what is chlordiazepoxide?
Librium.
Now, when you obtained this information in advance of the first hearing, had you seen any reference to Librium in any of the documents that you'd reviewed?
Yes.
You recall seeing a photograph of a Post-it note that had been found on Mark Jensen's day planner?
Yes.
And that was one of the items listed on that Post-it note. Is that true?
Yes.
I'm going to show you this document that has been marked previously as State's Exhibit 15. So, directing your attention to State's Exhibit 15, what is that?
Oh, this is a photograph of a page from Mark Jensen, state planner, with a Post-it note on it listing a number of different items.
Well, why don't you read the list to the extent that you can read it?
Okay. Own drug supply, Nicotrol, I don't know what that says, N-O, aspirin, bottle hyphen booze, razor blades, Librium hyphen shells, DeFazio, Terry with an I, patches, shells, syringe, and bag hands.
And were you made aware of who wrote that Post-it note?
Yes,
Who wrote it?
Mark Jensen.
And Julie Jensen had photographed that Post-it note, correct?
Yes,
And she provided that photo, or she provided the film to law enforcement.
yes.
Now, let's talk about ethylene glycol poisoning. In the course of your investigation into this matter, did you learn the approximate size and weight of Julie Jensen at the time of her death?
Yes,
How much did she weigh?
she was 115 pounds, I believe. This was at the doctor's office
Yes.
3 days prior to her death.
And that was her estimated weight at the time of autopsy too, wasn't it?
Yeah, I think Dr. Chambers might have said 110 pounds. That was an estimate.
So she weighed between 110 and 115 pounds at the time of her death.
Yes,
Now, doctor, are you familiar with the toxic effects of ethylene glycol on the human body?
yes,
Are you familiar with the manner in which ethylene glycol is metabolized by the human body?
yes.
What I'd like you to do is describe to the jury what ethylene glycol does to the human body as it is ingested and then absorbed. I'd like you to describe what it does to the body and also what symptoms a person who's ingested ethylene glycol is likely to manifest at various stages.
Okay, this will take a little while. Ethylene glycol is an alcohol. Its structure is very similar to ethanol or beverage alcohol that many of us enjoy. When ethylene glycol is first ingested, it has the same effect as beverage alcohol does. A person will act drunk or loopy, or they could have trouble walking, they could stumble around. Depending on how much a person takes, they could have seizures, they could even enter into a coma. And all of this can happen, from about 30 minutes after exposure to about 12 hours after exposure. So that's the first phase. That's what they call the first phase of ethylene glycol poisoning. Following that, the amount of ethylene glycol in the body decreases because it's being processed by the liver. So as it's processed by the liver, it's processed into a number of other compounds, all of which are acids. The most important one for the next phase, phase 2 of ethylene glycol poisoning, is called glycolic acid, Glycolic. And that causes the body to do whatever it can to try and get rid of the excess acid in the blood. So the person will start to hyperventilate, You can get rid of acid by breathing fast, by getting rid of carbon dioxide. The person will hyperventilate, and then they'll have really deep and abnormal breathing. They also can have heart symptoms. The heart can pound. It can, it can beat fast. It could even fail. That's the second stage of poisoning, and that starts anywhere from 12 to 24 hours after the ethylene glycol is ingested. As the ethylene glycol is processed into glycolic acid and then into other acids, one of which is oxalic acid, it combines, the oxalic acid combines with calcium in the blood. Calcium's always floating around in the blood, and makes crystals. Crystals, just oxalate crystals. And these crystals tend to lodge in the kidney, and they cause kidney damage. The acids themselves also cause kidney damage. So the third stage, starting about maybe 24 to 72 hours after taking ethylene glycol, is called the renal or kidney phase. And that's where you can see the kidneys fail. And you can see death in any one of the three phases. It all depends on the dose and what kind of, if the person got any kind of therapy, etc.
Now, during the course of your examination of this case, did you undertake to prepare your own slides of the tissue samples of Julie Jensen?
Yes.
Did you examine, for example, did you produce slides of the kidney sample from Julie Jensen?
Yes.
What you do to produce a slide. What is it that you do to produce a tissue of slides?
Okay.
A slide of tissue sample.
Right. At autopsy or even in the laboratory, as far as that goes in the hospital, the pathologist will receive a literal piece of tissue, and what's done is that it gets fixed in formalin, so it's a preservative. It gets fixed in a preservative, then it gets processed. The water's removed from it, and it's ultimately embedded in paraffin wax, and it's like into a little block about the size, a little bigger than a postage stamp. That block of wax with tissue embedded is cut very thin, very, very thin, on an instrument called a microtome. And like we're talking 5 micrometers maybe. And anyway, that tissue is ultimately placed onto a glass slide and stained so that, the structures become visible. And that's what the pathologist looks at under the microscope.
So you cut some slide tissue samples and you examined them?
Yes.
And I'm going to show you a series of photographs been marked S83 through S88. We'll go through them one at a time. So let's start with S83. And Madam Clerk, could you make sure that the television screen is on? It's on. So can you tell us what S83 is?
Yes, this is a close-up picture of a kidney. of Julie Jensen's kidney tissue, showing structures called tubules. And within those tubules, you can see one foreign body, which is a glycolic acid crystal.
So now look at the screen, if you will, up there. Can you see my cursor moving around there?
Oh boy, I can't see it.
Can you see it? No, look at the screen up there, doctor. Look at the one
Oh,
over there. You might be able to
that's
see a lot
better.
better. Can you see it now? And
Yes.
can you see my cursor moving around?
Yes.
So is this a tubule right here?
Yes.
And also right here?
Yes.
And then another one right over here?
Yes.
And then there's one right here. And
Yes.
what is this substance inside that kidney tubule?
That's a crystal, a glycolic or an oxalic acid crystal.
Now, and that's kind of a characteristic form there. That, you know, I didn't know what sheaves of wheat look like, even though I grew up in Wisconsin. But is that oxalic acid crystals? They say resemble sheaves of wheat. Is that the description that they provide?
Yes.
So that's supposed to be what sheaves of wheat look like.
Yes.
Right there. Okay. So, and then I'm going to proceed to the next slide. And directing your attention to this slide, can you tell the jury what that is?
This is another close-up picture of kidney tubules. Okay, so and then you see kind of going diagonally across the screen in the middle, there's a tubule cut the long way. Think of the tubules as like pieces of spaghetti. So if you cut it cross section, you'll see a round structure on the side. If you cut it the long way, you'll see like a long tubular structure.
And that's what you're seeing here, this long tubular structure here?
Yes.
And what are these white items here?
That's oxalic acid crystals.
And what is this item? What is this is exhibit S, this is S80. You've got them up there. Which exhibit is this?
This looks like 87.
So exhibit S87. And can you tell the jury what this slide portrays?
Yeah, that shows the kidney from a little bit farther away, so you can see more of the tubules, and you see that a number of them have crystals within them.
So what do these crystals do to the kidneys?
Well, they clog up the tubules. You know, the tubules are what the kidney filters blood into urine, makes blood into urine, filters the blood, removes poisons, et cetera, et cetera. And so the crystals will actually clog up the tubules and interfere with processing.
Now, are oxalic acid crystals in the kidneys, are they diagnostic for any particular type of a condition?
They're very characteristic of ethylene glycol poisoning.
Can you think of anything else that causes oxalic acid crystals in the kidneys?
There's a certain disease, a certain hereditary disease that can cause that. Very, very unusual. It's called primary oxaluria.
But in this instance, there was evidence that Julie Jensen had ingested ethylene glycol.
That's correct.
So let's talk about the amount of ethylene glycol in Julie Jensen's system at the time of her death. And then let's talk about what constitutes a lethal dose of ethylene glycol. So she had a very small amount in her blood, correct? I mean, 50 to 55 micrograms per milliliter.
Yes,
And she had a larger concentration in her stomach of what, 3,900 or 4,100 micrograms per milliliter.
correct.
And that amount in the stomach contents amounts to about, a teaspoon or a teaspoon and a half of ethylene glycol in her stomach?
Yeah, half a teaspoon to a teaspoon, something like that.
So it's a relatively small amount in her stomach,
Yes,
even though it seems like a larger concentration. It's concentration against gastric contents as opposed to a concentration against the blood,
correct.
the urine. But there was a relatively small amount in her blood. Correct?
Yes.
Now, does that give you any information or does it allow you to draw any inferences about the manner in which this ethylene glycol was ingested or the quantity in which it was ingested?
It is consistent with ingesting more than one dose.
So tell me what it is about this presentation that, aside from what any witness statements are, what about this particular presentation would cause you to infer that there was possibly more than one dose?
Well, you're finding, first of all, we know that Julie Jensen was alive and experiencing symptoms for about 2 days. And so we know she had ethylene glycol sometime earlier on. She felt the effects of it, ongoing effects of it. She was processing it. She was to the point where crystals were forming in her kidneys, but yet she had unabsorbed ethylene glycol in her stomach, which would seem to indicate to me that that was a second dose. She was already feeling the effects and showing the effects of an earlier dose.
So how much ethylene glycol would a person the size of Julie Jensen need to ingest in order for it to be ultimately fatal without any medical intervention?
There are a number of different calculations out there that you can use. One of the calculations that I looked at said about 50 milliliters, but it's true that as little as 30 milliliters can be fatal.
Well, and the effect that it has on the body, I mean, the effect that, say, 30 or 40 or 50 milligrams or milliliters would have on a body is dependent to some extent upon the size of the body, correct?
Yes.
So as adults go, Julie Jensen weighed between 110 and 115 pounds. That's relatively on the small side for an adult.
Yes.
I mean, I weigh 200 pounds and maybe a little more, but we'll say 200 for the record. A person that weighs 200 pounds would probably be able to withstand a dose of ethylene glycol, say a 30 milliliter dose of ethylene glycol, better than a 110, 115 pound person.
Generally speaking, probably.
But a person that is Julie Jensen's size of 110 to 115 pounds, what would be the minimal amount of ethylene glycol that would need to be ingested in order to produce this kind of result where she had ethylene glycol in her stomach, in her kidneys, these ethylene glycol or these oxalate acid crystals in her kidneys, and then 50 to 55 micrograms per milliliter in her blood? How much ethylene glycol would she need to ingest in order to produce that?
In order to produce that, as little as 10 milliliters. After taking as little as 10 milliliters, you can see crystals forming in the kidneys.
But now there's, before the first hearing, you had heard evidence that Julie was manifesting symptoms in the early morning hours of December 2nd, correct? In late
Yes.
evening hours of December 1st and the early morning hours of December 2nd.
Yes.
And what symptoms was she manifesting according to the reports that you reviewed?
She was in the early or the first stage of ethylene glycol poisoning, the intoxication stage, where she's showing the effect of the unprocessed alcohol itself of ethylene glycol. So she was acting drunk.
And that was that was on the evening of the 1st and the early morning hours of the 2nd, correct?
Yes.
And then did you hear about a phone call that Julie made to her friend and neighbor, Margaret Voigt?
Yes.
And that occurred at about 10 a.m. on December 2nd?
Yes.
And at that time, was there anything about what you'd heard about that phone conversation that would cause you to draw any inferences about whether or not Julie Jensen was still experiencing or still under the influence of ethylene glycol?
Margaret Voigt described Julie Jensen's voice as being like somebody who was drunk.
And that's a sign of ethylene glycol intoxication?
Yes.
The first stage of ethylene glycol poisoning?
Yes.
And at that point, Julie had said to her friend and neighbor, "Oof, I can't believe the effect this medication is having on me." Something to that effect, correct?
Yes.
Now, then there was information about Julie Jensen's presentation on the morning of December 3rd. Do you remember what you heard about the presentation of Julie Jensen on the morning of December 3rd?
Yes.
So tell the jury what you can remember about the presentation of Julie Jensen on the morning of December 3rd.
She was very lethargic, very weak, and she was breathing quite heavily.
And Mark Jensen had repeatedly indicated that she was unable to get out of bed.
Yes.
Is that true?
Yes.
And that's consistent with what stage of ethylene glycol poisoning?
The second.
Now, and how is that consistent with more than one dose of ethylene glycol poisoning?
The half-life, or for the amount of time ethylene glycol remains in the body is really pretty short. If you take a single dose of it, you'll absorb it probably within a half hour or so. You'll have a peak amount in the bloodstream in about an hour, and then it gradually disappears. So a half-life means that half of the dose has already been processed or metabolized, has gone through the body. So it normally takes, after like 5 half-lives, you shouldn't really see any of the parent compound anymore.
Where? You wouldn't see any more of the compound where after 5 half-lives?
In the blood.
And yet she had 55 micrograms to 50 micrograms per milliliter in the blood.
Yes.
At the time of her death.
Yes.
And if she'd only had one ingestion on the evening of December 1st, you wouldn't expect to see anything in her blood.
That's correct.
Is that what caused you to draw the inference that she was likely to have had 2 doses of ethylene glycol?
Yes.
Before the first hearing?
Yes.
After the first hearing and before the second hearing, you'd received additional information, correct?
Yes.
So let's talk about your diagnosis, your conclusions before the first hearing. Did you render an opinion to a reasonable degree of medical certainty as to the cause and manner of death at the first hearing?
Yes.
And can you tell us, after examining all of this evidence and these slides and everything, and the police reports and the crime scene photographs and the autopsy photographs, did you come to an opinion to a reasonable degree of medical certainty as to the cause of Julie Jensen's death?
Yes.
What was your opinion to a reasonable degree of medical certainty as to the cause of Julie's death at the first hearing?
Ethylene glycol poisoning.
Did you make any reference to the possibility of asphyxia?
At the first hearing, I don't recall.
Do you recall saying that you couldn't rule out asphyxia?
I do recall that.
So your first opinion was that it was ethylene glycol poisoning, but you couldn't rule out asphyxia as a contributing factor.
That's correct.
And did you have an opinion to a reasonable degree of medical certainty at the first hearing as to the manner of death?
Yes.
And what was your opinion to a reasonable degree of medical certainty as to the manner of death?
Homicide.
Now, what was it that caused you to believe that this was a homicide as opposed to some other types, for example, a suicide?
The picture did not fit that of a suicide. The history, the circumstances, as I was explaining earlier, the circumstances surrounding the death, all these things that we take into account did not fit the pattern of suicide at all.
So let's talk about the circumstances that you were aware of before the first hearing that caused you to believe that the circumstances did not fit the diagnosis of suicide. What were those factors that you can, if you can remember some of them?
Well, first of all, someone commits suicide with ethylene glycol with antifreeze. They're typically going to take one dose, and they'll take a large enough dose, to kill themselves. That's their intent, to kill themselves. So what typically happens is they're either found dead, or they're found in really bad shape. Somebody takes them to the hospital, and oftentimes they die later despite, getting medical attention. So that's typical for a suicide. The amount of ethylene glycol in the blood is typically higher in a suicide case than it is in a homicide case.
How much higher?
To the order of 10 to 100, 10 tens or hundreds more.
So 10 times more to 200 times more.
Yes, even higher.
What else about the circumstances leading up to Julie's death were inconsistent with a suicide or more consistent with a homicide?
She denied being suicidal to her doctor. She went to the doctor on December 1st, and he specifically asked her about suicide, and she said, "No, I'm not suicidal."
Now, you also, when you're looking at potential causes or manners of death, you're also looking at homicide, correct?
Yes.
And were there factors that you looked at in this case that caused you to think that this is more consistent with a homicide than a suicide?
Yes.
So what are the factors that you looked at that caused you to conclude that this was a homicide?
There were indications that Julie Jensen was very fearful for her life prior to her death, in the few weeks leading up to her death.
She'd spoken to Therese DeFazio.
Yes.
And she'd spoken to her sister-in-law, Laura Koster, who's also the defendant's sister.
Yes.
And she'd expressed concerns about possibly Mark was trying to harm her or kill her or poison her.
Yes.
Now, you'd also learned of searches on the internet for ethylene glycol poisoning and for other types of poisoning.
Yes.
And those were on the Jensen home computer.
Yes.
Judge, I do object to the leading. I think you should ask the things she has considered without feeding it to her.
Well, Your Honor, if you remember,
Just rephrase it and we'll keep going, okay?
okay. So what are some of the other factors that you considered? Did you consider the computer evidence?
Yes, I did.
And what was it about the computer evidence that caused you to lean toward homicide rather than suicide?
There were numerous searches for different kinds of poisonings, undetected poison, a whole lot of different categories. There were probably over a dozen different subjects relating to poisoning or death.
Now, had you also heard about any motive for the defendant, Mark Jensen, to want to murder his wife?
I was aware that Mark Jensen was involved with another woman.
He was having an affair.
Yes.
Now, had you also heard about a pattern of abuse and humiliation and gaslighting that had taken place over the preceding 7 or 8 years?
Yes.
Same objection as before, Your Honor.
Rephrase the question, Mr. Chambers.
Were you aware of any efforts on the part of the defendant to shame, humiliate, emotionally torture, or gaslight Julie Jensen in the years preceding her death?
I maintain that objection.
She can answer the question. Go ahead.
Yes.
So what were you aware of? What had you become aware of?
Julie Jensen was known to have had an affair in the early 1990s. Following this affair, pornographic pictures started to turn up at the Jensen home, at Mark Jensen's place of employment, on, I believe, on the family car, et cetera, et cetera. And there were suspicious phone calls. And it was ultimately determined that Mark Jensen was the source of these pictures and these phone calls.
So this is the factual background that you had at your disposal in advance of the first hearing when you rendered your opinions to a reasonable degree of medical certainty as to the cause and manner of death in Julie Jensen.
Yes.
And then there was a second hearing. Do you remember that?
Yes.
Now, can you tell the jury what happened between the first hearing and the second hearing that, well, I'll rephrase it. Do you recall whether there was anything that happened or anything that was brought to your attention between the first and the second hearing that altered your perception of what had occurred in this case?
Yes.
What had happened that caused you to alter your perception of what had occurred in this case?
Witnesses came forward, additional witnesses.
So what was the name of the witness that you can, one of the witnesses that you can recall?
Aaron Dillard.
And did you review Aaron Dillard's statement?
Yes.
Did you review the letter that he wrote to his attorney?
Yes.
And did you compare the content of that letter that Mark Jensen had, that Aaron Dillard had written to his attorney to the facts in this case?
Yes.
Did you find that there was anything about the facts in this case that correlated to or were supported by the content of that letter?
Yes.
So bear with me while I pull up another slide panel here. Now, in advance of the first hearing, you had gone through all the crime scene photos, correct?
Yes.
And you'd gone through the autopsy photos, correct?
Yes.
So directing your attention to the screen, this is part of Exhibit S10. In advance of the first hearing, you'd seen this crime scene photo, Exhibit S10.
Yes.
And you noticed a couple of things about the body. For example, you noticed the way the hand, the left arm was underneath the body.
Yes.
And did it appear to you that that was a normal position for a person to roll into on their own?
I thought that was an unnatural position.
And you did learn that Mark Jensen had indicated to Detective Ratsberg that he had rolled Julie into that position.
Yes.
And actually that position is consistent with her being rolled into that position.
Yes.
Now, you'd also seen the autopsy photos, correct?
Yes.
And you'd seen the autopsy photos of the rib, of the subcutaneous bruising along the rib cage.
Yes.
But had you ever lined up the subcutaneous bruising photograph to the crime scene photograph that I just displayed to you?
Not prior to the first hearing.
But you did so after the first hearing.
Yes.
And you did that because of the testimony of, or because of the statement of Aaron Dillard?
Yes.
And directing your attention to the screen. Oh, no, I had to push it all the way. So now directing your attention to the screen. Is that the side-by-side display of these two photographs?
Yes.
And you see here the way the arm of Julie Jensen is laid out beneath her as though when she was rolled into that position?
Yes.
And then directing your attention here, you see subcutaneous, you see these marks here. This is rib 2, correct?
Yes.
And this is rib 3 here.
Yes.
And this is rib 4 there.
Yes.
And what you notice about rib 2 here, what can you tell the jury about this mark right here?
Well, there's some hemorrhage or bruising.
And that was not visible on the outside of Julie. It is only visible after her skin had been reflected after the classic Y incision at autopsy.
Yes.
And then there's another bruise mark here. Is that correct?
Yes.
That's on the 3rd rib.
Yes.
And then there's another one here on the 4th rib.
Yes.
And here Julie's laid on her back at the autopsy. But when you line Julie up, you line those injuries up, putting the arm underneath her, pretty closely lines up with those subcutaneous injuries to her rib cage. Is that true?
Yes.
And you had noticed that before you read Aaron Dillard's statement.
I'm sorry, repeat
You had
that?
not noticed the way this lined up like this until after you'd read Aaron Dillard's statement.
That's correct.
You read Aaron Dillard's statement and you put these photos side by side.
Yes.
I'm going to direct your attention to the, I'm going to first of all ask you to look at this document that's been marked as S69.
Do we still need the photo?
No, we do not. I'm going to take that down. And Your Honor, my wife was telling me the same thing as you were saying. So. That's been marked as S69. that document?
Yes, this is a letter written by Aaron Dillard to a Gretchen Rosenke.
And did you compare the content of this letter to the police investigation that had taken place up to this point?
Yes,
And did you compare it to the crime scene photos and the autopsy photos?
yes.
Now, directing your attention to page 3. In page 3, Mr. Dillard's making reference to a prior attempt of the defendant, that the defendant indicated that he'd previously attempted to kill Julie when he was at some conference in St. Louis. Did you see that?
Yes,
And did you compare that to the evidence that you knew about in this case?
yes,
And you were aware that there was evidence that Julie had become very sick while Mark Jensen was at the St. Louis Forensic Toxicology, or I'm sorry, not St. Louis Forensic, at the St. Louis Blueprint meeting, correct?
correct.
What was the evidence that you were aware of that she'd become sick while he was gone?
She had become ill. She had vomited from the bathroom or the bedroom to the bathroom, and
It was all over the carpet,
yes,
and there was a cleaning bill for the carpet, correct?
correct.
And you were aware of that at the time that you first read this.
Yes,
But at the time that you first heard about this vomiting incident, you'd not heard about Mark Jensen poisoning her before he left.
no,
But this statement is corroborated by that piece of evidence that you knew about concerning this prior carpet cleaning bill.
Object to this leading.
Just rephrase it, Mr. Chairman.
So could you state whether or not it appeared to you that that Aaron Dillard's statement as to what Mark Jensen told him about trying to kill Julie while he was at some conference, was that consistent or was that inconsistent with the evidence that you'd already heard about her being sick while he was at a conference?
consistent.
Now, in this, and directing your attention to page 4, Aaron Dillard wrote in his letter to his attorney, on a Tuesday, he took her to a doctor, and that doctor gave her a prescription for Paxil. Later that day, he gave her the Paxil as well as Benadryl, St. John's wort, Literol, and other drugs to make her woozy. Have you ever heard of a drug called Literol?
No,
But you've heard of a drug called Librium.
yes,
And he indicated then he gave her a few glasses of juice with antifreeze in it, to make her feel better. And now you had not heard that Julie Jensen had been administered a few glasses of juice with antifreeze in it before reading this letter, had you?
no,
But that's consistent with the information that you had in this case, that she was manifesting signs of intoxication in the early morning hours of December 2nd.
that's correct.
And then he wrote, she was up jumping around in the bed and saying she was drunk. He said he took her to the computer to comfort her and show her it was a side effect of Paxil. Correct? That's in this statement?
Yes,
And were you aware if there was any evidence that would support that proposition?
if that's a side effect of Paxil, it's got to be extremely rare. I have never even heard of that.
But were you aware that, in fact, Mark Jensen had printed out information about paroxetine?
Yes,
And paroxetine is the generic name for Paxil?
yes,
And he writes in here, the next day he went to the doctor to talk to him about her, and that doctor gave him the medicine Ambien. And now, is that consistent or inconsistent with the information that you'd already received concerning this case?
Consistent.
And he indicated, he said that way she would sleep through all the effects of the antifreeze. And now, can you tell us what effect taking Ambien has on the normal person?
Ambien is a drug that helps a person fall asleep.
It's a powerful enough drug that it requires a prescription to get it, right?
Yes.
I mean, I can't walk down to Walgreens and just buy a bottle of Ambien.
No.
I need a doctor's prescription.
Yes.
Now, you'd gone through Dr. Borman's notes. Did he indicate anything at all about Julie having difficulty sleeping?
He said that Mark Jensen told him that she was having trouble sleeping and that if she could get something to help her sleep, that might help her feel better.
So the only part of Dr. Borman's notes about Julie having difficulty sleeping was the information provided to Dr. Borman by Mark Jensen.
That's correct.
And then again on page 5, he said that he gave her some more juice, quote juice, with antifreeze, and he intoned juice when he said juice, and she was throwing it up a little. Now, before reading this, you hadn't actually heard any indication that Mark Jensen had actually given her a second dose of antifreeze. Is that true?
Yes.
But the evidence in this case is consistent with her taking more than one dose of antifreeze.
Yes.
And then he writes, Aaron Dilber writes to his attorney, he said she was really sick in the morning and the kids wanted to call the ambulance and he calmed them down. He said he gave her another sleeping pill so that she would just sleep. Now,
Yes.
at the time of her death, Ambien or Zolpidem was found in Julie's body. Is that true?
Yes.
Was it found in her blood or was it found in her gastric content?
Both.
So that's consistent with the information that Aaron Dillard was providing in this letter.
Yes.
So he said he would then gave her another sleeping pill so she would sleep, and said to me he thought she would be dead by the time he got home from running around. He said he went out, kids to school, some check thing, and came home. He said she was breathing better, and he was scared she was not going to die before the kids got home, and they would force him to call an ambulance. He said she was sound asleep and very non-responsive. Is that consistent with the third stage of ethylene glycol poisoning?
Yes.
Particularly if somebody's also been administered Ambien?
Yes.
He writes here, said she was sleeping on her back and he rolled her over a bit and she did not wake up. So he rolled her over on her face with her face in the pillow. He thought that would make it hard for her to breathe, and he left her for a bit and came back and she was still alive. Now, the condition of Julie's body, the position of Julie's body at the crime scene was consistent with this description, was it not?
Yes.
And Mr. Dillard then wrote, then he got on top of her and pushed her head into the pillow and sat on her back so she could not breathe. And she died, and he went to work. Now, that last part is something that you'd not heard before. Is that true?
That's correct.
But is that consistent or inconsistent with the photo that I just showed to you and to the jury?
It's consistent.
Now, is there any way that Aaron Dillard could have obtained this information unless the person who murdered Julie Jensen gave it to him?
Argumentative.
I'll allow the answer.
I can't think of another source.
Well, you looked at all the evidence in this case, correct?
Yes.
And you're a trained forensic pathologist,
Yes.
a medical doctor.
Yes, I am.
You've done thousands of autopsies.
Yes.
You'd examined the crime scene photos.
Yes.
You'd examined the autopsy photos.
Yes.
You looked at all the tox screens,
Yes.
and you had not come to the conclusion or formulated the hypothesis that Mark Jensen sat on Julie and shoved her face in the pillow and asphyxiated her. You had not come to that conclusion, had you?
No.
You'd not ruled out terminal asphyxia. You said you couldn't rule it out, but you'd not concluded that she died by terminal asphyxia.
That's correct.
Now, if Julie Jensen had not been asphyxiated, the ethylene glycol on board could have killed her without medical intervention. Is that true?
Yes.
Even though it seemed like it was a relatively small amount.
Yes.
But it's only after reading Aaron Dillard's description of Mark Jensen's confession that you compared the autopsy photos demonstrating the subcutaneous injuries to Julie Jensen's rib cage to the crime scene photo showing her having been rolled into that position, correct?
Correct.
Now, if Julie had just been rolled into that position and left there and died, could have been a possible explanation of maybe positional asphyxia contributing to ethylene glycol poisoning. Is that a possibility?
Yes.
However, would positional asphyxia explain the injuries to the rib cage?
No.
She only weighed 110 to 115 pounds, right?
That's correct.
So this skinny, tiny woman just laying on her side with her arm between her chest and a mattress would not cause those kinds of injuries to the rib cage.
I probably not.
But a guy the size of Mark Jensen, 165, 170 pounds, sitting on top of his wife and shoving her face into the pillow until she was dead, that would cause those kinds of injuries, wouldn't it?
It could, yes.
Can you think of anything else that would cause those kinds of injuries to the rib cage of Julie Jensen?
Not that fits the evidence in this case.
Now, so Aaron Dillard, you're aware that he's a con man.
Yes.
But he's not a seer, is he? You're
Not to
aware
my
that
knowledge.
He doesn't talk to the dead.
I hope not.
I mean, there was a television series called Medium, where I forgot the name of that wonderful actress who was a medium. She could talk to dead people. We don't have anybody in the Kenosha DA's office here that talks to dead people, do we?
Not that I know of.
Now, out of the 4,000 or so autopsy cases that you've been involved in, have you ever seen a case like this one before?
Not in the cases I've personally been involved in.
But you followed up on this case, didn't you?
Yes.
You did some research on your own.
Yes.
You compared suicides by ethylene glycol to homicides by ethylene glycol.
Yes.
And how many different suicides by ethylene glycol were you able to examine?
I looked at 15 of them.
And how many homicides by ethylene glycol poisoning did you examine?
Well, this one I examined directly. There were about 10 that were public knowledge.
But you didn't get all the tox screens from the homicides.
Not all of them.
But you got tox screens from some of the homicides.
Yes.
And you got tox screens from the suicides.
Yes.
What did you find in this analysis of ethylene glycol poisonings, suicide versus homicide? What did you find about, what inferences did you draw? What patterns did you see concerning the amount of ethylene glycol in a person who died by suicide versus
Judge,
a person who died by homicide?
Judge, I have an objection. It involves 971.23.
Take a break, folks. Right, the jury's outside the courtroom. What statute number did you say, Mr. Perry?
I was referring to the discovery statute, 97123. Ms. Mainland is testifying. Mr. Jamboys obviously knows what she's about to testify. He's leading her to it in terms of these comparisons, this follow-up, these studies comparing suicides to homicides. And I don't believe I have, I don't believe I've been provided with that.
The information that he's asking this expert witness
That's,
about?
that's right, that he, I think, plainly knows that she's done this and what her answers are going to be.
What's the state's response?
I don't, first of all, she didn't produce a report to me. She and I talked about this yesterday. And that's when she told me about it, that she'd been doing this research on her own and she came up with this information yesterday. So it's true. Maybe I should have told them about it yesterday, but I didn't. What I'd like to do is, what's that? I looked at 971.23, or actually I'm going to look at it right now. And so let's examine my statutory obligations. We produced, first of all, they've already have her testimony from the last hearing. And of course, she didn't testify about this, but they were aware of what her testimony was going to be as to cause and manner of death. And I'm going to pull up 971.23.
Under sub E, it talks about results of scientific tests, experiments, comparisons that the district attorney tends to offer in evidence at trial, and it talks about experts. So
I mean, I didn't object to the other things that, I did know about her prior testimony and the cause and manner of death opinion, didn't know about this, and I would suggest this is not a reasonable amount of time before trial. I'd ask that this be prohibited from being gone into.
Do you have something in writing as to what she was going to testify?
I'm sorry, Your Honor.
Do you have anything in writing as to what she was going to testify as to the comparison tests?
I don't have anything in writing. I don't. I don't have a report from her. I talked to her about this yesterday, and she was indicating that the average amount of ethylene glycol on board in a suicide is 2,000 micrograms per milliliter.
Because the statute then also talks about if the expert does not prepare a statement, there should be a written summary of the findings of the subject matter of the testimony. So we don't have a written statement. We don't have a written summary.
I don't, Your Honor. What I have is what she told me yesterday, and I suppose I could have told him about it yesterday, but that's when I found out about it.
For the record, we're not going there. Then, based on 971.23 sub E.
Okay, well, Your Honor, at this point, then I would at least like to have her produce those notes, and I will make copies of them, provide them to defense counsel, because it may be something that we'll go into on cross-examination of one of their experts, and it may be something we can go into in rebuttal after the defense has rested its case.
You're welcome to do that.
I'd ask that jury be instructed to that prior testimony as it related to her doing these comparisons be stricken and instructed to disregard it.
If I'm listening, hopefully I'm correct. We never got into the studies. She just talked about them, right?
Yes, she did.
Yeah, she talked about having.
We didn't get to the.
What
What did you find, right?
I objected in time for that, but she did talk about.
You did a good job, Mr. Perry.
Thank you.
So you want me to just say, hey, don't. The last test transcript or the testimony, she said that they are tests that's stricken.
That she's done these comparisons, that be stricken.
All right. And then, Mr. Jamboys, you free to give the defense a summary of.
Well, I've got to look at it first. I don't know if she's got it with her. Let me. Holding up the sheet of paper.
All right.
I'll mark it as an exhibit.
And we'll mark it.
break then?
Yeah, I was going to say, we're not going to bring back the jury and then tell them we're doing a morning break at 10:30. We'll just take our morning break, and then when they come back, I'll instruct them. And I just want to, on the record, that the defense is getting a copy of this report, so we're going to wait, and then we'll take our break.
Yes, Your Honor. And then I was hoping that I could do a brief voir dire of the witness about this information so that they will have that information, so that if I cross-examine their expert on it, they'll have that information, and they'll have that much of a report from the witness.
We'll do it after the break.
Yes, Your Honor.
Well, let's wait for the report because you marked it. I want that part of the record.
Okay, I am going to mark it. I haven't marked it yet, but I will mark it.
Brought in the courtroom by the bailiff.
Your Honor, it's Exhibit 90. Comparison, contrast, suicide versus homicide.
Record should reflect the district attorney is giving a copy to Mr. Perry, defense attorney.
I'm giving the original and the exhibit to Dr. Mainland. There's the exhibit.
Okay.
Okay, let's take our 10-minute break. Thank you. Tell the jury this is their morning break so they know.
Not at all.
Not at all.
Were you at one time?
No, I'm not. I wasn't at one time.
Wouldn't be able to testify at all about,
No, I would not.
okay,
Not
so
about ethylene glycol. I'm not an expert or even very comfortable going through the different pharmacokinetics of ethylene glycol.
so if you testified in 2008 about the phases of ethylene glycol, do you wish you hadn't?
I wish I hadn't.
I chose UW Milwaukee because they have industry connections that help launch careers.
I'm TC, and I've got cool sculpting done on my stomach. Cooking soul food with my fiance.
I do have one issue. If the parties want, I don't know if it's going to be an issue. Mr. Jambo, you could probably respond. Was there an issue as to the termination of Dr. Maureen Levin?
Yes, Your Honor. The defense had sought to cross-examine Dr. Mary Mainland about Dr. Lavin's termination of employment. Of course, Dr. Mainland was not here at the time that Dr. Lavin was terminated. The state believes that any testimony any information regarding Dr. Lavin's termination from employment is not relevant to this case. Dr. Lavin was the medical examiner for Kenosha County at the time this case was on December 3rd, 1998, the date that Julie was killed. But she testified at the preliminary hearing. But while preparing this case for trial, she refused to answer questions in my office about whether or not she was board certified. We knew she was not board certified. We were simply asking her questions about this, and she said she wasn't going to answer it. And I said, well, you understand that when you go into a courtroom, if you refuse to answer questions that are put to you in defiance of the judge's order, you might leave in that courtroom in handcuffs, and you are required to answer questions in court. And furthermore, when you're sitting in the district attorney's office and he's asking you questions, you are obligated to answer those questions as well. And if you don't, you're going to be terminated. And she refused to answer questions about her board certification. And as a consequence, she was terminated. It had nothing to do with her opinions concerning any of the evidence in this case. It had nothing to do with her theory of her prior testimony as to the cause or manner of death in this case. It was simply because she had not become board certified and she refused to answer that question.
So she never testified in Jensen 1, right?
No, she did not testify in the
And
trial.
Dr. Mary Mainland testified?
Yes, Your Honor.
And she was obviously the medical examiner for Kenosha County at the time, or from another county?
She was our medical examiner at the time of the Jensen trial.
So what would she know about the termination of Dr. Levin?
Well, as she indicated, she really didn't know that much about it. And she had heard things about it, but she wasn't here at the time that Dr. Levin had been terminated. I think what the defense counsel was trying to elicit from Dr. Mainland was that she was intimidated into rendering these opinions by the district attorney because the district attorney...
And that was you?
Yes, because the district attorney had gotten the previous medical examiner terminated. But she was not terminated because she refused to agree with the prosecutor's theory of the case. In fact, the prosecutor's theory of the case has always come from the medical examiners. It's not the other way around. But she was terminated because she refused to answer questions pertaining to whether or not she was board certified. It has nothing to do with the development of the evidence in this case. So it's completely...
Did we ever find out if she was certified or not?
She was not board certified. That's why she refused to answer the questions.
So, Judge, I think the concern is that as it relates to the cross-examination of Dr. Mainland testified that she was aware of some of this information, maybe not everything that Attorney Jamboy said, because she wouldn't have had that information unless Attorney Jamboy told her that information. But she was aware. Dr. Mainland was aware that there were issues with Dr. Lavin and her findings in the Jensen case, or her testimony in the Jensen case, that caused her to be terminated from her employment.
Did she testify to that in front of Judge Schrader?
She testified that she was aware that Dr. Lavin was terminated.
While you're looking at those other...
So, Your Honor, I can tell you this. The whole theory of the cross-examination of Dr. Mainland was to suggest, plant in the jury's mind, that Dr. Mainland was somehow intimidated by the prosecutor into rendering the opinions that she rendered in this case. Contrary to what defense counsel just said, there was nothing about Dr. Lavin's testimony.
That's what I'm saying. Get the transcript and let me take a look at it.
Okay.
So remind me, that's another issue for the pretrial. The first one that I want to deal with is the testimony that was in the original trial, which I will call Jensen 1. The transcript has been provided. I'm dealing with a letter
other points in our motion in limine. So this would be this letter for Dr. Long.
Oh, yes. The state had filed a motion to prohibit the defendant from introducing evidence concerning, in fact, introducing the letter that I had written on June 18th, 2003, and sent to defense attorney Craig Elby. The state objected to it as it being irrelevant, hearsay. And the defense sought to introduce the letter under a variety of theories, and the state will then address that. And we did so on, what was the page of this document? The document is document number 1487, and it was filed March 28, 2022.
Get to that document 1487.
Yes, Your Honor.
I wanted a degree, but 4 years to get one? No thanks. Then I found WGU. On average.
For the record, right now, there's 1,515 documents.
And Judge, this is something that was specifically ruled on by Judge Schrader. And what he said is he was going to allow the letter to come in through the expert. Otherwise, basically, Attorney Jamboy would be a witness in the case because it's a prior inconsistent statement.
And Your Honor,
What expert are we talking about?
Dr. Long.
Well, how would Dr. Long be in a position to testify about a letter that the prosecutor wrote to Craig Elby? There's no foundation for Dr. Long to be testifying about that letter.
Let me just stop you. Did he use the letter at any time to form any opinion?
Dr. Long?
Yes.
He never saw the letter, Your Honor.
The letter was a specific statement by Attorney Jamboy as to what Dr. Long was going to testify to at the trial.
Okay.
Dr. Long did not testify consistent with that letter, making the letter from Attorney Jamboy to Attorney Elby an inconsistent statement of a party opponent. This was argued at great length before Judge Schrader, and Judge Schrader ruled that it was an inconsistent statement and the letter could be used. And he basically said that he was going to allow the letter in so that Attorney Jamboy himself would not be a witness, because otherwise Attorney Jamboy would have to testify as to the prior inconsistent statement, which would make him a witness in the case. So instead of making Attorney Jamboy a witness, Judge Schrader allowed the letter in as cross-examination of Dr. Long.
And the state opposed that at the time, Your Honor, and none of the criteria that apply to the admission of prior statements by prosecutors, none of those criteria were met in that case. But
Attorney Jamboy conceded that some of those were met.
Well, I concede, Your Honor, that I wrote the letter and that the letter was in error, that I wrote that letter, that I committed an error when I wrote that letter. Then let me finish, counsel. Then at the time of the forfeiture hearing, Dr. Long did not testify in a manner which was consistent with the content of my letter. At the time of the trial, he did not testify in a manner which was consistent with that letter. So the fact that the prosecutor made a mistake in, March of 2003, I'm sorry, June of 2003, is not relevant, was not relevant at the time of this trial in January and February of 2008, and it's even less relevant now. So the error that I'd made in that letter was based upon a letter that Dr. Long had written, and that the state agrees that Dr. Long's letter is admissible. Dr. Long's letter made reference to the content, the amount of ethylene glycol in Julie's blood and Julie's stomach, and he described the ethylene glycol in her stomach as a large amount when it turns out it's a half a teaspoon of ethylene glycol in her stomach. That was discovered when the defense attorney filed their expert witness report, Dr. Rumach's report. So this was all resolved months, years in fact, in advance of the 2008 trial. And allowing Dr. Long to testify about this letter that I wrote in 2003 does not address the issue of it makes me a witness in the case. And I don't wish to be a witness in this case because I'm prosecuting the case along with Deputy District Attorney McNeil. So I don't think that this letter is admissible, and it doesn't fit any of the criteria for admission. It is a statement by the prosecutor, but it was never made in a courtroom. It was never made in an opening statement. It was never made in a closing argument. It was made in a letter to a defense attorney months in advance, in fact, years in advance of the case going to trial. It's just not relevant. It has nothing to do with the facts of this case today.
I'll give you a brief response from the public defender.
So Judge, specifically the three things that the Judge Schrader considered were the law in State v. Cardenas Hernandez, Cardenas-Hernandez, 219 Wisconsin 2nd 516. Judge Schrader found that it was an inconsistent statement because it went from a very large quantity of almost pure ethylene glycol in the stomach, which is what Attorney Jamboy wrote in his letter as an agent of the state, to just a large amount of ethylene glycol. So there is a difference between pure amount of ethylene glycol in the stomach to 660 milliliters to a half a teaspoon, which is what Dr. Long later testifies to. So Attorney Jamboy agreed that it was an inconsistent statement in his arguments before the court, and Judge Schrader found it was an inconsistent statement. It's equivalent testimony of something that of a defendant or a witness. Judge Schrader found it holds true that it seems to me that Mr. Elby has the right to argue to the jury that there's a circumstantial case tending to show that Dr. Long gave some faulty information, which would tend to raise doubts about the accuracy of some of the reports in this case.
A discovery issue and a summary report that Dr. Malin provided regarding some tests that she was looking at regarding the issue of suicide versus homicide regarding the poisoning issue. You wanted to do some voir dire questions, Mr. Jambois?
Yes, Your Honor. And first, I'm going to provide you a copy so you know what we're talking about.
All right. It's been marked, correct?
Yes.
90.
All right. 90 has been marked. The defense has a copy. Correct, Mr. Perry?
That's right.
Thank you.
So, Dr. Mainland, the judge had described this as a report, but it's not actually a report, is it? It's just,
No, just some notes.
Just some notes that you had obtained by looking at suicide, ethylene glycol suicides,
Yes,
ethylene glycol accidents,
yes,
and then undetermined.
correct.
Now, in the suicides that you looked at, the ranges of ethylene glycol that were found at the time of autopsy, and this is expressed in micrograms per milliliter, is that correct?
Milligrams per liter.
Milligram.
Micrograms per milliliter and milligrams per liter are the same thing,
Okay,
but you don't have to remember that.
so
So this is comparable to the units that Julie Jensen's blood, the
So-
reports
okay.
use.
So the first one is 570,
Yes,
7400,
yes,
2640,
yes,
not determined,
not detected.
not detected. Okay, 740,
Yes,
1200,
yes,
830,
yes,
less than 20,
yes,
259,
yes,
9746,
yes,
1200,
yes,
966,
yes,
4600,
yes,
not detected,
correct.
and 930.
Yes.
Now, where had you found these ethylene glycol suicide autopsy reports?
These are cases that came through some of the offices where I worked, Milwaukee, Tampa. I think there were a couple in there from Waukesha.
Now, when you saw some of these autopsy reports reflect not detected or less than 20, did you examine those reports to determine whether or not medical intervention had occurred?
Yes,
And had medical intervention occurred?
yes, and most of them.
In
I
the
think
cases where medical intervention had not occurred, the results were higher?
Generally speaking, yes.
And overall, in looking at the suicides, the average amount of ethylene glycol, number of milligrams per liter of ethylene glycol was 2,072,
Correct.
which is about 40 times the amount that was in Julie Jensen's blood.
Something like that.
Now, I'm not going to ask you any more about this report, but
Okay.
I am going to ask you about why one might expect to find less amount of ethylene glycol in a homicide rather than as opposed to a suicide. And you can answer that without looking at this report and referring to this report.
Okay.
You knew that before you did this report, right?
Yes.
Okay. So we're ready to proceed then, Your Honor.
Can I ask some questions about this report?
I think we should allow you to ask.
I don't have a problem with that, Your Honor.
Dr. Mainland, did you receive these autopsy reports in these cases?
Yes.
And you have those?
I have some of them.
Not all of them?
Not all of them.
I'd move for production of the ones that she has, for one.
Well, first, let's find out, where are they?
They're the ones from Milwaukee and Waukesha. I basically took notes from the cases, so I did not copy any part of the case file. I have a few from Tampa with me.
Do you have them here or do you have them back in Tampa?
I have a few from Tampa, I believe, with me. Hang on.
I have no objection, Your Honor, to her producing the stuff that she has. I just wanted to know what she had with her and what she didn't have with her.
Whatever she has, we can produce.
I'll wait while you look.
Yeah, the 1, 2, 3. I have 5 cases here from Tampa.
Just wait. The reporter's plugging your
Oh,
machine in.
sorry. All right, I have 5 case reports here from Tampa, and then the rest of what I have is handwritten notes taken from case files in Milwaukee and Waukesha and Kenosha.
I'd request that, would you have a problem with us making copies of those and providing you with the originals back?
Nope.
Okay, Your Honor, I'd request that the bailiff make 2 copies. And are these going to be marked as exhibits, Counselor?
I don't
guess
know.
we'll-
They can be.
Just do 2 copies and you can make a decision later.
Okay.
And maybe we should wait for the copying until I'm done asking questions in case there's
That's
more.
how you want to proceed? Go ahead.
Do you have, are you able to look at these numbers with the records that you have and tell me where each one of these is from and the date of death?
Yes, I only have, as I said, 5 records with me. Actually, some of the notes, I think I can tell you the date of death.
Okay, did you receive these autopsy reports and toxicology results? Did you receive those electronically from people?
I probably looked at them physically.
They were mailed to you.
No. I did this a while ago while I still had access, physical access in Milwaukee.
You did this while you were working in Milwaukee?
No, but I was able to go and look at cases.
Okay, before you moved to Florida.
Yes, I believe so.
Okay. Do you have the sources for who made the determinations that these were a suicide, an accident, or undetermined?
No, I don't have the physician's name.
Do you have the reports that accompany them to support how they came to that conclusion?
No,
You just have
just the 5. Yeah.
for 5 of them.
Yeah.
And for those 5, you don't have the things I just asked you about.
For the 5, I have the physician's determination of cause and manner. I have the initial investigative report, and then I have the toxicology report.
Do you know which on this list, which 5?
Yeah, the 5 from Tampa. Let's see. It would be 2 of the undetermineds. Hang on. 1. And the other 3 are suicides. Wait. No. 1 is an accident, 2 are suicides, and 2 are undetermined. those are the cases I have with me from Tampa.
Right. Which ones on this list, please?
The two undetermineds. Well, you see that, and they're just two of them. The suicides. Hang on. None detected. One was 460 milligrams per deciliter. That's 4,600 milligrams per liter. And the last one, 930 milligrams per liter.
And the rest you have no details on with you.
I don't have any, all I have is my notes with amounts.
Which is really just reflected on this, the sheet.
Correct.
So no supporting documentation.
I have, well, only my notes. I have notes as to day of death and a little bit about the circumstances,
Okay,
et cetera.
So, and there are 21, if I can
Right.
do addition, there are 21 different things listed on here, right?
Yes.
And you can tell us, you have details about 5 of them, right?
Yeah, I mean, official details, yes.
Okay. I thought you testified at the start. I thought when this, you were first explaining this, that you compared suicides, accidents, undetermined, and homicides. Was homicides a category that you had compared?
I did, but the homicides were those are from public knowledge. I have, fewer toxicology reports.
And those aren't on this list.
No, they aren't. I don't know of any other ethylene glycol homicides either from here or down in Tampa, which is where I pulled this stuff from.
Aside from your opinion about this particular case.
Correct.
That's the only ethylene glycol homicide that you think exists, that you're aware of.
In this area, yes.
Okay, so in terms of comparing your study, comparing ethylene glycol fatalities of what's seen in a suicide and what's seen in a homicide, on the suicide list, you have 15.
Yes.
And your homicide list, which isn't on here, would be 1.
Yeah, actually there are, but I don't have amounts for most of them.
You don't know the amounts?
No.
Okay. That's all I have. I think it's, there's a separate objection just simply to relevance in terms of the
That's a different objection.
That's a different objection. It's not coming in anyway right now.
Right.
I would still ask for production of those notes at this time, though.
We'll have
Your Honor, I will just say this. First of all, I think it should come in now because now they've been provided the report. They've actually been able to cross-examine the witness about the report. They've had plenty of opportunity to discuss the report. So now the report should come in. This is normally what happens, instead of evidence just being excluded, the court will give the opposing party the opportunity to voir dire the witness. And that's what they've just done. They've voir dired the witness. So now this report, her testimony about this should be admissible.
Well, let's go make the copy. Yeah, let's try to do one thing at a time here. I mean, it is Exhibit 90, right? Is that, do I got the right number?
Yes, Your Honor. As you can see, it's not a report, Your Honor. It's just a list of her notes.
I'm going to correct myself. It is what I would consider written summary. And it's pretty small.
And
I mean, I don't want to say this is extensive, but it's pretty small.
In terms of her conclusions from it and her opinion based on this list and the list of the 5 examples that I don't have yet, and all of the other limitations to this, I I think the reason that statute 97123 talks about a reasonable amount of time before trial and gives actual like deadlines for expert summaries, expert reports is for the, I mean, it's logical, right? You know, we have experts in this case that we would consult with, and we would, in order to cross-examine Dr. Mainland on this, have an opportunity to find out, okay, well, what are the stats that would compare to be able to effectively cross-examine on this. And so finding out the details of her notes of, which we don't actually have at this moment yet, of really 5 cases, and then her just numbers listed for 21 different cases is not within the meaning of that statute a reasonable amount of time before trial. And so I would maintain the objection that I thought had been sustained.
Well, it had been sustained. I'm not disputing the fact that the court had sufficient grounds at the time you sustained the objection. What I'm saying is that there are 2 potential remedies. When there's been this kind of what I would call an inadvertent discovery violation. It was my fault. It wasn't Dr. Mainland's fault. And she told me about this yesterday. And when I got it, I guess I should have immediately notified defense counsel, and I just forgot to do that. But one of the other options, instead of excluding the evidence, is to allow the defense or the opposing party to voir dire the witness. And that's what's happened here. So I think now the stuff that defense counsel's raised here goes to weight, doesn't go to admissibility. And I think that it should be admitted.
Would you think it would be beneficial to the defense's expert witnesses to have this information prior to today's cross-examination?
Well, you mean so that they could then consult with the defense attorneys about it?
Correct.
Yeah, it probably would be, Your Honor.
I think it'd be pretty beneficial. So it's not coming in on direct.
Thank you, Your Honor.
All right, bring the jury back.
Did we get those copies back yet?
I think he's still working on it. You got to slow me down sometimes.
Okay, so you're telling him not to bring back the jury.
I know. That's why you got to slow me down.
But I think, so we're not bringing in the jury yet, sir. So
We need the copies first.
we need the copies first, okay.
We heard.
both sides now have the additional documentation or notes regarding the comparison studies that the doctor talked about. Okay, let's bring the jury back out.
All rise for the jury.
All right, we're back on the record. Mark D. Jensen, 2002 CF 314. The appearances are the same. The jury's back in the courtroom. Dr. Malin is still on the stand under oath. I just want to tell you, ladies and gentlemen of the jury, there was some question about comparative studies of homicide and suicide. We're not going to get there right now, so disregard all that. Whatever was said is stricken from the record. So you can continue now, Mr. Jamwis.
So, Dr. Mainland, let's talk about ethylene glycol as an instrument of death, okay? It is effective as an instrument of death, is it not?
Yes.
What happens to a dog if it happens across a bowl of ethylene glycol on the ground and it drinks up the bowl of ethylene glycol?
It dies.
And why would a dog drink ethylene glycol?
Because it tastes good.
Now, at the last hearing, I had you taste some antifreeze, did I not?
Yes, you did.
I'm not going to ask you to do that again. You spit it out right if you tasted it, right?
Yes.
But how did it taste?
It was sweet.
So ethylene glycol itself has a sweet taste to it.
Yes, it does.
But antifreeze, which contains ethylene glycol, contains other things as well, doesn't it?
Yes.
What are the other things that it contains?
I believe propylene glycol, and nowadays they add a bittering agent to it.
But in 1998 they didn't.
Not here.
So, but there were other additives like things to prevent the engine block from getting rusty and things of that, rust inhibitors and that sort of thing.
I can't remember all that. I don't know all the chemical names.
But you knew how it tested when you, or how it tasted when you tested it back in 2008.
Yes.
And it tasted sweet.
Yes.
And that's what would cause dogs possibly to drink it if they found it on the ground.
Possibly.
And sometimes children would drink ethylene glycol, right?
Yes.
And there'd be an accidental ingestion of ethylene glycol.
Yes.
And they'd get very sick.
Yes.
And sometimes they survived and sometimes they didn't.
Yes.
And then there are people who ingest ethylene glycol because they want to commit suicide.
Yes.
And then there are other people who select ethylene glycol as a means of committing murder.
Yes.
So let's talk about what kind of research one would find on the internet if you were looking at potential ways of killing your spouse. What would you find about ethylene glycol?
Well, you'd find a number of the things that we talked about. You'd find about the effects and et cetera. You'd also find that it's not usually tested for at autopsy.
So from a potential murderer's perspective, that makes it an attractive vehicle to kill one's spouse.
Yes.
It's sweet tasting and it's not typically detected at autopsy.
That's correct.
Now, in the literature, if you go online and you look up ethylene glycol as a toxic substance, has the literature that was available, did it indicate what the typical lethal amount of ethylene glycol would be?
It depends. The most common number you'll see in the literature is 100 milliliters. That's an old figure that was taken from dogs in the 1930s. It's been shown that as little as 30 milliliters can kill a person.
To give the jury an idea of what 30 milliliters look like, I'm going to ask you to take a look at this. So that's a small dosing cup that came with my NyQuil. And how many different variations or markations are there on that? Demarcations are there on that?
There are two lines. The first one marks 15 milliliters, and the second one, closer to the top, marks 30
Could you hold that up to the
milliliters.
jury so the jury can see it? So 30 milliliters is just a little bit less than what's contained, what would be held in that cup.
Correct.
And is that the amount that you're holding there in your hand that would fit in that cup? Would that be a sufficient amount of ethylene glycol to cause the symptoms that Julie Jensen was manifesting?
Yes.
Would it be sufficient to cause the oxalic acid crystals that were found in her system?
Yes.
The amount of ethylene glycol was found in her blood and her gastric contents and in
Yes.
her urine?
Yes.
But that amount of ethylene glycol, that small amount, 30 milligrams or milliliters, 30 milliliters, would that be likely to cause her death very quickly, or would it be likely to cause her death over a longer period of time?
Every individual's different, but the symptoms are the severity of the symptoms will kind of depend on the dose. Well, not the severity, the manifestation. A person could survive. I'm sorry, repeat your question, please. I got off track.
Okay, well, let's start with this. You heard Aaron Dillard's, or you read Aaron Dillard's letter to his attorney where he indicated that Mark Jensen had provided Julie with 2 doses of ethylene glycol.
Yes.
So hold up that cup, and you said that would be sufficient all at once to kill her, correct?
Yes.
So 2 doses of half that amount would be enough to kill her?
Probably.
So hold up show the jury where the 15 milliliter line is.
Right where my fingertip is.
And so that's a very small amount of ethylene glycol.
Yes.
And if it were mixed in with a cup of orange juice or some kind of a juice, it might not be noticed.
Might not.
And if you're going to murder somebody with ethylene glycol, you don't want them to taste it on the way down, right?
Probably not.
On the other end, if you're going to commit suicide with ethylene glycol, you just gulp it all down.
Object to foundation.
Why don't you just lay a foundation as to that question?
Well, if a person is going to commit suicide with ethylene glycol, they want to die from ingesting ethylene glycol. Is that right?
Right.
So what are they likely going to do if they want to die from ingesting ethylene glycol?
Drink enough of it.
To kill them?
Yes.
All at once?
Yes.
Let's talk about the process of dying from ethylene glycol poisoning. You described the stages, but can you describe the level of suffering that a person who's dying from ethylene glycol, describe to the jury the level of suffering that Julie Jensen went through in the last 2 days of her life?
Especially the second and third phases of ethylene glycol poisoning, the second phase where glycolic acid is being produced and the body is becoming acidotic is very uncomfortable. I was describing how hard and deeply the person is trying to breathe in a futile effort to get rid of acid in the body. there could be some depression of the nervous system as well. First stage could cause even seizures. By the third stage, you can get pain, a lot of pain. That would involve the crystals building up in the kidneys. So you get pain from that. You would just feel misery. It's, I guess I could compare it to a bad flu. You would feel generally weak and miserable.
So one large dose would shorten the agony and the misery, and multiple small doses would prolong the agony and the misery.
Yes.
So if a person's committing suicide, most people who commit suicide don't want to suffer, they just want to die, right?
In my experience.
So ingesting multiple small doses of antifreeze is more horrific way to die than ingesting one large dose of ethylene glycol.
I would say so.
On the other hand, it's hard to get somebody to ingest a large amount of ethylene glycol unwittingly.
Objection, Foundation.
Overall, go ahead, you can answer.
Well, I'll back up. You tasted ethylene glycol, right?
Yes.
It was a sweet tasting substance.
Yes.
But there were other tastes to it that were not so pleasant.
Yeah, there were, yes.
I mean, you've had orange juice. Correct?
Yes.
And you like the taste of orange juice.
Yes, I do.
You don't like the taste of ethylene glycol that you're secretly hankering for more ethylene glycol, right?
No, I have not.
It doesn't taste as good as orange juice, does it?
No, it does not.
So if you wanted somebody to ingest ethylene glycol and you're going to spike their orange juice with it, you'd put in a little bit of ethylene glycol and a lot of orange juice.
That would help to disguise it, yes.
So 2 small doses is consistent with homicide, but inconsistent with suicide.
Yes.
And the information that you have concerning the last 2 days of Julie's death, or Julie's life, I should say, the last 2 days that Julie was alive, is that more consistent with 2 small doses or 1 large dose?
It's more consistent with multiple doses.
And that's consistent with what Aaron Dillard's indicated Mark Jensen confessed to him.
Yes.
Now, it is true that it's unusual for a murder suspect to confess to a fellow inmate, isn't it?
I wouldn't know.
It's also unusual for one guy to get drunk and tell another guy that he's planning to murder his wife.
Well, men say a lot of things when they're drunk, but I don't think that many men talk about murdering their wives.
But in this case, you're aware that there was evidence that Mark Jensen told Ed Klug that he was planning to murder his wife.
Yes.
And he was planning to murder her with a drug that crystallized her from the inside out.
Yes.
And is that a pretty fair description of what ethylene glycol does to you?
That would be a good layman's description, yes.
Crystallizes you from the inside out, right?
Yes.
Now, and after Ed Klug came forward, you're aware that Mark Jensen undertook a conspiracy with a fellow inmate to try to have Ed Klug done away with before the trial, correct?
Yes, I'm aware of that.
And you weren't aware of that before the forfeiture hearing, but you were aware of that, the first hearing, but you were aware of that before the second hearing, correct?
Yes.
So, Doctor, just to complete this line of questioning, As you're sitting here today, do you have an opinion to a reasonable degree of medical certainty as to the cause and manner of death of Julie Jensen?
Yes.
What was the cause of her death?
Ethylene glycol poisoning with probable terminal asphyxia.
And what was the manner of death?
Homicide.
Nothing further.
I take it, Mr. Perry, you're doing the cross?
Yes.
Go ahead.
Thank you, Judge. Dr. Mainland, when you started this morning, you were explaining your kind of qualifications for going through your CV, right?
Yes.
And you started from the beginning with your, was it a residency?
Medical school.
Yeah, and then fellowships.
Yes.
And your experience, you talked about, you added up over the years and the averages for the years, but you ballparked it as doing about 4,000 autopsies.
That's correct.
And that's up until your retirement a couple of years ago.
Yes.
And you indicated since retirement, you've done some consulting.
Yes.
Who do you consult with?
Well, I had a part-time job. I worked for LifeLink of Florida, where I reviewed cases in which tissue was to be donated. I did that for a while. I have another case with Mr. Jamboys, and that's about it, really.
Was that referred to you after your retirement?
Yes.
And that was for you to review records and see what had been done?
Yes.
And that's something you're doing just for private pay?
Yes.
Have you ever treated live patients?
Only in medical school.
Like when you're doing rotations?
Yes.
But never after you graduated from medical school?
No, unless you need to discount my family.
You've, setting aside any rotation you did while in medical school, I guess I'll refer to your professional career.
Okay.
You've never dealt with patients who are alive and depressed?
No.
I guess I could have broken that up. You've never dealt with patients who are alive?
Actually, yes, I have.
You have?
But few and far between.
Okay. You don't prescribe medications unless it's to your family?
No.
You're not a forensic psychiatrist?
No, I'm not.
What's a forensic psychiatrist?
A forensic psychiatrist is same thing as not same thing, similar work to a forensic pathologist. The psychiatrist will look back at a deceased person's psychiatric history and try to determine, what was going on with them, make diagnoses, etc. So I guess they're also employed looking at living individuals as well.
Okay. You've never treated somebody who's ingested ethylene glycol?
No.
Now, Julie Jensen died in December 3rd of 1998, right?
Yes.
Dr. Chambliss did the autopsy on December 4th, 1998.
Yes.
Everything that he did was then turned over to the Kenosha medical examiner.
Yes.
And that person was not you.
No.
You became the medical examiner in Kenosha in 2005?
Yes.
And you stayed in that position until 2008?
Yes.
So what your role was, it sounds, correct me if I'm wrong, similar to the consulting work you're doing now.
That's correct.
So you were reviewing an autopsy done by somebody else.
Yes.
You're reviewing samples that were taken by somebody else.
Yes.
Looking at photographs taken by somebody else.
Yes.
And you're piecing through the reports that have been provided to you, and you're trying to come up with something that the most consistent explanation that makes sense to you, right?
Yes.
And that's when you testify and you say the words a reasonable degree of medical certainty, that's what that really means, isn't it?
Yes.
Is this is what makes sense to you considering everything you've looked at?
Yes, you can call it an opinion.
Okay. To do your job, you need reliable information,
Yes,
and it needs to be credible.
yes.
Prior to today, did you review all your prior testimony in this case?
Very briefly.
You testified on direct that you reviewed the autopsy report.
Yes.
Do you usually take the photos when you do autopsies?
I take a lot of my own photos. Others do not. Some rely on autopsy technicians. Some rely on law enforcement.
And the reason you take photos yourself is you want to be sure that you're photographing what you want photographed.
Yes.
And you can be, it's part of the whole report essentially, right?
Yes.
Okay. You wouldn't want to, I guess you aren't doing autopsies anymore. It's a bad question. But you don't want to find out when film got developed that the picture didn't capture exactly what you wanted.
Of course not.
And, film hasn't been used in a long time, right?
Well, I used it in 2000, but it's been quite a while.
Okay. And then everything went digital.
Yes.
And in this case, these were film photographs.
I believe so.
And they were film photographs taken by Detective Ratsberg.
I'm not sure who took them, but I'll take your word.
Do you still have the autopsy report in front of you?
Yes.
It was a paper copy was given to you this morning, right?
Yes.
If you were to look at top third of page 1, would that refresh your recollection?
Yes, you're talking about
Right above the word personal effects.
I see that, yes.
Yeah, and it says photographs are taken by Sergeant Ratsberg of the Pleasant Prairie Police Department.
Okay.
You see
I
that?
believe that, yes.
Okay. Would you agree that it's the standard to take photos before incision?
Yes.
And the reason you want to do that is to document the state of the body as it's received by you prior to doing the autopsy.
Yes.
Any external findings would want to be documented.
Yes.
You haven't seen any pictures like that in this case, have you?
No, I haven't.
You're not aware that any external preliminary photos were taken at autopsy?
Not at autopsy.
And so when you're doing kind of your review of the work that's been done, a limitation is the work that's been done, right?
Of course.
And the quality of that work.
Yes.
How long does an autopsy typically take?
It depends. A really simple autopsy can be completed in an hour. Depending on the findings, depending on the type of case. Multiple gunshot wound case can take days.
In all of your years of doing autopsies as a forensic pathologist, have you ever done an autopsy and then just turned it over to somebody else?
No.
And the 4,000 autopsies you've done, you've then done the investigative part of it and sent things for samples and done the follow-up work.
Yeah, we do obviously have investigative staff, but I reviewed their work product.
Okay, and in this
together.
case, I'm sorry.
Yeah, I reviewed their work product and put it together with the other things that you mentioned.
By your staff.
Yes.
Okay, and in this case, you're understanding that Dr. Chambliss did the autopsy and then turned it over.
Yes.
And he didn't do any additional follow-up.
I'm not aware of it.
And he was the Waukesha medical examiner at the time, right?
I think so, yes.
I want to talk about that autopsy report, which is marked, I think, as Exhibit S. It's part of S10, I believe. And that's, you have that in front of you. And it describes the condition of Julie Jensen as of December 4th, 1998, right?
Yes,
It notes that she weighed 110 pounds.
approximately.
Okay. Would you think that the St. Catherine's, where this was done, would have had a scale?
I really don't know.
Would it be in the 4,000 autopsies you've done, do you weigh the body?
All of my autopsies, except those I've done in Kenosha County, I did not have a scale.
Kenosha County doesn't have a scale.
They did not at the time.
Well, presumably she was weighed, right?
Objection calls for speculation just by the word of presumably.
Sustained.
It's in Dr. Chambliss's report, isn't it?
There was
Objection, the question is vague. What is in Dr. Chambliss's report?
It's a follow-up question about how much Julie Jensen weighed.
Well, we know the report says 110 pounds. Let's move on.
Actually, it says approximately 110 pounds.
Approximately. Thank you for correcting it.
It notes only blunt trauma injuries are minor and few. Do you see that on page 1?
Yes.
And at the time the body was discovered, there was little or no rigor, legs and neck and body still slightly warm. Do you see that?
I'm looking for that. Which page is that on? Oh, yeah, I see it. I see it.
Did I read that correctly?
Yes.
What, you said what? I'm sorry, what did you say?
On page 1.
On page 1.
Now that would be consistent with her dying approximately 3 hours earlier, correct?
It could be, yes.
So if there was testimony that a first responder was at 4:35 p.m., would you ballpark her time of death as 1:35 to 2:35 p.m.?
It's, again, a very ballpark figure, but yes, it could be.
That'd be reasonable considering the description of her body at the time she was found.
Yes.
Do you see the spot in the autopsy where it notes the hemorrhage of the mucosa of the hypopharyngeal muscles on the upper back of the thyroid cartilage of the larynx near the areoepiglottic folds? How did I do?
Not bad. Areoepiglottic.
Areoepiglottic. Okay.
I'm looking for it. I recall reading that. I'm looking for it.
It's if you look at page 4 under gastrointestinal system.
Okay, I see it.
And it says there's a hemorrhage of that mucosa, right?
Yes.
That's something that is not an infrequent finding, correct?
That's correct.
That could be entirely post-mortem artifact.
It could be, yes.
Can you explain what post-mortem artifact means?
Sometimes a body after death would look as though something could look as though it's an injury, but it's not. That's the simplest way to put it.
Could happen just as part of the dying process, right?
Yes.
This description
Yes.
doesn't mean that a person was struck.
No, not necessarily.
You could die of a heart attack and have that.
Yes.
There isn't a photo that adequately shows what this is there?
There is, yes.
Is there a description or photo enough for you to make a decision about the cause of that?
In this case, it was not.
Okay. That finding, based on the autopsy, doesn't reveal a whole lot, does it?
No.
I want to talk about on that same page under cardiovascular system at the top. Do you see that?
Yes.
It notes there's petechiae in the lung and pericardial sac.
Yes.
Can you explain what petechiae are?
Petechiae are, it's just a doctor word for tiny little hemorrhages, almost rash looking, just tiny little pinpoint hemorrhages.
And you can see those anywhere, right?
Yes,
Anywhere in the body,
pretty much so, yes.
living or dead.
Yeah, yes.
Is there anything suspicious about there being petechiae in the lung and pericardial sac?
Possibly, not always.
It doesn't necessarily mean anything.
Correct. It could be a post-mortem artifact.
Oh, that could be something that just truly just shows up after somebody's died.
Yes.
And that's a pretty common finding.
Fairly.
And the pattern that these are described in, that's consistent with what you just said, right?
That it's a probable post-mortem artifact?
Yes.
Or peri-mortem? It could be, yes.
Okay. A heart attack can cause petechiae?
Probably.
Straining?
Yes.
And nothing even discernible can cause petechiae.
That's true.
Find the right page. On page 3, under internal examination, under neck organs, tell me if you see that.
Page.
Organs.
Okay.
It notes that the small and large strap muscles show no sign of injury.
Correct.
Can you explain what the large and small strap areas of the neck are?
Yes. There are muscles, talking to the microphone, there are muscles that run down underneath the skin, run down the front of your neck. Guys can tense that up and see the shaving muscle, they call it. And then there are other deeper ones that run down either from your, from like the top of your throat or from your larynx down to your sternum, basically.
Okay. And you might find an injury there if somebody had been strangled, correct?
Yes.
There's no indication of that in this case.
No.
There'd be evidence of injury in a strangulation because there'd be pressure on those muscles, right?
Yes.
Same section. You see where it says the mucosa of the larynx is normal.
Yes.
The cartilages of the larynx are normal.
Yes.
The hyoid bone is intact.
Yes.
You might see damage to that area if there was pressure on the neck, right?
Yes.
And in this case, there's no damage to that area.
No.
Talked quite a bit in direct about the gastric contents. The report doesn't actually indicate that gastric contents were collected, does it?
No, it doesn't.
It gives a description of the gastric contents.
Yes.
It indicates that there were about 660 milliliters, right?
Correct.
And I think it described that it contained what Dr. Chambliss described as potatoes and pepper.
Correct.
Have you ever examined the gastric contents?
No.
I want to walk through a little bit of measurements in this case, because there's been a lot of discussion about that. I can just skip to the end. Do you agree that 660 milliliters is about 22 ounces?
Sounds about right.
You testified that the toxicology report indicated that there were 3,940 micrograms per milliliter of ethylene glycol in that stomach.
Yes.
A microgram is 1/1,000,000th of a gram, correct?
Microgram. Yes.
$3,940 micrograms per milliliter. If we were to multiply that by 660, we would get 2,600,400 micrograms per 660 milliliters. Does that sound right?
Yes.
That's the equivalent of 2.6 grams.
Correct.
Which is the equivalent of about 1/10 of an ounce.
You're making me do math on the fly. I grant that, yes.
Okay. A teaspoon is 0.166 ounces. Sound right?
Sounds reasonable, yes.
This is about 2.6 grams of ethylene glycol is about half a teaspoon.
Yes.
Okay. So out of the 22 ounces of stuff in Julie Jensen's stomach, about half a teaspoon of it was ethylene glycol, according to this, right?
That's correct.
Okay. The autopsy report notes that the stomach was distended.
Yes.
That could suggest that the stomach was not emptying properly, correct?
It's possible, yes.
And if the stomach had stopped emptying, that could extend the amount of time that ethylene glycol in her gastric contents would be absorbed into her system.
Yes.
Beyond what you might typically expect with the absorption of ethylene glycol.
Yes.
Because what you'd typically expect with the absorption of ethylene glycol is what you'd typically expect in a correctly functioning GI system, right?
Yes.
And there's indication that Julie Jensen's GI system was not functioning the way it should be.
Yeah, at least at the time of death.
Now, gastric emptying time is variable in individuals.
Yes.
We have no idea about Julie Jensen's gastric emptying time.
Correct.
Gastroparesis is when the stomach doesn't empty properly for any number of reasons. Agreed?
Yes.
And that's a pretty common thing to occur even in healthy individuals.
I'm not sure how common it is, but I mean, it's knowledge.
Okay. Properly functioning kidneys one of their jobs is to eliminate nitrogen wastes from the body, right?
Yes.
And if that's not happening, then something called uremia can develop.
Yes.
And the uremia is really just the buildup of nitrogen waste in the body.
Yes, basically.
That's something that can cause gastroparesis.
Yes.
An electrolyte imbalance, kind of the acid-base status, is something that can affect GI motility.
I would imagine so, yes.
Yeah. Also, meaning that can cause gastroparesis.
Probably, yes.
Now, for something to be absorbed through the lining of a stomach, that something needs to come in contact with the lining of the stomach, correct?
Yes.
Our intestinal tract has absorptive cells.
Yes.
Now, peristalsis, did I say that right?
Yeah, good job.
Thank you. Is the grinding up of the food, liquid, everything that's in the gut, mixing it with digestive enzymes, and puts it into contact with those absorptive cells.
Correct.
Now, when there's gastroparesis, that's breaking down. That system isn't working, right?
Correct.
To know whether the half a teaspoon out of the 22 ounces would have come in contact with the lining of Julie Jensen's stomach, with those absorptive cells, we really need to know what the other 22 ounces are, right?
I'm not sure how that would make a difference.
Well, if it's if the 22 ounces is just clear water, that's different than 22 ounces of sludgy food, right?
Okay, I understand now what you're getting at. Yes.
Yeah, you'd agree with that then?
Yes.
That to assess the likelihood or unlikelihood of what was going on with that half a teaspoon, we really need to know the makeup of those 22 ounces.
Yes, that'd be helpful.
And we don't know that, right?
We know some about it, but we don't know the chemical composition. We know the texture, the color, etc.
We know the color, and we know that it, the description from the person doing the autopsy is that it contained potatoes and pepper.
Correct.
I think you testified on direct about somebody who is acidotic.
Yes.
Now, the human body maintains a slightly basic acid-base status, right?
Yes.
For somebody who's healthy, it's around 7.4.
Approximately, yes.
And when you go below 7, that's an acid, right?
Yes.
Okay. Now, if there's too much acid, that's toxic to the cells in the human body, right?
Yes.
And Julie Jensen was necessarily acidotic, wasn't she?
Yes.
And we know that because she was actively processing ethylene glycol.
Yes.
And the metabolism of ethylene glycol breaks down into those acids that you talked about.
Yes.
The oxalic acid and then the glycolic acid.
Correct, among others.
And is there any way for a body that's processing ethylene glycol to not be acidotic?
If there's a significant amount of ethylene glycol, probably not.
And that's something that we talked about, that electrolyte imbalance is something that can delay gastric emptying.
Yes.
The autopsy report indicates that the urinary bladder was distended with 150 cc's of urine.
Yes.
That's a pretty typical amount for somebody to die with.
Yes, it is.
You have an indication that Julie Jensen was drinking a lot of water?
Yes.
And you referenced looking at scene photos and descriptions of the scene, right?
Yes.
There's no indication that any bodily fluids were found in the bed.
Not to my knowledge.
That would suggest that she was able to get up and go to the bathroom, wouldn't it?
Either that or she simply wasn't going.
Okay.
Or someone helped her.
Those three options,
Correct.
but it was a typical amount in a bladder.
Yes.
The small amount of soft tissue hemorrhage to the ribs.
Yes.
That's a non-specific finding, isn't it?
Yes.
That could just be congestion.
It could be, yes.
Can you explain what congestion is?
Congestion, excuse me. Congestion just means settling of blood. Settling or a collection of blood. That's all.
Is another way of saying that is that, would that be post-mortem lividity?
Yes.
So if laying face down with gravity, blood would pool correctly?
Yes.
Correct?
Yes.
And that's something that that this might be.
Yes.
That's something that could have happened when the body was even moved.
I'm not sure about that.
You have no idea whether it's an injury, correct?
I can't say definitively that it is an injury.
And you don't know how long it had been there.
No, I don't.
Is that something that could be a post-mortem artifact?
It could be.
And it could just be simply congestion of blood.
That's a possibility.
And you're aware that Julie Jensen was found face down.
Yes.
It could have been from bumping into something.
Kind of an odd place to get injured from bumping into something.
Well, if somebody was
Maybe.
if somebody was in an intoxicated state, they could have bumped into any number of things, right?
It's possible.
So it could be an injury, could not be an injury.
Correct.
Could have happened before death, could have happened after death.
I don't think it happened after death.
That's what post-mortem finding is, right?
Yes.
Okay. The positioning of the arm in the photo, that today you said you thought it was an unnatural position.
Yes.
You'd agree that people sleep in weird ways.
Yes, they do.
And when people are on their side, an arm has to go somewhere, doesn't it?
Yes. At least one of them.
Right. The report notes bruises on the right buttock.
Yes.
That's also not a specific finding, right?
That's correct.
That could happen from falling or running into a table.
Yes.
You'd have no idea from this description how old they are.
The description would indicate they're fairly fresh.
Could have been there for days.
Maybe a couple.
The bruise on the right shin, you saw that in the report.
Yes.
That means nothing to you, right?
That's correct.
That's also what you'd say is non-specific.
That's correct.
That could be from bumping into anything.
Correct.
Also, no idea how long that's been there.
No, I don't remember. Don't remember if he described the color. But
It just, is it the location that makes you think it doesn't matter?
yes.
The report notes a superficial yellow, slightly curved abrasion over the right side of the front of the neck.
Yes.
That's something that could be post-mortem.
Yes.
That's something that could have happened before her death.
Yes. Shortly before.
It's described, I thought, as like by the shape of a fingernail, right?
Yes.
Could have been caused by a fingernail.
Could have, yes.
Could have been caused by not a fingernail.
Sure.
It's superficial, meaning there's no injury underneath it, right?
Correct.
That's something, I think, I don't want to misstate what you just said. That could be post-mortem, right?
Yes.
That could have happened from moving the body.
If somebody grabbed the body by the neck, I would imagine so.
If somebody moved the body and glanced the neck.
Possibly.
There were pictures at the scene when she had died, and it showed her eyes, right?
Yes.
You remember seeing those?
Yes.
That's something that doesn't strike you as significant in any way, right?
The description given by Dr. Chambliss, if that's a correct description, no, it does not. It's non-specific and common.
It doesn't mean anything to you based on his description.
Correct.
And we kind of have to go with his description, right?
Right.
The same scene photos showed her nose.
Yes.
Now, it's not uncommon for people to die face down, is it?
It happens.
And if you die face down, you have the weight of your head on your nose, right?
Yes.
Cartilage is pretty pliable.
Yes.
Not unusual for a nose to be pushed to one side.
No.
By the time of the autopsy, it indicated that the nose was midline.
Yes.
No damage at all.
None was described, no.
I want to shift to, well, Judge, I'll ask you this. I'm going to shift to a new topic.
Let me just ask you, how long is your cross going to be as of right now? How much more do you need?
I suspect at least an hour.
All right. And you're going into a new topic?
I am.
I think it's a great time to stop.
Yeah.
1:15, folks. Don't talk about the case.
Prosecution's last witness. I'm thinking of having our first witnesses here at 3. Does that seem appropriate based upon cross, redirect, recross?
Well, I'm expecting my redirect's going to be quite brief. Certainly not anywhere close to an hour. And you said yours is about an hour? We're going to start at 1:30?
I mean,
I said 1:15.
Oh, 1:15,
So we're-
start at 1:15, you'll be done at 2. I'd say 3 o'clock is a reasonable
All right.
time.
So we're going to be done by 3 o'clock with this witness.
maybe.
Maybe I shouldn't ask the question.
Don't jinx us, Judge. Just having a couple of witnesses drive from Milwaukee, so I'm going to tell them to be here at 3.
So let me just ask Mr. Jamboy before we go off the record.
Bob.
Is this your last witness?
It is, Your Honor.
Thank you. All right, have somebody available.
But 3 o'clock's an okay time to tell them to be here? And they're coming from work, so I want to be respectful of time.
I don't want to stop at 3 and we got nothing to do.
And there's going to be an afternoon break.
I'm just saying, is 3 o'clock an okay time to have someone here, or should I have them
I
here
think it's a
earlier?
great time.
Okay.
All right, we're in recess.
Let me just can everybody type in the chat? Let me know that you guys can hear me and
Oh, I can see it now.
okay. Let me just put up a little banner here so everybody knows what the hell we're doing.
I think everybody's saying hello. Oh, cool. Hi, Eva.
There we go. Perfect. Perfect. Cool. Okay, so just to let everybody know what we're doing. So we had talked about kind of in the YouTube chat earlier. So Denise watched the 2008 trial. She watched a bunch of it, and she was pretty convinced at that time that Mark Jensen was guilty. Now she's come back and she's watching the retrial of Mark Jensen, and she's been with us for a while since the start here and following on, and she's been kind of taking notes. So tell us about the trial that you watched in 2008. What made you really think that Jensen was guilty in 2008?
Well, the first thing I would say is the letter, was a big thing. And then when I didn't hear that long ago that the letter had gotten thrown out and that it was retrying. I didn't hear about that a year ago. I didn't hear about it anywhere. And I was just on my phone at work and I was looking for a trial or something to watch. And I was like, what is this? So I was like, there's no way. This has to be the letter that they're throwing out. So I went and I did a little research. And I'm like, holy smokes, I can't believe this. And so it was hugely convincing. But even then, I was like, if they throw this letter out, there's still so much circumstantial evidence that was in that case between the neighbors and, not knowing what they were going to allow in. But the computer stuff was a huge thing. The Klugs were a huge thing. It wasn't just that Klug, because he's a weasel, right? I mean, we all know he's a weasel. He's like the Wormtail, of this. If this was Harry Potter, he's the Wormtail, But I would say, but his wife was so convincing. You know what I mean? I'm like, why would his wife lie for him? So then with this trial, when the wife came on, I was like, okay, now they're divorced. So, if she thought that he was bullshitting back then, unless she did it to save her own face, or the fact that she would have gotten in trouble for, testifying in a court of law and not being honest.
Right.
What reason would she have to lie for her weasel husband now? But then when he said he went back to the Appleton branch, right, and they had gotten the call there, and when there was the woman that they had gone back and forth without the presence of the jury about the excited utterance, I believe the woman was a secretary, her name was Stephanie maybe, and she said, "Oh shit, he killed her." He also went back to that same branch. I believe it was Appleton that Klug, sorry. When he went back there after that, what did they call that conference? The summit or whatever they did. I can't remember the name of it now. But when he went back there, he was talking shit in the office. Allegedly, he was talking shit in the office. He was going up to anybody who would listen to him talk and saying, "Oh my God, Mark Jensen told me he was going to kill his wife." I don't doubt that the two of them, if the conversation did happen, that they were both hypothetically talking about it, which I think was probably a reason why he didn't come forward. So that's kind of like what I always thought. Like that would be the reason why he didn't come forward, because he would incriminate himself, and he was trying to work things out with his wife, and they had renewed their vows and all that crap, but now I would really like to see, and I don't remember, because like we're going back 14 years, and I have COVID, okay, so like I have COVID brain right now, so the fact that I can't even remember all this stuff in detail is kind of crazy to me. But if there was a corroborating witness from back in the day in 1998 that could come forward and say, yeah, he came back and he was telling everybody by the water cooler or at lunch or wherever that Mark said he was going to poison his wife with antifreeze, that would change things for me. But at this point, as it stands, the defense case hasn't even started their case in chief yet. That's what's crazy. They are annihilating their witnesses.
Happy New Year, Michael's Rewards members. You scored a free $5 bonus reward. That's $5.
Yeah.
Right?
Yeah, I think they absolutely are. I mean, we've seen, the pathologist Michael Chambliss. That was a big one because he was a key witness back then. And I think Attorney Perry absolutely demolished him. And then the very end there, where he gets him to say, he starts talking about the antifreeze and asks him about it. And Chambliss is like, I don't even know. I don't want to speculate on anything. I'm not an expert. I don't know the chemical compounds of it. I don't know anything. And then I think that pretty much shut down Perry's whole line of questioning. And he just jumped right to the end and said, so if you testified about this in 2008, do you wish you hadn't? And Chambliss says, yeah, I wish I hadn't. And I went, oh my God.
Yeah, I would have tapped that right then too. I'd been like, thank you, sir.
Right.
It's been a pleasure. Grab a t-shirt on the way out. Bye.
Yeah, exactly. What else? So like we hear that. And then what other things kind of stuck out to you that like made you kind of go from this guy is 100% guilty to, oh shit, now I'm not sure?
Well, you know what? It was a little hard for me to get sold on the fact that she was doing this gone girl thing. You know what I mean? I
like how you put that. If you guys haven't seen that movie with Ben Affleck, Gone Girl, watch that. And then I want you guys to watch that. All right. Watch that over the weekend. And then seriously tell me that
it's like the basic instincts of our generation. It's terrifying.
Right.
That somebody could do that. So then you think about this woman. That stuff's not even out. The fact that she could think of that, she would have to be one of the most diabolical criminals. You know what I mean? I mean, even though, the only thing that now I buy, because the defense has changed what they're saying. They're not saying she tried to kill herself, saying she attempted to feign suicide, right? So that he would get away for attempted murder. And I'm thinking, okay, as a mom, she doesn't want her husband, father of her children, going to jail for murder. She doesn't want to die and leave her children. But okay, I could see her being like, you know what, you little son of a bitch, you fucking torture me with these pictures all the time, and your penis fetish or whatever else you got going on. I'm gonna fix your ass, you know. So maybe she did sit there at home like the good little woman and just, you know, come up with this shit. Maybe there's a book that she read. Who the hell knows? But like, I thought it was weird about the neighbors, because she was so close with all her other neighbors. She honestly wasn't that close with the two that she had entrusted the letter and the rolls of film to.
Right.
And all that stuff. And I'm like, why all of a sudden is she trusting these people over the last 6 months? You know what I mean? She's known them and been basically just say hi and wave neighbors for 7 years, or since they bought the property across the street and then went up buying the property next door to them and building the house and all that stuff. And the guy had done work in their house too. He redid the office. He did work there in their home, and she still wasn't close with them. And then all of a sudden, the last 6 months. So all of this stuff that's coming out in this trial is, you know, I'm just paying more attention to those details now. So, you know, I tried not to take anything from 2008 and carry it over with me, because anytime I watch a trial, I go in there and I'm like, I'm going to pay attention to what the jury is getting. If the jury is not in the room, I'm not going to carry any of that stuff with me to form an opinion about it. But I've been trying, but the damn jury's been out of the room so freaking much this trial. I'm like, Jesus Christ, it's going to take 6 months to get through this thing.
Right.
And but the kid, the computer kid, what's his name? Ruff?
Yeah.
He was fantastic. That was fantastic. I mean, I said, if they could, what was it yesterday? I think I said, if they could show me that Julie, if they could show me a way to make it that Julie lied about being computer savvy, then there's nothing she couldn't lie about. And she was out there spilling that to everybody. And that's what she did. She went and peppered that shit everywhere.
Yes.
You know?
Yes.
She went and peppered the drinking, the computer stuff. You know, she went and sprinkled that shit everywhere. And not just to, you know, not just to anybody, the two neighbors who really didn't talk to anybody else, right? Just the two of them for the last 6 months. You know, I'm surprised she didn't talk to a priest, because she talked to the cops. She talked to these two neighbors who were like freaking saints, right? The school teacher, the school principal knew about it. Like, you know, I'm surprised they didn't come up with a priest too. You know, maybe she wasn't religious. I don't know. But she really did pepper that shit everywhere. You know, and I was like, ooh, yeah, okay, Kevin, I see your point here.
Yeah, see, that's a thing for me. So, you know, I saw the letter. So I knew, so again, transparency. So again, one of the legal counsel is our company counsel. But again, she can't talk about the details of the case. I told you guys, I texted her, I tried to get her on to, you know, just give us background, not tell us about like the juice, you know what I mean, but give us background about what it is and maybe things we should pay attention to. But she said she can't make media comments. So she's never said anything to me about the case other than, did you hear that the Jensen case is coming back? And I was like, no, I had no idea. And they said, yeah. She goes, yeah, they're not allowing the letter this time. So for me, I focused on the letter and I read the letter and I was like, I'm like, oh, Jesus, this is a damning letter, right? Like this is a big deal. So, and then as we like started doing all the background, and I was doing stuff prior, you know, to showing even you guys, but as we were doing the background stuff with you guys and we were playing this old footage and going through the history and case details and background of the confrontation clause, all these things, and listening to the old footage, I was like, man, something's wrong with the I don't drink, something's wrong with the I don't take pills. And I've said that from day one, that I didn't trust that letter to begin with.
Yeah, it's a weird thing to say. I mean, I have a very similar personal background to her as far as having a mother that was an alcoholic. I don't drink very often. I know I joked about it a lot the first day I was on there. But like, I'm very OCD. I plan that shit like it's an event. You know what I mean? When I'm actually going to do it, like it has to be the wind has to be going the right direction. My children have to be accounted for. You know, there has to be nothing that's out of my control when that happens. But everybody around me knows that. And I definitely would never say, oh, I have 1 or 2 a week. I don't have 1 or 2 a week. I'm lucky if I have 1 or 2 every 6 months.
Right.
You know, 1 or 2 a week, you're drinking. You know, my background is drug, alcohol, and, you know, criminals with, you know, mental health issues. So, you know, an alcoholic is, you know, 3 drinks a night. You know, you have a drinking problem. It's part of the standardized, you know, system. You know, at least it is, but in the state of New York, and as far as OASIS goes, which is the state agency that oversees all drug and alcohol programs, you know.
Yeah, Wisconsin likes to say if you have a couple of drinks a week, you're an alcoholic. They're kind of psychotic out here.
Yeah, it would be considered, if you're drinking 1 to 2 a night, it's, you know, okay, you're drinking a lot, but you're not dependent on alcohol. If you're drinking 3 drinks a night or more, you're dependent. You know?
Yeah. What did you think about so is in regards to the forensic kid, DCI guy from the Fusion Center. So and
also the I'm sorry to interrupt you, the recordings that you put on last night, those other things, I know they were behind jury stuff that was going on and different things, but those pre-hearing things, I was like, holy shit, this guy is so fucking crooked. Jamboy and his wife sitting over his shoulder, it's creepy as fuck.
Yeah, there's definitely something around Jamboy that I don't trust. And that's why I said, you know, like, let's say the cocaine thing, if like, let's say that was the only allegation, right?
Yeah.
It seems far-fetched. They have put holes in that theory, right? So, I mean, it could go either way. They definitely put holes in it. So if that was the only thing, I'd be like,
yeah, but
I don't.
Who, you know, I'm sorry, but I don't care what your position in life is. You know, if you don't want anyone, he knows 2 hours away, but that's not a big deal. If you're going to go score coke, you're going to drive 2 hours away, so no one's going to know you. If you're the freaking DA of Kenosha County, why wouldn't he drive 2 hours away? I hope he would, or he's a fucking idiot. You know,
right. And that's the thing is, like, you know, thinking logically about that, and I know that can be hard for some people because they don't know much about drugs or how the deals work and the secrecy and right, because it's probably taboo is the wrong word, but
oil change anxiety, the stress of not knowing who to trust.
You know what I'm saying? Like, you don't want people to know, right? Because there's shame behind that. So even addicts, right? They go through, even when they get they score whatever drug they're using, they go through this kind of cycle of shame and guilt, right? And then
he also doesn't want to go in, you know, a half hour away from his house and get ID'd by somebody who he's pinched before, you know?
Right. Yeah, that's where that one for me, I'm just like, and I kind of cringed when Milosauskas is just laughing at this stuff and he's like losing his mind. Like, it's not even because he lives in Madison. I'm going, bro, how many like drug people have been in front of you? Like, you don't know how this works. And I get it, dude. Like, it's a big accusation and we don't really have proof on it. And we're going to smear, you know, this public official.
I honestly didn't believe it until I saw and heard it with my own eyes, you know?
Yeah. And that coupled with everything else, you've got the letter thing, you've got the termination of Lavin. There's too many scandals.
That too. That was wild. I mean, he's like, oh, she sat in my office and she wouldn't say anything to me. And, you know, she wouldn't admit that she wasn't that her license wasn't updated or whatever.
Yeah, she wasn't board certified.
Certified. Okay, so you hired someone that wasn't board certified?
Right. That's the thing that caught me too, is going, oh, I don't understand why you hired her in the first place then. You know what I mean? Unless there was some like condition of, you know, we'll hire you, but within 6 months you have to have this certification, and she just never got it. So, you know, I think we need a little bit more detail on that. And you know what?
We hire people like that too. Like, you know, certain people won't have all their credentials and they come under somebody's wing for supervision by a certain time in order to operate for everything that we need them to, they have to have it or they're gone, you know?
Right, exactly. So I could see something like that, you know, and that's what, you know, we gotta try to play devil's advocate. So maybe Jamboy is telling the truth, right? I wish there would have been a little more detail so we knew, like,
Yeah, I see JK
definitively.
say he must have been buying large amounts at the time. He probably was.
Yeah, I don't think he's driving 2 hours.
He's not going there to buy,
for a G.
Yeah, a gram.
You know what I mean?
Yeah.
Right, exactly. So I mean, he's definitely going with. I'd say at least an ounce, if not more. I would even say, you know, definitely not a G. He's probably not buying a teener. You know, see, Denise laughs. Denise knows. So it's definitely a large amount. But yeah, it's the pathology thing was. That's the one thing for me that I was just like, because I'm used to Kenosha. That's why, you know, I tell you guys, I investigate Kenosha so hard. And, you know, maybe I push for donations a little harder than some other streamers do because of what we do. We don't just sit here and live stream. Like, we actually investigate real life stuff. And, you know, we try to like Serpico this stuff. So, you know, when you hear stuff like this, it's like, man, dude, you lose the original report. It'd be one thing if they lost the report.
That too.
You know,
that
like
too. How does no one have a record? It's not that they wouldn't have any computers. Computers weren't in everyone's homes. You know, all these things are generated and sent off to other places via either a fax or computer. Not more than one person had to have that report. How did it disappear?
Yeah, right. And that's the thing. And let's just pretend like, okay, fine, they did lose the report, but now you've got a scandal surrounding why this pathologist is fired. And then you've got her boss, Mary Mainland, and even Jamboy says in that pretrial hearing that that Mary Mainland testified to the prosecution's theory because there's the allegation that she was intimidated to testify that way. So now I'm going, okay, dude, what's going on here? And then you got Chambliss, who comes into the picture, and he does the autopsy now, like a re-autopsy, and his theory matches, you know, everybody else's. And then we find out that he lied in 2008 trial, and I'm going, oh my God, dude, what? I don't understand what the fuck is going on here with this. Like, this is, that's why I keep saying for Bobby Boy's, you know,
yeah,
I don't want to say credit because that's the wrong word. I can't think of the right word now, but to give understanding, you know, the higher ups are putting pressure on these guys, and heads are going to roll. People are going to get fired, and that's where I think Bobby Boy.
I mean, do you personally know, has he been working? Because I saw a news clip of him recently. I guess it was from about a year ago or whatever, or a year and a half ago. And he said, if this thing comes back, I will pull myself out of retirement and personally prosecute him again.
I thought he had some job. I know in the interim of everything, after
This is the plan to finally connect with our family's heritage.
I think it was even before the 2008 trial, because in 2006 is when this alleged thing with Thompson happened. So before the trial even happened, he left as the DA of Kenosha County. He left and went to Madison for like I don't know the title he had, but it was a hired job, right? Like an attorney general.
Oh yeah, and that was another thing. The judge was like, oh, well, technically he wasn't working in this county when that happened anyway. I'm like, does that matter?
And that's I said the same.
Matter?
Yes, I said the same thing. Like, Jesus,
it's
God,
okay
dude.
that you're I was almost said public defender. You're is he the head prosecutor? I think he is, right? So it's okay that he's having, you know, a white Christmas every weekend, and then he's coming in and putting fucking people behind bars for the rest of their life.
Right.
That's okay. Oh my God.
Yeah, that's a lot of stuff with him where it's like, you know, and you know, look, if he wants to go and do you know, skiing trips on the weekends, like, fine, let him do whatever he wants, right? But when you're doing skiing trips that involve these, you know, witnesses in this high profile case, now we have some serious questionable ethics issues, you know, I'm literally there needs to be a federal probe into this.
I would love to see him picked apart. I really would. I would love to see a huge investigation of all these pieces of shit, because they just seem like they're so crooked. You know, they really do. I mean, we have our problems here too. Don't get me wrong. We have a very overzealous drug task force that does all kinds of creepy, shady shit all the time. And I deal with guys who deal with that all the time. And I've seen it multiple times with different clients. But it's not at that high of a level. It's not going to the judges or the prosecutors. You know a lot of times it gets knocked down.
It probably is though.
A lot of times these charges are getting knocked down though. It's just these one Yahoo guys. They think they're fucking cowboys. It's like, yeah, it's crazy. But Jamboy seems to be living out some kind of movie fantasy in his head about his life and how important he is. The other thing I want to talk about was Julie poisoning herself to make it look like she was being poisoned. Maybe, and because it turns out it was half a teaspoon that were in the contents of her stomach. All the information was there on the computer about the effects of antifreeze and ethylene glycol and what it does in the body, and how, after 10 hours, after 4 hours, she would feel intoxicated. After 10 hours, it would start to slow down the kidneys. After 18 to 24 hours, there will be crystals in the kidneys, whatever it was. I don't remember exactly. But she would have had to have it in the bedroom by her. I know you think that she could get up and go into the garage. I don't think so. But I think that maybe she had a small supply there. Or maybe it was in the bathroom, or maybe it was in the kitchen, wherever it was. Maybe Mark caught it, and then he said, "Oh, you want to die? Or you know what? She's halfway there. Let me finish her off." I mean, whatever it was, he knew she was actively dying. He fucking did nothing. He didn't call 911. His children were pleading with them. So whatever happened there, I think maybe there's a possibility he caught her, cleaned up the mess. You know what I mean? Maybe he just cleaned up the mess and said, "Yes, now I get to be with my girlfriend because dipshit over here just fucking killed herself." You know?
Yeah.
And who knows? But we won't know. If he was preparing the drinks in the kitchen and bringing it back to her, well, Jesus Christ, where were the fucking fingerprints and the stuff? It would be on the cup that they didn't fucking test. And they also didn't want to, mess up the house too much by taking the kitchen drain out. They took the bathroom drain out and the shower drain out. I think the kitchen drain might be a little bit more important than the shower drain, Sherlock,
Yeah. Boss and I were talking about this last night because I said we were up till, I'm up all night doing these video edits, and then Boss calls me, and him and I are up till 2 a.m. talking. And we were talking about the police stuff with the not testing the cups, not testing, the bowl,
the kitchen drain,
testing
kitchen
the drains. Right. And that's
where the medication was. Why wouldn't you think that's where the drinks are? That's where the water is. That's where he's preparing food. Why would you not think to take the kitchen drain? It blows my mind.
Right. There's too much. And then like we even mentioned too, where it's like you're in the house for a couple of hours doing your crime scene investigation. And I think he said after 3 or 4 hours, whatever, they're done. And they call him and said, "Okay, hey, the house is released to you." Boss and I, you guys should have heard our conversation. We were losing our minds last night at 2 o'clock in the morning going, how in the fuck are you releasing a crime scene after 3 or 4 hours and you let the, person come back to the house? How much evidence, if he did it, right? If he did it, how much evidence did this guy get rid of now at this point? You know what I mean? He probably may have came in the house and been like, "Ooh, gold mine. They didn't take this. They didn't take that. They didn't take this." And he's just destroying everything now. If he did it, I don't think he did.
And a side note, how much action was their bed getting?
Find your relief from back pain, neck pain, migraines, and more at The Joint Chiropractic.
Stuck in a never-ending renovation? That's
She was with Mark in that bed. She was with Perry Tarika in that bed. Then he was with his own wife in that bed. She died in the bed. And then he had Kelly in the bed. How fucking creepy are these people?
Yeah,
like all these crazy rich yuppies back in the day were just all doing each other and lying and going on business trips and fucking around and scheming. It's like Falcon Crest or Dynasty bullshit from back then.
Yeah.
All I see is shoulder pads, cocaine, and sex. What the fuck?
And you know what? I mean, that's the stockbroker, kind of thing, right? I mean, if we think back to the Charlie Sheen and Michael Douglas movie,
yeah.
You know what I mean? Like that's
JK's like, since when did they give a shit about destroying people's property in a rape?
Right. It's law enforcement. You know what I mean? So yeah, I think
indoors for no reason.
I think knowing Mark is in this business, so he's definitely, he's a deviant, right? Like even think about the Wolf of Wall Street, right? Leonardo DiCaprio, and then the real story of Wolf of Wall Street. I mean, that guy's done a lot of interviews and said like what a crazy time this was.
Yeah.
And what gets me though, and this is where and there's been several things that got me. Once I heard about her schooling and those specific classes, which is something else. I need to clip that too. I'm so far behind on videos.
I didn't see that. I took you at your word because I know you're not a big fat liar like Jamboy, but
well, thank you.
yeah. Yeah, that's pretty wild. But I mean, I'm telling you, 5 days ago, had you said to me, do you think there's any chance Julie could have attempted to make it look like she was killing herself? And I was like, hell no. Why would she risk leaving her kids? But if she was smart enough to Gone Girl all this stuff, she was smart enough to think that she could get away with that too.
Yeah. And that's why Boss and I were talking. I was like, bro, if you follow the timeline, like you really got to listen to these dates of when weird shit starts happening. And like you said, going to specific neighbors, not giving shit to other neighbors that know her better. Right. And
who were her girls. Yeah. Because those were her girls. Those are the ones that she day drank with and watched kids in the pool and went to birthday parties with. If you're a mom and you've raised kids, you know who your girls are.
Right.
So if she's not trusting her girls with this stuff, I mean, I have 5 girls right now. I could call them and say, hey, wear black, pick me up. They would ask no questions. I wouldn't go to some fucking people next door that just say hi and wave to and say, here's a letter, here's a bunch of rolls of film, and I'm calling the police and da-da-da-da. These people have so much trauma or an emotional mess because of what she did to them. You could see even the poor lady's dead now, but even when she said, oh, I came home and my husband and my youngest daughter were crying on the couch and he said, see, you told me to stay out of it. Now she's dead. Oh my God, that was heartbreaking. I got chills.
Right.
She really roped these people in. And I think, honestly, I mean, I don't want to, I think it was because they were foreign and they have a different kind of standard and morality. So she wanted to go with the most upright people that she knew that she thinks that she could, sell her story to.
She
did.
That's a great point, Denise. That's a great point that she went to them and possibly because they're foreign. Yeah, it got me with the specific classes. When they read the names of the classes, I went, Jesus Christ, dude. Like, this is all about toxicology. This is all about chemical effects of the body. This is all about death, composition of the body. I'm going there. She did, like, she Gone Girl
a lot. I couldn't believe it.
Right.
I really couldn't believe it.
This was plotted for a long time.
Didn't factor in him going to the doctor and getting the Ambien and him giving her 3 within, and he may have done that very innocently because she was up sick all night and just wanted her to sleep because either he felt bad for her or he was just annoyed as fuck with her acting like an asshole and he wanted to get to sleep.
And you know what? Right. And that could be too, because I've said several times, like, he may have been legitimately concerned because everyone's like, why didn't he take her to the doctor? And I keep telling people, well, he did 6 days earlier. So, even in, DV situations, there are still moments of, because the cycle of abuse, you have the what is it called,
Right,
the,
but
marriage period or whatever.
Right. Even if you have had DV in your life, in your marriage, if you're an offender or a victim, whatever it is that you do, even being a total douchebag does not make you a killer.
Right. Right. Yeah. So you might be right that because she, apparently she's, fucking drunk monkey midget on acid hanging from the fucking ceiling fan, right?
Mm-hmm.
And then he's like, oh, this is nuts. And he may have legitimately looked up the Paxil going, oh my God, this might be the Paxil. And like you said, he goes, we know that he went, the Borman gives him the Ambien, and he may have innocently given her the Ambien, and then that also really kind of set some things into motion. So that's that. When they drilled the computer kid, or was it the computer kid? So it was not him. It was somebody. It was the one witness that testified that she got her Series 7 license. The minute they said Series 7,
I know
what that is.
Perry Tariqa.
That was Tariq. Okay. So I didn't like that guy. That dude skeeved me out too. But the minute he said she was getting her Series 7, I already know what that is. I went, this fucking bitch, bro. No, and like Boss and I are joking on the phone, like, hey, we're gonna start typing free Mark in the chat, And when he said that, I was like, oh my God. So and I immediately put 2 and 2 together with the searching for the corn stuff. We got to say corn, searching for corn, searching, and then what got me too is, why is Mark searching the Stifel directory for the name Kelly? And I'm so glad the defense pointed that out, because I was losing my shit about that last night. And I'm glad they said that, because we said that, I think, in the recap.
Hold on 1 second.
Too.
JK, Paxil is not a fast-acting drug. It is an SSRI, and it does build up in your system over time. But you don't know the effects of it you can't mix it with alcohol, and ethylene glycol is an alcohol.
Yeah, so that may have been, and I think she had some other shit in her too. So she's kind of, all these things are coming.
And you know what? These things affect everyone differently. Like, some people take NyQuil and, they pass out right away. NyQuil gives me heart jitters. It makes my heart race and I can't sleep all night.
Yeah.
So everything affects people differently. So
my body,
kind of like the stuff that he's saying makes sense. But when you see somebody who's dying, it's a distinct thing. You know what I mean? The rattled breathing and all that stuff. He knew she was dying. I think he was being an opportunist.
I think that's the case too. But yeah, so when you look at the computer,
trying to catch me riding 30. The 30-day money back guarantee, only from CarMax.
Exactly what the defense said, and I said this yesterday. I said she's looking up emails. She's logging in at 1 o'clock in the morning, 12:30 in the morning, to an email that was sent at 3:52 p.m. And the defense said it today. And then she's looking at the email. Follow the email. She looks at the email, then goes on to Stifel's staff directory and types in various Kellys, and then what branches they're in.
Right.
Why Mark's not doing that?
Right.
And then
that was one of the things too that I was like, oh shit, it's coming. Yeah. It's coming together, folks. Yeah.
And then there's right after that, then there's logs for stockbroker shit, right? And that paints to the jury that this is Mark because he's the stockbroker. And then the Series 7 shit comes out, and I go, this motherfucker was a stockbroker too. So it's her. You know what I mean?
Yeah.
So yeah, there's a lot of that stuff.
But as hard as I'm trying, it's hard to tune out the stuff that we know from 2008. It's hard to tune out the stuff that, all the dirty shit that got, that the judge didn't let in with Jamboy, all that stuff. It's hard not to let it color your opinion of what's going on. I just hope the jury sees it. And like I keep saying over and over again, I think what they're going to do is they're going to offer him a lesser if they're smart. If they're not smart, then they're going to fuck themselves, and he's going to wind up with a really great lawsuit and all kinds of book deals and movie deals and everything else. Is they're going to offer him a lesser included charge of negligent homicide, and he's going to get time served, and he's going to walk out of that courthouse. And like DeBoss and I keep saying, Kelly's going to put her paperwork in because those two were making eyes at each other. It's going to be on. He's going to be back with Kelly by Valentine's.
Yeah, I think if they were smart, they would come up with some type of plea. Because I do believe that, you know, and I said this, where something set her in this panic, desperation mode, where I think, you know, she either took too many pills, she took too much of the antifreeze, she's combining everything now. Because 3 days before, we know ahead of time, before anybody else right now, that she went to her doctor, and the doctor said, this chick's acting like a fucking nut job. So I think that he probably did say, like, that's it, we're done. Something had to have happened, right? It has to. That put her in that desperation.
That goes to that email when him and Kelly about him getting his ticket punched with her, and then she said, "Oh, that I think that meant that, you know, he spoke to her about wanting a divorce, and that they were going to work towards that."
And right, and that's what that email probably is talking about. And then you know, I think you're right, and I've said this, where I think he was very opportunistic, and he was just like, you know what, fuck it, die, bitch. Like, that's it. Like, I don't care anymore.
Somebody also said in the chat, I don't know if it was Darlene today that said in the chat about the life insurance, that the 50,000 and the 50,000, maybe she intended, you know, just in case, I want to make sure my boys are taken care of, you know, because you couldn't collect if you're a murderer, but it could still go to the kids.
Right. And so there were 2 different years. It was 92. So this is after the affair that she had, because she had the affair in like 91. Right. Now, remember, she does the divorce, and she cancels the divorce. So I think it was sometime very shortly after the divorce that she went full fucking Gone Girl mode. And she started plotting and scheming then. You know what I mean?
And then the other policy was added in 95, I believe they said. So
right.
And then she was getting real in 95. Yeah.
Yep.
So,
exactly.
You know, I think a good 5 years, maybe, she was really, her wheels were spinning, you know?
Yeah, 100%. Yeah, this is gonna be interesting. We still have a long trial to go. But I'll ask you 2 final questions, and then I'll let you go. Where do you sit now? Are you undecided? Are you he's not guilty? If you were on the jury and had to make a decision today,
I don't think they could. I don't think at this point, with the level of doubt that the defense has already been able to bring forth for the jury. I mean, you got to think about how little the jury's been in the courtroom. They've been in there a lot today, but they've just been taken out. Even the judge was getting annoyed by it. So the level of doubt that they have been able to bring up so far and just annihilate every single witness just about, right? Their case hasn't even started yet. I can't even imagine who they have coming. And Jamboy said, you know, he's got like another week maybe. When did he say that? Yesterday or the day before?
Yeah.
You know, like I said, I have COVID brain right now, so you have to excuse me. So I don't know what that means for him. So if he said it yesterday, today's Thursday, maybe next Wednesday they plan on finishing their case in chief. Once the defense starts going, I can't wait to. I can't wait to see who their witnesses and stuff are. But I think at this point, my prediction would be is that if it keeps going the way it's going, he will either be fully acquitted, depending on what their case in chief is. But as of right now, I would say that it's going to be a lesser charge of negligent homicide because he didn't call 911, which she was clearly dying.
Right. 100%.
You know, there's no mistake that she was clearly dying. The kid did the impression to his friends. Other people did the impression.
And Mark even said it himself in the interrogation that he watched her die. So
yeah, he did. I was going to say he did. I think he did it in front of Rathburg. right?
Yeah,
Ratsberger?
when Ratsberger was doing the 99 interrogation, he's like,
Right.
Mark, you sat there, and Mark says, yeah, I sat there, I did nothing, I probably should have.
Yeah.
So
So
that's by his
they
own
may have
admission.
him there. Yeah.
Yeah. All right. So last question, and then you get to do something fun after this. So last question is so you're new. All right, chat. That was that. That was recorded on Friday. So we're going to have that viewer come back on the platform every Friday and kind of do a case breakdown, which will be good because I've not listened to anything about this trial today at all. So let's address a few things. First, we need to address this. It's been a little, issues on YouTube again this morning. So let's be clear so everybody knows. And on Facebook, listen up as well. We are just putting out theories on this case. I'm an investigative journalist, so I find all of the corruptions. I find the inconsistencies, right? And we do actual investigative articles, and we expose corruptions in the systems and courts and district attorneys' offices, police departments, right? Because we want the bad people in those systems to go away so that the good people in the systems can do their jobs the right way, right? Make everything fair. Good police officers can really do their job. And sometimes with the bad police, and this is why we expose this, and we highlighted this a lot with Wauwatosa Police Department out here in Wisconsin, is that there were good police in Wauwatosa that were trying to step up and report sexual harassment against the female officers. And those female officers were getting bullied by the men. And when they're on these like very high felony traffic stops, these very dangerous traffic stops, their male counterparts are either not showing up when they call for backup, or they're sitting like blocks down the street just watching, right? And there was a Wauwatosa female police officer that was killed by her husband. And we did a whole thing on this. We investigated the whole thing, and we exposed what really happened behind that, right? So, it's things like that, right? And then you have good police officers that are getting fired. They're losing their pensions, right? So that's what we do. So in the Jensen trial, that's why I'm pointing out all of this stuff, okay? So I'm not defending Mark. I don't know if he's guilty or not. I have no idea, right? But I'm pointing out all the things that are pointing to Julie. A lot of stuff that was missed in 2008. And I think in 2008, they were so focused on Julie intentionally doing this to intentionally unaliving herself, which I think is where Craig Albee got it wrong, okay? And that's why we keep saying she Gone Girled herself. We're referencing a movie with Ben Affleck, Gone Girl, right? Where she planned all this and blah, 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 blah. So some of our chat has come up with kind of like alternate versions to our theories and added some details that have kind of helped clarify some things. So the point is I welcome all the theories, right? And that's the point of what we're doing here, guys, we're trying to solve the case. We're not on the jury. We're just watching. We're like flies on a wall, right? And let's get the theories. Let's have fun about the theories, though, okay? What we won't tolerate on the platform are personal attacks and negativity, right? Now, I haven't banned anybody today, but that's what we do. We ban people for that. So when I start a stream this morning, and before I even say hi to anybody, I'm getting personally attacked on one of the platforms, I'm not going to tolerate it. And when chat comes in and they've missed all of that, and then they also want to be douchebags and start screaming at me that I'm yelling at people about theories, I'm kind of just done engaging with everybody because I've got other stuff I have to do as well. I've got my real aspect of what we do here on Never Stop, which is write investigative articles. That's what we really do, right? So I've gotten attacked by a lot of people today because I am kind of getting a little pissy. And that's why I haven't talked much today. I've not even listened to anything on the trial because I'm dealing with something big, okay? Now, to clarify that for you guys. So in 2020, I was one of the live streamers, and this is why I get put in this live streamer category. I was one of the people that was out live streaming Protest World. Okay. Now you can imagine the controversy that surrounds me on Protest World and the accusations that have been thrown around. Okay. I was just a guy that was out there documenting and trying to tell people the truth. And I got attacked for it. Law enforcement has used my live streams to not arrest criminals that were like doing riotous activity. They used my live streams to identify people that weren't engaged in illegal activity and then fabricate criminal charges against them. And that's not why we're out here doing this stuff. We're out here trying to document so you guys can see what's actually happening so that the misinformation and disinformation that goes around can stop. And yesterday, while we were streaming, okay, about an hour before the trial ended, I got sent something, and a police department intentionally singled me out in a criminal complaint and my company as if we're a confidential informant for the police department. So you can imagine how upset I am. Okay, and that's big. That puts my life in danger. Literally puts my life in danger. Okay, it also kind of discredits a lot of things that we've done in the past. There's a lot. And it also ruins the integrity of myself and my company when it comes to confidential sources, whether that's, you know, just say a protester, or we'll say a militia member. But there's times we have district attorneys, and there's times we have police officers that come and hand us documents, and they're confidential sources. And it ruins our credibility with that. And the protection, the high protection of those sources. I'm willing to go to jail to protect those sources. So when a law enforcement department does that to me and my company, and specifically names me, and they have other ways that they were able to obtain different things, but they intentionally put me out there, it's to put my life in danger. It's retaliatory for things we've done to the police department. Okay. So I'm just forewarning you guys, I'm a little pissy, and none of that has to do with you guys. And if, you know, some of that, obviously I'm kind of taking out a little bit, and I apologize for that, but I'm a little upset. And I put out a press release on the Facebook page. I'm going to read it to you guys now because I wanted at some point to publicly address this anyway, but you guys can go and read this, share it around. I don't care what you do with it. Okay. So this is what I wrote in my press release. And mind you, I'm a big Punisher fan, so I use a lot of Punisher quotes in this, right? So we talk about like corruption will be punished. You know, it's just my silly thing, whatever. So the post says, corruption will be exposed and punished. Those who do evil to others, you will come to know me well. I have work to do. Read your newspaper every day and you'll understand. Si vis pacem para bellum, which stands for, if you want peace, prepare for war. Never Stop Media's mission is to bring the uncensored and raw truth to the people, to tell the stories that mainstream media glosses over or completely ignores, to bring to light and expose corruption in real stories through investigative journalism. If every other news organization wants to be stenographers for law enforcement, let them. NSM doesn't write for corrupt agencies who violate people's rights on a daily basis. NSM writes for people whose rights were violated. So when law enforcement says something, we only have one question. Is it true? Right? And basically what we do here is to prove or disprove something. And we've defended police departments when they're, you know, getting attacked and they didn't actually do something wrong. We've actually defended them. Independent media refers to any form of media, that is free of influence by government or corporate interests. That's why I tell you guys all the time, we don't make money doing this, right? There's no money in this. That's why we rely on you guys for donations, right? Never Stop Media, LLC, practices journalism that is completely free of influence. At no time will any government entity, privatized group, or individual control the narrative of any coverage that Never Stop Media puts out. During our live coverage, we document events to their exactness. In some scenarios, we are legally not allowed to speak on a situation as we may be called to testify. So I sometimes, when you guys ask me questions about Kenosha, there are still lawsuits in the background and I can't answer certain things. What needs to be understood and is generally misunderstood and perceived as bias or narrative control by the general public is that independent journalists / press are not law enforcement and therefore use judgment in each situation during filming. We need to be hyper alert of our surroundings and any and all safety risks while filming. Law enforcement agencies have been using live streams to identify and target not only criminals, but also those who are engaged in lawful and constitutionally protected activities. And I don't care what side you're on. You could be a right wing, you could be a left wing. If you're out there engaging in constitutional stuff, law enforcement is still trying to identify you from our live streams. And this is why I put the press release out that we're no longer live streaming outdoor public protests and events, and we're not doing it anymore. I'm done. I'm still filming, but I'm not live streaming. Citizens have used these live streams to dox another individual by revealing not only public information about an individual, but also their personal and private information. We are not out there to intentionally jeopardize anyone's safety, and we are not law enforcement there to capture and expose criminal actions or to help law enforcement identify individuals to violate their rights later. Our sole purpose is to document the truth of the events that are happening, whether on camera or off. Our interaction with law enforcement is always respectful and always will be. But NSM will not allow our coverage of events to be used to target individuals and fabricate criminal charges against them. NSM deeply apologizes to individuals whose rights were violated and had fabricated criminal charges brought against them due to any live event that we covered. Falsified charges brought upon an individual exercising in a constitutional protected activity is absolutely disgusting and unacceptable. Those charged with crimes for protecting the lives of those around them against great bodily harm and death is a gross negligence by law enforcement while ignoring the real criminal who actually endangered the lives of dozens of individuals. And for a law enforcement agency to publicly single out and name a media outlet in a criminal complaint presents an inference that the media outlet was an informant, which is not only inaccurate, inflammatory, reckless, dangerous, and in its purest form, nothing but retaliation for exposing decades worth of lies, corruption, cover-up, criminal activity, murder, conspiracy, sexual harassment, racism, and worst of all, endangering the lives of Wauwatosa community members and Wauwatosa officers who also have tried to expose corruption within the Wauwatosa Police Department. Now, I can't go into further detail, but I think you guys can kind of gather what I'm talking about there. Okay? And because we do investigatory articles, and I've tagged Wauwatosa PD in this. If you go on here and read this, I've also put probably about 50 different links because this is all the work that not only we're missing a few links, but it's the majority of the work that myself, Never Stop Media, Isaiah Holmes with the Wisconsin Examiner, and Kimberly Motley, a civil rights attorney, has done to expose decades of criminal activity with this police department. So this is a retaliatory thing that they've done. And it's because I'm a little guy. They don't view me as being able to protect ourselves. And sometimes when we kind of tell you guys some things, right, we get attacked a lot. I've spent thousands of dollars defending this company. People try to misquote me. They put allegations on us, and they've never won. Because we protect ourselves, and we're always accurate, and we tell the truth. And if I make a mistake, I'm very quick to tell everybody, guys, I made a mistake. This is what it was. I am so sorry, whatever. And that comes very, very few and far between that actually happens. So now I have a police department that has started a war now. And this happens. Kenosha Police Department has done it to us in the past. And we went after them. And they lost. Now I got another one. So yeah, I'm in a little bit of a bad mood. And now my attention to this trial has stopped because I need to now protect my company again. I need to now protect our integrity and our credibility. We need to make sure that individuals and groups that are referencing in this don't start looking at us sideways, because we had to do a lot to gain trust. So this investigation now is kind of taking precedence over a lot of other things that we're doing. That's that. The other thing on Facebook, some of you are losing your minds over your comments are not showing up. I've said this before. We lost our original Facebook page. Okay? And that is due to a lot of attacks that came at us. Right? And then Facebook's nonsense and whatever. And we, based on, let me just say this in a legal way, based on information and belief, through investigatory resources and things that we've conducted here at Never Stop Media, we're not entirely confident that Facebook took our page. You guys have heard about the Fusion Center in the Jensen case with Jason Ruff that testified, the computer expert. The Fusion Center is right down the street from my house. And we know for a fact that the Fusion Center monitors everything that we do, particularly what I do. So they might be behind us losing our page. Now, if that's accurate, we can't control any of our platforms going down. But due to comments, allegations, false articles that are written about me, all types of things, people coming in and attacking, trolls that are messing up, all the fun stuff that we try to do here. Both platforms are so heavily protected, basically against you. So depending on a word that you type, a phrase that you type, a topic that you're talking about, cuss words, your comment gets blocked. I get notifications that I have to go through on a daily basis, and I have to sift through your hundreds of comments and either approve them, ignore them, delete them, ban people. Okay? If you're on Facebook and you don't have a profile picture, you don't get to comment. If you just created a Facebook page and you have no friends, because then I get it, some of you are, you're worried about your real identities because of the things that we talked about, crazy people. You don't get to comment. We do that because we have people that build fake pages to intentionally attack us, creating aliases, all types of things. So that's why. So if you fall into that, any of those categories that I just mentioned on Facebook, that's why your comments are gone. Okay? And I have to sift through these every day to try to approve the comment. It's the same thing on YouTube. I have to go through those. Certain comments get held for my review. Other comments are just immediately blocked. And I have to go through all of those comments. And you'll see on some of our videos, I've had to disable comments. We just released video footage of Ohio police officers beating the shit out of a black female. I've had to disable the comments on those videos. And you can imagine the amount of hateful, disgusting things that have been said to make me disable comments completely. So that's why, Layla, no, it's not Facebook. It's me using caution to protect my platforms. Because we've also had people that have come in the past and they put just very derogatory things or certain things that they know Facebook is going to block, right? And I've lost a lot of content. So somebody will intentionally write something and then report my page. And then we get messed up for violating community standards. And my mods, even though they're great and they're fast, sometime in the past, we've had videos that we've had, and this is why it makes me crazy. We have 30 people sitting here listening to me talk. We've had videos where we've had, 3,000 people in a chat, and that video is getting 100,000 views later, and we can't keep up with the comments, right? On YouTube, NSM security, like they're running around deleting and screenshotting. We have an entire file of thousands of death threats that we've had to turn over to the FBI. And we can't keep up with this stuff sometimes. And then people go, they intentionally do this. For those of you that weren't, we did the stream, I think it was Friday, or no, it was, when was it, boss? Was it Saturday? We did, I think it was Saturday, kind of late morning. I wanted to come on, and I'm paying attention to the trial, guys. I am watching for them to come back. They're not back. But Saturday, we tried to do another marathon stream of the 2008 footage, so because we wanted to give you guys some background. We did the stream, and then the last hour and 20 minutes, it shifted focus from the trial, and then we all just kind of started talking. And I was like, hey, this stream is about to get messed up now because we're all just fooling around. So I ended the stream, and we restarted another one. During that stream, and if you weren't here, you don't know this, and that video is private now. During that stream, I almost died that night, legitimately. There was a situation outside of my house, and I went down there to confront it and see what was happening. And I had a gun pulled on me. Okay? And I had to very quickly de-escalate it. So we were joking around that Kevin from Never Stop Media almost permanently got stopped. I almost got shot. I came very close to being shot over something that had nothing to do with me. So I am a little on edge about that, and I'm sorry if I get a little attitude and whatever. I have complex PTSD, and that twacked me out. So I'm still, I'm fine, I'm safe, I'm good, but it kind of messed me up a little bit. Okay? That was a pretty spooky situation. Then later, we had people that have actually stalked me. We have videos of all of this up there. People that have actually stalked me, and militia members armed to the gills with high-powered rifles that showed up to addresses, hotels that I was staying in. They came into my chat. And one of them likes to come into chat using my son's name. And he likes to talk about how he crawls in bed with my son every night and does goofy, weird things that I don't want to mention. Okay, so this is why we protect our platform, because of all of these things. So when I have all this stuff happen to me all during the weekend, and this is a common occurrence, folks, for those of you that are new, this happens every day. It just used to be thousands of things that I had to deal with a day. Now it's one or two, but it still comes. The death threats still come. That's why nobody knows my address. Other addresses that are associated with me are sealed in the courts. Anytime we have to go to court, we give, I'm not going to say all that, but my address is heavily protected. Nobody knows where I live. There's a reason for that. So when I deal with this shit on a daily basis and all this stuff comes up and I almost died, right, or came close to it, I could have. Let's just say it that way. I could have, because I don't want to sound dramatic. I could have. Okay? And then I started a stream this morning. Now, mind you, I got an hour and a half of sleep because I'm dealing with this Wauwatosa stuff, right? And I'm editing videos for you guys to try to get out there and trying to build a new YouTube channel so we can get the protest world shit that a bunch of you don't even care about anymore. And I get it. That's great. That's cool. And we don't want to contaminate you with that stuff if you don't care. So we're trying to build another platform just for trials only, right? But when I deal with that, and before I literally just started the stream, and before I even said hi to anybody, hey everyone, welcome to the stream, and blah 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 blah, right? The usual shitty, stupid spiel in the fake reporter voice. I'm immediately getting attacked about what a piece of shit I am. I don't need that. I don't need that. You know, I thought we were building a really, really cool, fun community on Facebook and YouTube. It's great. Everyone that's been here has been just amazing people, right? Some of you have donated, which is awesome. You have no idea. Like, that makes me emotional when people donate. You have no idea how much we appreciate those things, and sharing the videos out and the little things that you guys do if you can't help financially, right? And some of you try so hard to just really help us. And I thought we were building a just really awesome community here. And for the first time, even my moderators will tell you, ask any of them, this has just been awesome so far with this trial. It's been awesome. And now we're starting to have some bullshit. So my mods are losing their minds because they're having to protect stuff. They're ignoring their families, their kids, their jobs, trying to protect my platform that they don't even get paid to do. They don't get paid for it. But they're so invested because they've been with me for 3 years. You know what I mean? They're ignoring their own lives to protect me. So we don't want nonsense, guys. We don't. We really want to just have this cool, killer little community, you know? And like yesterday, we were talking about if the state rests today, I want to have you guys, I can send you the link and have you come onto the stream, and we can kind of do this separate little thing called the jury room, and we can all sit and deliberate. And again, there's going to be rules for that too. But we have our own little pretend jury for all the stuff that we've heard. And some of you are missing stuff because you have your lives to deal with and you can't watch every waking second of the trial. But you're going to have that too in a real trial. You're going to miss stuff. So I want to get people in here. I don't know how many we can fit in the thing. I don't know how many we can invite on, but I want to have our own little jury and do that when the state rests, and then do it again when the defense rests while the jury's actually, you know, deliberating. But if the whole chat is being, you know, contaminated by drama and silliness and attacks, unfortunately, then we can't do fun stuff like that. And then all of this loses the fun and excitement for me too, because it takes away from what I actually do. And when I'm streaming a trial, it takes away from me working a day job, and I'm ignoring all of my responsibilities. And I kind of snapped on YouTube today because, you know, we've been here for 2 weeks. I've made $60 doing this entire thing for 2 weeks instead of the $3,000 a month that I make working. So I'm losing stuff, right? My cell phone is being shut off tonight. The website we're about to lose. I'm about to lose the company insurance. And when Kevin loses the company insurance, Kevin doesn't post anything because we have no protection then, right? And I don't want you guys to think I'm saying this because I want a pity party or poor Kevin, and what. It's not anything to do with that, right? I love doing this type of stuff, but I just want to build a cool little awesome community together. But if we can't do that, then I'm not interested in continuing on with this, and I'm just going to go back to investigating dirty law enforcement and then get the hate for doing that, right? And then I'm going to go back to work, save money. I'm going to go on my hiking trips, and we're not going to have fun. You guys can go have fun on Law and Order and Court TV that doesn't even talk to you. And send your super chats and your donations to fucking corporate entities instead of helping out, you know, little people like me and Mercado Media and whatever other independents that you watch and little channels that you watch. So let's just have fun, guys. All right. Let's have fun. Let's build a cool little community. And I welcome all the theories on these cases. And if we do future cases, I want all the theories, the conspiracy theories. What do we think about this? Right? This is one of the first times that we've been able, because of what we used to cover in the past, that we've been able to have right-wing leaning people and left-wing leaning people in the same goddamn room and not argue with each other and want to kill each other. Some of my viewers don't like that. I don't give a shit. I don't care anymore. I'm done with it. We got enough bullshit problems in the world and with our own personal lives. I don't want to argue about that. Right? When we talk about politics and protest world, we'll do a stream and then the box of crazy can come out. But when we're not talking about those things, I don't need people pissed off that I have right-leaning people in here. I have right-leaning friends. I talk to militia members. You know, people have known this for years. So it is what it is. I also wasn't even on the pro-movement side, right? I was on the other side. So, you know, whatever. We don't need any of that today. Not during trial coverage, right? And a lot of you have been able to put those differences aside because we're not talking about that. And we're talking about cases, trials. Is he guilty? Is he not? So some people aren't even thinking about it, but others are. And we're just not going to tolerate it. And my mods are not going to tolerate it. They want to shut shit down sometimes faster than me. Sometimes I kind of let some things go, and my mods are not having it. Okay. So that's that. There's my lecture and my rant for the day. So if I'm not chatty today, if you don't really see me and I'm not first off, I'm not going to break down the case today because I missed everything. I missed 4 hours of testimony. I have no idea what even happened. I can't even talk to you about it. And now I'm fucked for the case because I don't even have time to go back and watch 4 hours. I don't now. So I don't even know how I'm going to break this case down for you the rest of the trial because I missed it because of bullshit on my platform. Are you investigating Tyree Nichols police out of Memphis? No. So the problem with this is that we're not this big corporate entity, so we can't investigate all these different things. We don't have the budget for it. And even the 5 investigations that I'm working on now, it's too much. I've spent thousands and thousands and thousands of dollars just on the articles that I've written. And that's why we ask you guys for donations, right? And a lot of that, and I've said this, a lot of that is to pay for open records requests, and it helps us be able to investigate more things, right? Right now, we need money to get another 4 terabyte hard drive. I can't afford it. So we do ask you guys if you want to donate for that. And I tell you if it's equipment. Sometimes I'll be like, dude, guys, I'm really fucked right now because I haven't worked, whatever. Who wants to buy me a pack of smokes? I tell you guys that too, right? I'm very open. I told you guys I'm very open about money because I don't want weird accusations about money. So unfortunately, the problem is that there's a lot of things I want to investigate. We just can't afford it. And even now going after this police department where we may have to sue them and hire, our legal counsel, because the legal counsel is not just sitting there and they're like, yeah, we defend you on everything. We have to pay for that, right? We had another media outlet attack us, and I spent 5 months in court defending, my company, right? And then these people were fabricating evidence and tampering with evidence, trying to actually have me arrested for criminal charges. I spent 5 months and thousands of dollars defending that, and we won. So, no, I'm not, and I can't investigate everything. I'd love to because there's a lot I want. Bobby Boy in this trial, I want to open up a massive investigation on him because he is corrupt. And I think a lot of these other people in this trial are, and I believe it's because of Bob. That's my personal belief. That's my theory. And I want to investigate to prove or disprove that theory. But I don't even have the funds for that. You know what I mean? So that's that. They're still not back in court. I haven't seen movement yet. There's a lot. I mean, the TikTok story that we put out, that wasn't even a planned thing. You know what I mean? Something seemed off about it. We didn't believe it at first, but something seemed off. And the more we investigated, now we're exposed. And this is again out here in Wisconsin, but I mean, we wrote 3 articles. Check them out on the website. They should go viral. You guys are going to lose your minds about it if you haven't read it. This is about a girl that a 25-year-old man had sexual intercourse with a child. So, and the DA lied to the judge, and it got the case dismissed. And this guy's running around terrorizing and doing all kind of stuff. So, and I'm glad that something felt off to me about what we heard in this story, because it did cause me to investigate it. And I've spent countless hours on this, and we're still not done. And we've already exposed basically what I told you. And now we have a family court judge who's also trying to fuck this girl. And they're basically re-victimizing her and protecting the offender. And we have reason to believe, we already know that the doctor, because they ended up having kids together, but the doctor should have reported it because they're mandated by law. And he didn't, because the doctor was a family friend of the guy. And he told the nurse, you're also not reporting this. So we found that out. So there's a lot of things, but that's countless hours. That's time. That's money. And we're the only news outlet that's reporting this. Corporate media is not. So that's why I said we report on things that mainstream media glosses over or ignores. Right. And I think, because I got a phone call, I think we found her a civil rights lawyer. All right. They're coming back in court. But, you know, that's the thing, is we just can't unfortunately investigate everything. And some of our investigations that take 3 months anyway, because of how deep we go, are taking 2 years. So, you know, when we put the links up for the GoFundMe, Cash App, whatever, that's why, guys. That's why. It's not so I can go eat steak dinners. You know what I'm saying? There's nothing to do with that. So, so yes, I apologize if I sound a little pissy this morning and cranky. I'm dealing with a lot, and I have no sleep right now. Let's just have fun, chat. I really want to. Let's build the community up. Let's get some cool ass people in here. Let's all have a good time. If you're offended by anything I just said, it's probably because you're the fucking problem, and you should probably just move along and go somewhere else. If you're not offended, then it probably means that you have nothing to do with anything that I'm talking about, and you're just cool people. So we're abrasive here. We use naughty words. I'm crass. As long as the streets are abrasive,
We're
I'm
back
going
on the
to
record on Mark D.
as long as you're
Jensen,
respectful to me and my
2002
platform, I'm going to treat you with the
Appearances are
utmost
the
respect.
same. Dr.
Here we
Malin
go,
is still on the
lovelies. Back to the
stand. We'll
case.
continue with the cross-examination anytime you're ready, Attorney Perry.
Thank you, Your Honor. Dr. Mainland, ethylene glycol is a non-volatile substance, correct?
It's, I think it's lowly volatile.
Lowly?
It's relatively non-volatile.
And what that
Yeah.
means is that it doesn't evaporate easily, right?
Right.
Does it mean anything other than that?
Not to me.
Okay, not to me either. You talked about the phases. You talked about the phases of ethylene glycol poisoning on direct, and there. The theory is that there are 3 of them, right?
Yes.
And now this 3-stage theory has existed for a long time.
Yes.
A limitation in understanding the phases of ethylene glycol poisoning is the reliability of information about somebody who's been poisoned by ethylene glycol. Would you agree with that?
Yes.
When somebody shows up at a hospital and they've ingested ethylene glycol, they might not be the most reliable source for exactly when, how much, all of the factors, correct?
That's correct.
Okay.
They may not.
And through kind of all the literature, that limitation is present, isn't it?
Not all of it. There are some accurate reports, but I would say in general, yes.
To extrapolate in terms of how everybody would process ethylene glycol, it's a limitation.
And I'm not quite sure. Well, I'm not quite sure what you mean.
Well,
I
I think today you said every individual is different.
Yes.
And I guess what I'm getting at is issues with metabolization.
Okay.
Okay. and then how these different phases might manifest in any particular person.
Okay.
Do you agree with that?
Yes.
That it's not a, I guess, a strict recipe in terms of what happens when any one person ingests ethylene glycol.
Okay, that, correct,
Okay.
correct.
And I think a quote that is present in the literature and has been for a long time is that metabolism of ethylene glycol has not been thoroughly investigated in man.
That's correct.
And it hasn't been because it's poisonous.
That's correct.
Okay. And aside from you drinking ethylene glycol on the stand, most people don't do that.
I didn't swallow it.
Okay. There are these three phases, right? That's the theoretical three phases.
Right.
Okay. Stage one is thought to begin, pretty big range, anywhere from 30 minutes to 12 hours after ingestion.
Yes.
That's the intoxication phase.
Yes.
Stage two, thought to begin 12 to 24 hours after ingestion.
Yes.
Cardiorespiratory phase.
Correct.
Now, the reason there's a cardiorespiratory phase is that goes back to that sort of acid base level that the human body needs to be at, right?
Yes.
Okay. And so if a healthy individual needs to be at a 7.4 pH, right?
Right.
Once ethylene glycol starts getting metabolized and it turns into those acids, correct?
Yes.
And the heavy breathing, the rapid breathing, that's the body trying to get rid of the acid in the blood.
Yes.
And that would happen while a person is acidotic.
Yes.
That's where you see possible cardiac arrest.
Yes.
Issues with just heart rate.
Yes.
And then labored breathing.
Yes.
As long as the body is acidotic, would you expect to see somebody in phase two?
That's probably the description of phase two. I'm not sure it has a strict definition, but phase two relates to the production of glycolic acid.
I guess
acidosis.
What I'm trying to understand is the logic with it, okay, and the explanation for it. So the heavy, rapid breathing is because the body has become too acidic, right?
Yes.
Okay, and so it would stand to reason that as long as the body is absorbing ethylene glycol, actively absorbing ethylene glycol in the blood, you would be acidotic.
As long as the body is metabolizing it.
Sure. And as long as it's being metabolized, it seems like you would probably be in that phase two.
Yes, until you got through, until you metabolized all of the glycolic acid or whatever other acids were being produced.
Sure. So if you had unabsorbed ethylene glycol that was still being processed by the blood, it seems like that would put you into phase two.
If glycolic acid was being produced?
Right.
Yes.
Okay. Then you talked about stage three, and that's thought to begin, again, a really wide time frame, anywhere from 24 hours to 72 hours after ingestion.
Right.
And that's the renal phase.
Yes.
And that's the whole issue with the kidneys and kidneys shutting down.
Yes.
Okay. These stages can overlap, can't they?
Yes.
You may have a stage that's not clinically apparent.
That's correct.
A person could exhibit multiple phases at once.
That's correct.
And the reason that you could exhibit multiple phases at once is because when you ingest something, if a person were to ingest an alcohol, the gut doesn't immediately process all of it at once, right?
Right.
And that gets to kind of some of the stuff we talked about earlier with the GI motility.
Yes.
It gets to absorption in those absorptive cells.
Right.
It gets to a person's rate of metabolization.
Right.
Okay. And so it's not like the stomach isn't like a sink where you pull the drain and it all just goes into the bloodstream.
Not usually.
Right. And so if and you might see this or even experience it with drinking alcohol, right?
Experienced what?
This idea that all alcohol isn't absorbed simultaneously.
Correct.
Okay. You could get really drunk at night, not drink anymore, and still be drunk the next morning.
You could.
And is the logic that I'm explaining, is that consistent with that?
Is what consistent with that?
Just that metabolization, rates of just GI motility, all of that would play a part.
Yes.
Genetics might play a part.
Possibly.
Genetics might play a part in terms of how a particular individual absorbs and processes alcohol.
I would imagine so. I mean, yes, I know some examples.
And while we can't study, while ethylene glycol can't be studied on people, there are lots of studies about how people process alcohol, right?
Yes.
And the enzymes that metabolize alcohol would be the same enzymes processing ethylene glycol.
That's correct.
Okay. Would you agree that amongst comparing individual to individual, a person who's a chronic consumer of alcohol, that could result in the upregulation of those enzymes?
Yes.
That person would be able to metabolize alcohol faster than somebody who's not a chronic consumer of alcohol.
Yes.
And the reason they'd be able to do that faster than the person who doesn't drink alcohol is because the body has adjusted that P450 enzyme, right, to be able to do that.
Yes.
Okay. And so it would stand to reason if you were not a regular drinker, you would likely not metabolize alcohol as fast as somebody who is a regular drinker.
That's, yes.
I think today you testified that, well, you testified about half-lives, right?
Yes.
And a half-life is once a substance reaches peak level in the blood, it starts being eliminated from the blood, correct?
Correct.
Okay. And then if a half-life is 4 hours, in 4 hours' time, you would have half of what was in there 4 hours before, right?
Right.
And then 4 hours later, it would be half of that.
Right.
And it's thought that 5 half-lives, when you do that 5 times, you're basically down to 0, correct?
Right.
Okay. And so if a half-life is 1 hour, you would expect that it would be out of your system within 5 hours, correct?
Right.
And if a half-life was 8 hours, you would expect it to be out of your system in 40 hours.
Yes.
The peak level for ethylene glycol, in terms of the literature, is estimated as being typically 1 to 4 hours after consumption.
Yes.
I think earlier today you gave the number of 1 hour.
I think 1 hour is what I've seen more commonly.
That's the low end of that range.
Okay, I mean, yes, I have seen 1 to 4 hours in the literature.
You're aware of cases in which the peak is reached after 4 hours.
Yes.
And it's not the ethylene glycol by itself that's fatal to a person, it's the metabolization of it.
That's correct.
So you could have, and you might frequently have, somebody who's died from ethylene glycol poisoning and their blood level at time of death would be 0.
Yes.
The current reported half-life of ethylene glycol in an adult human being is estimated at being 3 to 8 hours. Would you agree with that?
I've seen 3 to 5 more commonly.
You've seen that in more textbooks,
Textbooks, literature,
and you've also seen 3 to 8.
I have seen that as well.
To know what Julie Jensen's half-life is, we'd have to know a lot of variables. Would you agree?
Yes.
We'd have to know, one, when precisely she ingested ethylene glycol.
Yes.
We'd have to know how much.
Yes.
And then, I mean, that would be those would be necessary points to figure it out, right?
Well, we would have to know where the peak concentration is.
At what time the peak concentration was.
Correct.
Okay. And then there are all those variables in terms of her own P450 enzymes, right?
Right.
We don't know anything about that with her.
Not specifically, no.
We don't know what was happening with her gut on December 1st to December 3rd.
We know the way it ended up.
We do.
Right.
In terms of her GI motility is what I'm talking about.
Right.
We don't know that.
No, we do know how it ended up. We don't know how it started.
All the examples I gave of things that can cause gastroparesis, it would stand to reason that Julie Jensen was experiencing gastroparesis, wouldn't it?
Yes.
She had an electrolyte imbalance.
That wasn't proven, but I'm sure she did.
She had to have, right?
Right.
Her body was dealing with a toxin.
Yes.
Do you still have that little NyQuil cup of Mr. Jamboy's is up there?
Yes.
$30 milliliters is what you've testified to be the amount necessary to be fatal to Julie Jensen.
It could be, yes.
Do you think that's the bottom end of what's fatal to her?
I'm not quite sure.
You think 30 milliliters would be fatal to her?
Probably.
Somebody who weighed approximately 110 pounds at the time of death.
I would say probably between 30 and 50 mLs.
The testing showed that at the time of death, she had unabsorbed ethylene glycol in her blood, correct?
It was absorbed because it was in her blood.
It was in her blood, but it was still being processed.
Right,
It had not yet, it's still in the process of being broken down into those metabolites.
right.
In your work as a forensic pathologist, one of the manners of death that you need to consider is suicide, right?
Yes,
You would consider prior suicidal statements,
yes,
prior attempts at suicide,
yes,
anything indicating a suicidal ideation,
yes,
and that would be like a comment to a doctor, a friend.
anybody really.
You would consider a significant history of depression or mental illness.
Yes,
You would look to see whether or not a person had been diagnosed as being depressed.
yes,
You would take weight loss into consideration.
yes,
In this case, you reviewed Dr. Borman's notes, I think you mentioned on direct.
yes,
And on September 21st, 1998, you note that Julie Jensen weighed 123 and a half pounds, according to those notes.
yes,
And then on December 1st, she weighed 115 pounds.
yes,
And then at the time of her death, it's estimated to be 110 pounds.
yes,
Would you agree that depression and suicides can run in families?
it's been shown, yes,
It's understood that people frequently try to hide depression from people.
that's common.
The majority of people who commit suicide are suffering from depression.
I would agree with that.
You would consider whether or not a person's been treated for depression.
Yes,
And that treatment could include counseling.
yes,
It could include medication.
yes,
Paxil is paroxetine, right?
yes,
Okay. There's an FDA warning on that classification of drug, isn't there?
yes,
It can cause someone initially, when they take the antidepressant, to get dramatically worse initially.
yes,
Another thing that can happen when people start taking an antidepressant is that and start feeling the effect of it, is that they can have the strength to take their own life where before they might not have.
that's correct.
There's a stigma about depression.
I would say so, yes,
There's a stigma about suicidal ideations.
I would say so.
There are frequently consequences to reporting suicidal ideations.
Yes, there can be.
There are mandatory reporters,
Yes,
and that could lead to commitment.
possibly.
Women with children have killed themselves.
Yes,
Would you agree that things can be counterintuitive with suicides?
yes,
What might seem logical to somebody who's not depressed doesn't necessarily apply to somebody who is depressed.
correct.
When you made an opinion in this case, in any of the times that you testified, you didn't have access to Julie Jensen's counseling records, did you?
I don't think I did.
You didn't know that several years earlier, she had been prescribed an antidepressant.
I may have known that, I'm not sure.
I think you testified today that one of the reasons you thought this was homicide and not suicide is that a suicide would typically take a large enough dose to kill themselves.
Yes.
And then you explained and held up Mr. Jamboy's NyQuil cup that 30 milliliters is enough to kill somebody.
Yes.
Did you take into consideration with your opinion information that that there had been a suicide attempt in Julie Jensen's family?
Yes.
Did you ever speak directly with Dr. Borman about his assessment of depression?
No.
I want to talk a little bit about asphyxiation and the findings in the autopsy. If you saw injuries to the lips or cheeks, would that be an indication of asphyxiation?
It could be, yes.
In this case, there were no injuries to the lips or cheeks.
That's correct.
There were no teeth marks anywhere.
No.
The neck showed no sign of injury.
That's correct, unless you count the perimortem yellow mark.
There was no damage to the larynx that we talked about.
Correct.
And you'd see that if there was pressure on the neck.
You could.
Correct me if I'm wrong. You talked about positional asphyxia a little bit on direct exam today, right?
Yes.
And the notes that I scribbled down when you testified is that you said it was not positional asphyxia because that wouldn't explain the injury on the ribs.
Yes.
That's the injury that when we talked about, you agreed could have just been congestion.
Yes.
Could have been just postmortem lividity, that pooling of blood.
Yes.
So aside from that explanation, you don't have an explanation for the injury to the ribs?
Aside from those two explanations, no.
It's a common finding and it didn't mean much to you at the time, right?
Correct.
The only reason you think asphyxiation occurred in this case is because of Aaron Dillard.
Not necessarily. I would say he is my main reason.
Because he provided an explanation for that notation about her ribs.
And a lot of other information.
Found at autopsy, right?
Including that.
Prior to hearing about Aaron Dillard, your opinion was that Julie Jensen had died of ethylene glycol poisoning.
Correct.
And your opinion was that it was probably a homicide.
Yes.
And that was based on her unabsorbed ethylene glycol in her gastric contents?
That was one factor.
And the other was that that she was experiencing multiple phases at once, right?
Objection. The question assumes the existence of a fact which is not in evidence, in fact, is contrary to the prior answer. So I object to that question.
Well, why don't you ask her what her opinion was based on? Go ahead, Mr.
Well, I'll rephrase it.
Go ahead.
I think you just testified that one of the reasons you thought it was homicide is because she had unabsorbed ethylene glycol in her gastric contents.
Yes.
What's the other reason?
Objection. Again, he assumes the existence of fact not in evidence, to wit that there's only two reasons.
What are the other reasons?
Thank you.
As I tried to explain in the beginning, the case did not look like a case of suicide. It did not look like a suicidal ingestion. The circumstances simply were wrong.
Is one of the other reasons that she had crystals in her kidney at the same time she had unmetabolized ethylene glycol in her blood?
No.
That didn't play a part in your opinion?
No.
That didn't play a part in your opinion that there were more than one dose?
No.
Is the opinion that there was more than one dose because there was the amount in her gastric contents?
That my opinion is partially based on that.
You testified about the letter Aaron Dillard wrote.
Yes.
Did you also review the recorded statement that Aaron Dillard gave?
I believe I saw at least part of it.
At some point in your history with this case?
Yes.
In the letter that you reviewed, he describes kind of the evening of December 1st, December 2nd, and then December 3rd, correct?
Yes.
And on December 2nd, described that Julie Jensen was vomiting a little.
That sounds familiar, yes.
Did you review in his recorded statement that she wouldn't get out of bed, was really just vomiting?
I recall that, yes.
You've looked at the scene photos in this case.
Yes.
Have you seen any indication that there was vomit on the bed sheets?
No.
Any indication that there was vomit in the garbage can next to the bed?
No.
Any indication that any vomit was found anywhere?
No.
I think you were asked on direct about Aaron Dillard. I think Mr. Jamboy's asked you, you know he's an admitted con man, right? Or something like that?
Yes.
And your answer is yes, right?
Yes.
That you know that about him.
Yes, I do.
You understand that a really good con artist can figure out ways to present a story that aren't obvious to other people.
Yes.
Mr. Dillard indicated that Mark Jensen told him that he pushed on her back or lungs or something like that, right?
Yes.
Someone might create that story if they realized there was damage in the lung or rib area.
Possibly.
Aaron Dillard's letter describes what medications Julie Jensen was taking.
Yes.
It's not a confession if Mark Jensen had told Aaron Dillard what medications Julie was taking.
No. No, if he's in isolation, no. If that's what you mean.
Aaron Dillard's statement and the findings at autopsy line up, in your opinion, correct?
Yes.
Today you testified that there was no other source for that info.
For which info?
For Aaron Dillard to have that information, but for Mark Jensen.
I am not aware. I am aware of materials that Aaron Dillard had access to.
Which ones are those?
I believe that he had access to an interview with Detective Ratsburg between Mark Jensen and Detective Ratsburg.
It was also well known that this was an antifreeze poisoning case.
Yes.
There were newspapers or articles about this.
Yes.
There have been articles about your testimony.
Yes, there have.
There have been articles about your testimony that it was your opinion that multiple doses were given.
Yes.
Anyone who read that article would know the state's theory that multiple doses were given.
Possibly.
You mentioned Detective Ratsburg's interview with Mark Jensen. Did you read that?
I'm not sure that I read the same interview that was in the cell with Mark Jensen.
You're aware of description of the interview, the interrogation between Detective Ratsburg and Mark Jensen?
Yes.
And you know that he was suggesting deaths that he thought were consistent with the autopsy findings.
Yes.
He even suggested an autoerotic death.
I don't recall that.
Well, maybe that doesn't matter because nobody's suggesting that that happened, right?
Not to my knowledge.
He suggested in that interrogation the location of her arm.
I don't remember.
His suggestions incorporated what Dr. Chambliss described as a neck hemorrhage, the petechia over the cardio area, and the bruising on the ribs.
I honestly don't remember if he referred to all of those things.
You just don't remember precisely what he referred to.
Correct.
But it's your understanding that Aaron Dillard had access to that.
Yes.
Talked a little bit about this claim of poisoning in November, right?
Yes.
That's one of Aaron Dillard's claims.
Yes.
That Mark Jensen had tried to poison Julie Jensen in November when he was at a conference.
Yes.
And got home and found that there was vomit everywhere that hadn't been cleaned up.
Yes.
In terms of your, I guess, investigation or overview of this case, are you aware of any reports of her being sick for a several-day period in November of 1998?
It depends on how you describe sick. Do you mean by vomiting or by?
Sure, by vomiting.
No.
Any reports from neighbors that Julie Jensen was sick prior to December of 1998?
I don't think so.
Anything from the Voights?
No, I don't think so.
People at school?
I don't think so.
Any reports that she didn't tend to her usual activities in November?
No.
That she needed help with the kids?
I don't recall. I don't think so.
She was at home with the kids in November, right?
Yes.
Any claim anywhere that she appeared intoxicated in November?
No.
You reviewed Dr. Borman's notes. Did you see anything that she came in for treatment in November?
No.
No description about any breathing abnormalities in November?
No.
If Julie Jensen had been endlessly vomiting on December 2nd and then not eating, would you expect to see 22 ounces of material in her stomach?
And what day did you say?
December 2nd.
She may have been drinking.
You've been asked this before, and I'm just going to ask you once again. Would you buy a used car from Aaron Dillard?
No.
I have nothing else.
Redirect, Mr. Jamboys.
Thank you. Dr. Mainland, you were asked on cross-examination about injuries to the neck.
Yes.
And the kind of injuries they were asking about are the kind of injuries you expect to see with a strangulation, right?
They were asking about injuries that I said weren't there. Is that what you're referring to?
Yes.
Yes.
And you never suggested that there'd been a strangulation in this case, had you?
No.
Now, when you were asked about the injuries to the rib cage, after being asked a series of questions about it, you indicated, I don't think it was post-mortem. Is that true?
I think that's what I said.
Well, was it? So what did you think it was when you observed these injuries after reading Aaron Dillard's report?
I thought it was perimortem.
And the injuries are consistent with perimortem injuries.
Yes.
Okay, so let's go through the ante-peri post. Antemortem, A-N-T-E, mortem is pre-death.
Yes.
Perimortem, P-E-R-I, mortem is during the death process.
Right.
And post-mortem is after death.
Yes.
So post-mortem artifacts are something you expect to see that could come up after somebody, it's a post-mortem artifact, something that happens after death.
Yes.
And antemortem is something that could have happened before death.
Yes.
But perimortem is something that happens during the death process.
Around the time of death.
Now, the injuries that you saw on Julie Jensen's rib cage in the photos was consistent with a perimortem injury, an injury during death that would be caused by somebody sitting on a rib cage while her arm is stretched beneath her, as it was in the two photos that we displayed earlier to the jury.
Object to the leading.
Well, is it consistent or inconsistent with that?
Rephrase it and let's go.
Is it consistent or inconsistent? Is the notion of perimortem injury consistent or inconsistent with the two photographs that we displayed to the jury earlier that you were testifying about?
Consistent.
Now, counsel was also asking you questions about another statement. This was the recorded statement, recorded interview that Mark Jensen, or that Aaron Dillard had, that involved his defense attorney, the prosecutor, that being myself, and Aaron Dillard. Did you read that transcript?
Between or among the three of you?
It was a transcript of an interview that I conducted with Aaron Dillard that was recorded with his attorney present, Gretchen Rosenke. Do you recall ever seeing that transcript?
No, I don't.
Some exhibits appear, Mr. Jamboy, I know that. Attorneys can search their areas for 71.
I'm going to direct the court and counsels and the defendants and the witnesses' attention to the screen.
And what exhibit is this for the record?
Well, this is our screen version of Exhibit 71, Your Honor.
Right.
And we don't know where Exhibit 71 is. If we can't locate it anywhere, I will confess that ordinarily I'm the prime suspect when something is missing like this. And if we can locate it, I'll produce it. If I can't locate it, I'll produce another one and we'll have it remarked.
We'll fix it.
So in any event, now that you've seen the first page of this, does that look familiar to you at all?
Yes, it does.
So you did at one point see this interview that was, it says J. Jamboys, D. Dillard, G. Gabrielle, and R. Gretchen Rosenke.
Yes.
And you know who Angelina Gabrielle is.
Yes.
And you know who I am. And so let's get to the point where Aaron Dillard is asked about where this conversation occurred. He said he was in J Block in the Kenosha County Jail. Is that correct?
Yes.
And he starts talking about how they got together and we're talking about this, correct?
Yes.
And then I asked, I want to hear exactly what he said. And he replied, okay, he said it's all bullshit. It's all bullshit. This Klug guy just came and said this, and they revoked my bond because that's basically what the conversation was about. Why are you in jail? You were in bond, you know? And he said this guy wrote a letter saying, I want to kill my wife or this and that. And he just comes out now. And so then we started getting more deeper into the conversations, meaning, well, why would he say that, you know, things along that line? And he would have just answered that he was an attention getter. He was just seeing this as his big moment. He could try to steal the limelight or whatever, something like that. I don't remember the exact words, but that's the gist of how we started talking about his case. And then right away, when I first got there, that's when, you know, we just started talking and he asked me about myself. And I said, well, yeah, I'm here for revocation and all that. It was just a minor chit chat about my case and things like that. And I said, well, yeah, I'm looking at 4.5 years or whatever on extended, but I said, I don't think I'll get it. I'll probably get a chunk of it, but not that much. And then we went through the conversation more. And then he said, well, yeah. And I said, he said, here, you know, he gave me this transcript, the actual transcripts from the Klug hearing. And I read that transcript. And then I asked, it was a transcript of what? D, of the Klug hearing. Of what? Of Klug's testimony? Dillard, his testimony, yeah, Klug's testimony. Now, that you've read that, does that refresh your recollection as to what documents it was that Aaron Dillard had reviewed in the county jail?
Yes.
He hadn't reviewed Mark Jensen's interview with Paul Ratzberg. He'd reviewed Ed Klug's transcript of his testimony from the forfeiture, from the first hearing.
Yes.
And he wrote, and he said, his testimony, yeah, Klug's testimony. And I told him at that point, I said, this is kind of really lame, you know. What I meant, if you look at it, it seems just kind of out there that there's nothing concrete in this. And I said, the only thing that's going to get you this is when we started talking about, he was like, well, how do you think I can get around this thing? And I told him that I don't think you can. If the two secretaries say that you did come back, or that Klug did come back and say these things to them, because in the transcript he said something about he came back to the office and he mentioned it to two of his secretaries or whatever. I think it was somewhere at the end of his statement. And I said, well, if he comes back and they say that he did say those things, that you're basically, that you're fucked. You know, that they can collaborate his statement, then you're screwed. I don't think there's a way around it. Jay, so question. So what did he say to that? Dillard. He was kind of quiet, think about it. And they spoke about he had some spots outlined in it in his paperwork, and said that in that statement and that testimony, that shows on he was just an attention getter and seeker, and that he was talking about specific people in there and about how they probably wouldn't say anything, and that he had probably already, when we were going through the testimony at the court hearing, that he probably already sent an investigator down to try to talk to them. He told me that.
Judge, I object to Mr. Jamboy's reading this entire transcript.
Well, he asked about
how many pages is a transcript?
Well, here, let me
tell me how many pages the transcript is.
First of all, Judge, I wasn't going to read the entire transcript, but it is 34. It's 35.
I read the entire transcript in the last 5 minutes.
Well, not yet.
What's that?
I said not yet.
You said you objected to him reading the entire transcript.
Sure.
I do listen.
He's in the middle of it.
All right. Let's finish it up in the area, Mr. Jambois.
I'm getting there, Judge.
Thank you.
Mr. Dillard might not be quite as succinct as I might be on my own devices. But, I'll skip down some in deference to, the jury's time and then we started talking a little bit more. I was just talking with my lawyer that there are some things that you can look at and verify that we talked. He asked me also, this was later on, he asked me, well, what do you think I can do to get around it? And this was at the point when he was telling me about the toxicology report, about how you guys lost, or the department lost, a big stack of papers or whatever it was along that they lost it. Now let's stop there for a moment, Dr. Mainland. Had you been made aware of the fact that the St. Louis Forensic Toxicology Lab had lost some of the paperwork in this case?
I think so.
Yeah. And so how would Aaron Dillard know that if Mark Jensen hadn't told him?
I don't know.
So the stuff that was lost from the St. Louis Forensic Toxicology Lab, they didn't lose the samples or anything like that, did they?
I don't think so.
They just lost some of the paperwork, and they asked to get it replaced, didn't they?
Yes.
And you guys replaced the paperwork that they'd lost?
Yes.
But how would Aaron Dillard know that if Mark Jensen hadn't told him that?
I don't know.
It certainly wasn't an Ed Klug's transcript, was it?
No.
Well, you are aware that the transcript of Ed Klug's testimony from the first hearing related to his conversation with Mark Jensen in St. Louis, correct?
Yes.
The leading.
It didn't relate, to your knowledge, well, state whether or not it related to anything other than the conversation that occurred in St. Louis between Mark Jensen and Ed Klug.
Object to the leading.
Rephrase it.
Do you know whether Ed Klug's testimony at the first hearing related to anything other than the conversation that Ed Klug is alleged to have had with Mark Jensen at St. Louis?
No.
So then Aaron Dillard continued, and I told him that that you have a right to examine the evidence. Try to get samples of it yourself and then test it yourself. And if they can provide you with that sample, and if they can't provide you with that sample, and then he got on the phone right away and called his people. So you can probably verify on the phone records between the 14th and the 17th. I forgot exactly which day it was, but you can probably verify those phone records because you can hear him say, a guy in here told me that I should just try to get the samples rechecked. So, and I'm like, don't say me, in the background. You might even be able to hear me say it. And Jamboys replies, well, except for one thing, that's a phone conversation directly to his attorneys, and we do not record those conversations. Dillard, I don't know if it was his attorney or his wife at that time. Jamboys, oh. So at the time that he was talking to us, he was proposing that we check the phone records to confirm the veracity of his information to us.
Yes.
To your knowledge, did the defense ever have these toxicology samples tested?
Yes.
So they hadn't lost the samples at St. Louis Forensic Toxicology Lab, did they?
No.
They did have them tested, just as.
With a Tavern League Safe Ride program, there's never a reason to drive if you've had.
Oh, chat. I don't know. Hang on. Fucking, hang on, chat. Oh my God, chat. It's not me, chat. That's a platform putting commercials on shit. Hang on.
And then he says, or Jamboys, and was this the first day that you first met him, or was this Dillard? This was more toward the second day, because I got on the first day, I got in there around about 7, and they locked down at 9. And what day was you got there? I got there on the 14th, I believe it was. Jamboys, so this was sometime on the 15th that he made this phone call. Dillard, yeah, the 15th or the 16th. I think it was more toward the 15th, though, in the evening time, probably around 6-ish, I would say, if I remember correctly. Jamboys, okay, so then what happened after that conversation? Was there anything more that occurred during that conversation? Dillard, the one about testing the samples and things like that? Jamboys, yes. Dillard, it was basically just how to beat the case and what they did. What did they have against you, and what is your defense against it? And he was just going into detail about the pictures with the antifreeze, and that you guys came to him saying there was no antifreeze in the house. Mark, how could she have gotten the antifreeze? And he's telling me that in the pictures there are 2 bottles right in the thing, so he had that as a defense. He told me about the receipts, that his wife would be the only one that was buying all the prescriptions and all the St. John's wort and all over the counter medication, and that he would never do it. He was trying to use that as a defense. And then Angelina Gabrielle asked, did he show you the pictures of the antifreeze? Dillard, no, I've never seen the pictures. The point with the antifreeze, and then Jamboys, she purchased all the prescriptions, all the medication. Dillard, yeah, all the medication. And now we'll slip down to, let's see, I want to go up to something else here. And he told me that he told me that this in regards to the prescription medication, that he told me that he takes a medication for, that's in the conversation about the acid reflux and the cause of him to have anxiety or whatever. The Jamboys, Librium? Dillard, Librium, yeah. He told me it was an antidepressant or whatever like that. Now, first of all, is Librium prescribed as for acid reflux?
Yes. Or it was at the time.
And was it an antidepressant?
No.
But it was prescribed for acid reflux?
Yes.
And Jamboys, and he seemed to think that was a big issue. Dillard, yeah, he seemed to think that was a big issue, that he's trying to say that she self-medicated herself. She would call behind his back and get all his medications and get, you know what I mean, and start taking them on her own when it was, you know. So he told me that aspect. He told me, what else was it? Oh, something on the internet. He told me about something on the internet. There was a time where he can verify that he wasn't home or something like that. He said that was going to be one of his defense things, that there was one time that he wasn't home, that he could prove he wasn't home, that there was one of the hits for the poison site or whatnot, something like that. So he said he was going to use that as a defense. And then the question, and what did Mark say in response to that? Dillard, the first couple of times I said it, he was like, no, this is all just bullshit. It's the state. I'm ready to go. I'm ready to go. I never did anything there. I'm just trying. She wanted to kill herself. She was depressed. She was nuts. She had a nutcases for family, and justifying that, you know, she killed herself. Was that the expression that he used? I'm ready to go. Did he say that expression? Dillard, yeah. Bring it on. Bring it on. Yeah, bring it on were key words. Yeah, they can bring it on. And how did you respond to that when you would say things like that?
Why don't we get to some redirect questions, Mr. James?
Yeah, the second day I was in there, we got more into the conversation of, well, you know, why would those people say, or why would these people say you did it? And he goes, I don't know. You know, it's just they're trying to grab the limelight, more along those lines. Then I was like, well, I go, dude, you know, basically shit happens, you know, or I don't remember the exact term I used, but it was more like, we all have our problems, you know, something along that line. I said, we all have our problems, you know. If you did it, you did it. You know what I mean? And that's when he started, you know, he broke down and started telling me everything. Tell me about that conversation. Do you remember reading that now that you're seeing this, does that refresh your recollection as to the conversation that occurred between myself and Aaron Dillard that was recorded? Dillard, that conversation started out as, I know, like I said, I told you. I told him that he said, or he told me, I said, everybody has their problems, you know, and something along that line. And he was like, yeah, everybody's got their problems. And that's when we started getting a little teary-eyed. We started telling about how the wife, more about details about the wife, would put one kid in the corner and so on and so forth. And then started telling me more about family issues and this and that. And I go, well, you know, I said, basically, you didn't have to kill her, you know. And he goes, well, yeah, you know, just real down and out about it. It was basically, you know, just a little bit of tears, you know, the water welling up in his eyes. And then at that point, he started telling me about what happened, he told me about him and her going to the doctor that day. I don't know what days they were. I don't know exactly what day, but he said they went to the doctor and she said she was feeling down and this and that, and they got a prescription for Paxil.
Judge, I object again in terms of Mr. Jamboys is essentially.
I think you've refreshed your memory enough, Mr. Jamboys.
Well, I'm getting to the part that I really wanted to get to.
Well,
Judge.
let's get to the part, and then we'll ask a question on redirect.
So he told you, Erin Dillard said she took the Paxil, she took more medications. It was, the St. John's wort. He kept saying the St. John's wort. He kept saying the Librium and then the Benadryl. She took the Benadryl and the Librium and all that. And that's the first night when he gave her the antifreeze. Did he tell you how he got her to drink the antifreeze? Yeah, he said she was so loopy and everything. He says he mixed it with juice and he said, here, this will make you feel better, And he gave it to her because she was really, really out of it, really loopy and tired and more, I don't know what the word he used was, just sleepy, really out of it. Now, reading that, is that consistent with the history that you knew about this case?
Yes.
You had heard Mark Jensen had said this in his earlier statement to Detective Ratsburg, correct?
Had said what?
That Mark Jensen had told Paul Ratsburg that on that first night, she was really loopy and tired, the first night after she'd gone to see the doctor.
Yes.
And at that point, and then he goes on to read, and so he would give her stuff to drink. And he said, that's when he put the antifreeze in there. And I said, wow, how much did you give her? Didn't she notice that? And he said that at that point, he said that he would mix it probably like 1/3 to 2/3 of juice so that you wouldn't be able to see it and you wouldn't be able to taste it. Question, so 1/3 antifreeze, 2/3 juice? Yeah. And so he gave her the antifreeze that day. And then at nighttime, he said she was acting like a nutcase. She was up in the bed dancing around saying, oh, I'm so drunk. I feel so drunk. Now, that's consistent with the history that Mark Jensen had provided to Paul Ratsburg, correct?
Yes.
But there's nothing like that in Ed Klug's statement, is there? Or Ed Klug's, the transcript of Ed Klug's testimony from the first hearing.
No.
And then he told me about how he went to the internet to show her that Paxil was a side effect of drunkenness, and he said, oh, look, it's just the Paxil. Don't worry about it, blah, 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 blah. So now you were aware of the fact that there was evidence that Mark Jensen had actually printed out some internet information about Paxil or paroxetine.
Yes.
Paroxetine is the generic name for Paxil, correct?
Yes.
And listed as one of the rare side effects, possible rare side effects of paroxetine or Paxil, there is some reference to maybe vertigo or getting dizzy and things of that sort.
Yes.
But that's a rare side effect, correct?
Yes.
It's not a common side effect.
No.
So then he said everything calmed down after he showed her the paroxetine side effect information, and she ended up going to bed. And the next day, he went to the doctor and told him, "Oh, she's acting drunk. She's all crazy. Wouldn't sleep at all that night." And he got her sleeping medication, which was the Ambien. He got her the Ambien. Now that's consistent with the information that was obtained at during the toxicology screens in this case. Is that true?
Yes.
And it was also consistent with the evidence that was recovered at the scene. Do you remember that?
Yes.
There were
Yes.
There were a certain number of Ambien pills, and there were some that were missing.
Yes.
And he said he came home after the doctor and gave her the Ambien, and she was sleeping. And then he woke her up and gave her more of the antifreeze, another glass of it. And at that point, he said the whole day she was throwing up and she was just really out of it. If you know what I mean, she was sick and this and that. And at that point, he said she would just stay in bed a lot, that she wouldn't get out of bed, and that she was really just vomiting and she'd stay in bed. That's actually consistent with the testimony you just provided on cross-examination about this information.
Yes.
Is that correct? And then he says, and he was like, wow, he didn't know if this was working or not because she was still fine, basically about it, He's like, wow, No, he expected it to be faster or something. And what I take out of the conversation, because he was like, he was more in, I don't know what the word too is. He was more concerned with time. It seemed like that it wasn't happening as fast as he thought it was or something like that. You know, that's what I got from the conversation. And then he sat with TV and watched TV with the kids. Now you've heard other evidence in this case that's consistent with the history that Mark Jensen had provided to Paul Ratzberg, isn't it? That he
Yes.
was sitting up with the kids watching TV on the evening of December 2nd?
Yes.
And that's consistent with what the information is contained here.
Yes.
But Ed Klug had never said anything about that in the testimony at the first hearing, did he?
No.
He sat with TV and watched TV with the kids and something like that, and she would just ask for a lot of water. She was drinking a lot of water and throwing up. So that night, he gave her more of the Ambien. Then he said the next day when she woke up, she was really bad. Now, first of all, that's consistent with the second and third stage of ethylene glycol poisoning, isn't it? That she woke up and she was really bad.
Yes.
And you'd heard that that's consistent also with how David, their 8-year-old son, had described her breathing, her raspy breathing to one of his little school friends.
Yes.
Then he said the next day when she woke up, she was really bad. It was that she was just breathing real hard, breathing just really nauseous. She wouldn't get out of bed. She wouldn't lift her head and she wouldn't do anything. At that point, that's when he told me the kids wanted to call the ambulance and he got real nervous about it. Now, that wasn't in Ed Klug's report, was it?
No.
But there was information that the children wanted him to call an ambulance, correct?
Yes.
He said like he didn't know what to do at that point because, I can't send her to the hospital. And so he said he told the kids that if mom isn't better by the time you get home from school, we'll call the ambulance or we'll take her to the hospital. Now, that wasn't anywhere in the transcript of Ed Klug's testimony, was it?
No.
So he took her to school. And at that point, he came back and actually he took the kids to school. But then he came back, and that's when he told me about him. He said he was worried because she wasn't breathing hard anymore. She wasn't raspy breathing. He didn't know what was going to happen at that point. That's consistent with your recollection of this detailed description that Aaron Dillard was providing about the manner in which Mark Jensen murdered his wife?
Yes.
And that's consistent with the evidence in this case, isn't it?
Yes.
That's consistent with third stage of ethylene glycol poisoning.
Yes.
And he says he got nervous. He said he got real nervous. And at that point, he sat on her. He sat on her back and he said, I couldn't have the kids come home because I couldn't have an excuse. So he said he sat on her back and pushed her face into the pillow. And then he killed her. And then at that point, he left for work or whatever. Now, there was nothing in Ed Klug's testimony at the first hearing that was suggestive of anything like this, was there?
No.
However, you were aware because of your examination of the autopsy records, the autopsy photos, and the crime scene photos, you were aware of certain information that was precisely corresponded or correlated to this description of the murder of Julie Jensen.
Yes.
Now, what were those items that you found that you found from the autopsy report, the autopsy photographs, and the crime scene photographs that precisely corresponded to this description of the murder of Julie Jensen?
There were the toxicology findings, the position of the body at the time it was discovered, certain injuries on the body, and I think I said the autopsy findings.
Now, there was significant discussion on cross-examination about gastrophoresis and a lot of other big, as you call them, doctor words. You know all those doctor words when you were reviewing the autopsy report?
Right.
And when you were reviewing the photographs and the crime scene photographs, the autopsy photographs?
Right.
when you were reviewing all the police reports in this case and the witness statements,
Yeah.
and knowing all of that information, what you knew prior to your testimony at the first hearing, or concern, and even at the first hearing, what was your opinion did you have an opinion to a reasonable degree of medical certainty as the cause and manner of death of Julie Jensen?
Yes.
And what was that opinion?
Ethylene glycol poisoning, homicide.
And so the cause of death was ethylene glycol poisoning, and the manner of death was homicide.
Yes.
And at that point, had you ruled out possible asphyxiation?
No.
No. That's what you knew up to the first hearing. Then between the first hearing and the second hearing, you'd read of Aaron Dillard's report.
Yes.
You'd read this statement that I just read to you.
Yes.
And you read Aaron Dillard's letter to Gretchen Rosenke.
Yes.
And there was a high level of consistency between the letter and this statement.
Yes.
The letter was only 6 pages long. The statement was about 35 pages long, or the interview was 35 pages long, correct?
Yes.
But there was no significant inconsistencies between them.
I don't think so.
And there was a great deal of consistency, or could tell me whether or not, was there a great deal of consistency between the description that was provided by Aaron Dillard and the physical evidence that you reviewed from the crime scene photos and the autopsy photos?
It was consistent.
And was it consistent or inconsistent with the toxicology results?
Consistent.
And with respect to missing toxicology reports or losing toxicology reports by the St. Louis Forensic Toxicology Lab, was this information consistent or inconsistent with what you knew of the history about the St. Louis Forensic Toxicology reports?
Consistent.
And there was nothing in in Ed Klug's prior testimony at the first hearing that made any reference whatsoever to certain missing documents.
That's
from
correct.
the St. Louis Forensic Toxicology Lab. And based upon, well, whether it's based upon, after Aaron Dillard had proposed to the defense team that they should request that all of those substances be retested, you learned that, in fact, all of those substances were retested, weren't they?
Yes.
At the defense request.
Yes.
Consistent with Aaron Dillard's recommendation.
Yes.
And none of this retesting was none of this information about these missing reports from the St. Louis Forensic Toxicology Lab was available from any source other than Mark Jensen at that point to Aaron Dillard. Is that true?
Yes.
Now, after reading Aaron Dillard's statements, you then testified at the second hearing.
Yes.
Correct? And you've now testified at the third hearing.
Yes.
And knowing all of this stuff, you knew all of this stuff about gastrophoresis and delayed stomach emptying and the kidneys shutting down. You knew all of that before the testimony at the second hearing and before the testimony at this hearing.
Yes.
So all of these things were raised on cross-examination. You knew all about that long before you testified today.
Yes.
And long before you testified at the last hearing.
Yes.
Does any of this stuff that was raised by defense counsel on cross-examination in any way, shape, or form alter your opinion concerning the cause and manner of death of Julie Jensen?
No.
So based upon your observations of the crime scene photos, your examination of the autopsy report, your examination of the toxicology report, your examination of all the police reports and the witness statements and the transcripts from the first hearing, and the statement of Aaron Dillard, what is your opinion today to a reasonable degree of medical certainty as to the cause and manner of death of Julie Jensen?
Ethylene glycol poisoning with probable terminal asphyxia, homicide.
Nothing further.
Recross.
Yeah.
Librium is a benzodiazepine, right?
Yes.
That's used to treat anxiety.
Yes.
You just testified that it's your opinion that the injuries that were noted on Julie Jensen's ribcage were paramortem.
Yes.
That became your opinion only after reviewing Aaron Dillard's statement.
Yes.
Because before that, as consistent with your testimony earlier today, it was non-specific, right?
Objection to the insertion of that editorial comment in the middle of his question. He can ask a question. He can't tell the witness what the answer. First of all, what she said earlier is something that the jury may remember, but defense counsel can't assert that fact in the middle of his question.
She just agreed to that fact by saying yes.
Did you forget the question?
No, I think I said yes.
You answered, yeah, you said that it was non-specific, right?
Yes.
Right. Could have been post-mortem.
Could have.
Could just be congestion.
Could be.
Only after reading Aaron Dillard's statement did you decide it was paramortem.
Correct.
Do you remember testifying in 2007?
Yes. Vaguely.
The first hearing we've been talking about?
Yes.
There was a big issue in terms of a mistake that had been made with the findings by the St. Louis lab, correct?
Objection. Objection. This is outside the scope of cross.
I didn't hear him ask anything about something
This
being
is all
wrong.
in terms of,
outside the
this
scope
is
of reading,
all,
I can't listen to two people at once.
this is all in relation to this issue about lost papers from the
You
St.
could
Louis
ask
lab.
that question in that area. Go ahead.
That's what I'm getting at.
You didn't use that exact word, so let's go.
Well, I had to set the context, but I'll get to it.
All right.
By the time of that hearing in 2007, things had been retested.
Yes.
What was lost were police reports that had been sent to the St. Louis lab, correct?
I'm not sure of the exact content,
Samples were never lost to your knowledge.
to my knowledge.
That's correct?
I don't think they were. I don't recall.
Did you review all the discovery in this case?
I reviewed what was provided to me.
In terms of a potential source of information for Aaron Dillard, all of that was testified to in 2007, correct?
All of,
In terms of the St. Louis lab and police reports that had been lost.
I don't recall.
You testified a number of times on redirect that the information provided by Aaron Dillard was not contained in the Ed Klug transcript, correct?
Yes.
And then on a handful of times you said that it was consistent with what was said in the interrogation by Detective Ratzberg.
Yes.
You've read that interrogation, correct?
Yeah, at least part of it.
This is Exhibit 53.
I think what I have was not this thick.
What, for the record, what did you show her?
This is the transcript of the interrogation between Detective Ratsberg and Mark Jensen.
Thank you.
I just want to say that I'm not sure I had the entire thing.
You've reviewed some of it?
Yes. I may have had the entire thing.
One of the things that you tried to do in this case is review all information that was in existence, correct?
All information that was provided to me.
And this is an interrogation of who the state believes is a suspect in this case.
That's correct.
This would have been important for you in your role as a forensic pathologist, correct?
Yes.
In terms of statements made by Mark Jensen?
Yes.
You were just asked a lot of questions about information that Aaron Dillard provided that was not contained in the Ed Klug transcript.
Correct.
And that's information describing the autopsy findings, correct?
Yes.
The Ed Klug transcript doesn't talk about the autopsy findings.
I don't think so.
If you turn to page 75 to 76.
Counsel, what are you looking at right now?
Exhibit 53.
Ed Klug's transcript?
The interrogation with Detective Ratsberg. Page 76 to 75 to 76, starting at line 24 to line 3 on 76. It's Detective Ratsberg. Tell me when you're there, I'm sorry.
I'm there.
It's Detective Ratsberg that says her arm was actually here. I'll show you how she was. Okay, her arm is actually across her body like that. Okay, and it's an unnatural position. Do you sleep when you're on your side with your arm across like that? Do you see that?
Yes, I do recall reading this.
If I could direct your attention to page 98 to 99, lines 25 on 98 to 16 on 99.
Okay, Counsel, I'm sorry. I need to, what page are you looking at?
Page 98, line 25 to page 99, line 16. Please let me know when you're there.
Okay.
It's Detective Ratsberg that says, I know there was some type of contact there. There had to be in this chest area, Mark. There's no question about that. And the only person that could have done that was you. I'm thinking before you left, you pushed on her maybe. Now, she was frail at the time. She was frail. You said she was labored breathing. That makes sense, and I believe that. Okay, I know that probably happened, but she's frail. And you just innocently, I don't want to, pushed her like that. And could that have caused something? I mean, we have petechia of the lungs. There's some type of contact here in the throat. There's also been an indication on the throat, as I showed you in Dr. Chambliss's report. It just did not appear there. Something and somebody had to touch her. That's the only way it could get there. There's no doubt about that. And did you push her, touch her on the throat maybe? Maybe like this? Do you see that?
Yes.
Now, that's not in anywhere in the Ed Klug transcript, right?
I don't think so.
But it is consistent with Dr. Chambliss's findings in the autopsy report.
Yes.
And it's consistent with the statement that Aaron Dillard made.
Yes.
If you could go to page 152, lines 3 to 6.
Page 162?
152.
152, line 6?
Lines 3 to 6.
3 to 6.
Okay. Sorry.
No, I'm just waiting for you. Yeah. It's Detective Ratsberg that says, maybe when you pulled her over this way, you pushed her back on the chest and then went back and brought her up again. You know, you would have pushed her back. Do you see that?
Yes.
If you could go to page 161, lines 19 through 20.
Page 161.
Yes. Are you there?
Yes.
It's Detective Ratsburg that says, we still have to explain the nose part, the head pushed into the pillow. How are we going to explain that? I mean, that's there. You see that?
Yes.
That's not in Ed Klug's transcript, right?
Right.
But it does line up with what Aaron Dillard says.
Yes.
If you could go to page 162, lines 4 through 9.
Okay, I'm there.
It's Detective Ratsburg that says, something had to push it down. There's three things that happened here. Head being pushed, the nose, some type of contact here at the throat, and some type of contact here in the chest. Okay? We know that happened. Okay? You were the only one there. You had to do something, Mark. Do you see that?
Yes.
That's not in the Klug transcript,
No.
but it is consistent with what Aaron Dillard says.
Yes.
I had asked you on cross-exam about potential sources of information for Aaron Dillard's statement, correct?
Yes.
I'd asked you that whether it was well known that this was an antifreeze poisoning case,
Yes.
that there were newspaper articles
Yes.
about you,
Yes.
and you volunteered that it was your understanding that Aaron Dillard also had access to the Detective Ratsburg interrogation.
Yes.
Aaron Dillard, as just read by Mr. Jamboys, denies reviewing anything except for the Klug transcript, correct?
I don't recall. Yeah, please, if you would find that.
Well, in the letter or in the recorded statement that was, maybe not all of it was read, but, and Mr. Jamboys asked, does this refresh your recollection in terms of what Aaron Dillard says he got the information from? Do you remember that?
Yes.
And that Aaron Dillard's claim is that he got this from Ed Klug?
That part I don't remember.
Okay. You reviewed everything that was provided to you in this case, correct?
Yes.
You reviewed way more than just Aaron Dillard's statement.
Yes.
And when I asked you about sources of information, it's your understanding that the transcript that's in front of you that you were just reading from, that Aaron Dillard had access to it while at the jail.
Yes, he may have. He was in the same cell.
Nothing further, Your Honor.
All right. Do we have exhibits that are by the doctor?
Just one. Oh, two.
Let's collect them. You're free to go. Thank you.
Thank you.
Right?
Well, Your Honor, I did have a few questions for on
You did redirect already.
Pardon me?
You did your redirect.
Yes, and
So we're
redirect.
not going to do double redirects. We haven't done it for any witness. We're not going to start here. So you are free to go.
Thank you, Your Honor.
Your Honor, we need to review the exhibits and make a decision about, make sure all the exhibits have been moved into evidence.
Let's go take our break right now while the attorneys do that. Please.
Oh, chat. That testimony went 12 rounds. I was losing
Jim?
my mind over here, chat.
We're off the record.
Mark over here needs to quit smiling, though. He's getting a little too cocky for someone facing life in prison again. Oh, man, that had my blood boiling. You guys were catching that too. Like Bobby Boy over here just read an entire transcript, and then Perry's doing it, and he's, oh, he can't do that. Shut up, Bobby. Sit down, you corrupt criminal. And even, dude, Facebook chat over here, guys, on YouTube, Facebook chat is catching the same stuff you're catching. All him sneaking in things he's not allowed to be talking about. This guy, dude, chat, this guy is a criminal. He is a criminal. That's not me talking. That's Never Stop Media talking. I am putting it out there. Sue me for defamation so I can file for discovery and get all the stuff. You are a criminal, Bobby Boy Jam Boy. You are corrupt. You intimidated people. You manufactured evidence. You didn't let people do their jobs so they could investigate this whole thing properly. You told them the answers, and you supplied them specifically with only things that supported your stupid theory. You are a criminal. You're corrupt. There should be a federal indictment, a probe, indict him, convict him, and send this criminal, corrupt DA to jail. This guy is a criminal. Crooked ass DA. You guys see why I investigate Kenosha so hard? I'm at guys, with Wauwatosa and Kenosha, if they just fell off the map tomorrow, I could sleep. I could sleep for once in almost 3 years. I could sleep. And they're off the record. They're having some kind of conversation we don't get to hear. Chat. We need to open up a serious investigation on Bobby Boy. For real. This dude's having back alley deals with snitches, making sure their testimony is what it's supposed to be. And for those of you that are not from here, because this was kind of pointed out with our other viewer in the little conversation, Madison is only 2 hours away from Kenosha. So, Bobby Boy definitely could have taken a drive, especially if he's having back alley deals. Missing paperwork, mice eating evidence. Now there's police reports gone too. Get out of here, dude. And chat, even if Mark Jensen is guilty, let's just say he is. And at this point, I'm about to go just make a goddamn sign and stand outside of the courthouse with a free mark for real. That's where I'm at right now. I don't know if you guys can see me in my camera. You guys pay attention. I am losing my mind over here. I was screaming at the top of my lungs. I'm surprised police are not at my house, thinking that I'm murdering somebody in my living room. Chat. I can't even do it with this guy. I can't. This guy makes me crazy. Craig Albee asked for a mistrial at least 3 times. I'm not even sure how many more times he did, because of the same tactics that Bobby Boy was doing in 2008. I mean, chat. And that makes me think, right? Like the defense, Man, their case in chief, it makes me think that their case in chief is just a massive mic drop. And that's why they've not done it. Because dude, and here's the thing too, is Bob, again, like, let's say that this guy's guilty, right? Let's just go with that theory. He's guilty. He did all the things and forget everything that we've all just, been pointing out for the last 2 weeks. He's just guilty beyond a reasonable doubt. The stuff that Bob is doing starts creating more appellate issues because he's bringing in stuff that the Wisconsin Supreme Court said you can't talk about this. I can't do a third trial, chat. I can't do it. I can't do it. Promise me, if there is a third trial, chat, just no matter where you live, we're all meeting outside of the Kenosha courthouse. we're protesting with free Mark signs. That's what we're in. Shit, by the time we get to a third trial, it's just going to be videos. Everyone's going to be dead. Oh, chat. I can't do it. This is such a stressful day already. This is too much, chat. Dave on Facebook still thinks Mark's guilty. Dave. Dave, come to the dark side with the rest of us and hold a free Mark sign. Shit. Oh my God. Look, Mark's definitely not innocent for sure. He's guilty definitely of watching Julie die. I think all of us could agree on that point. He's guilty of watching her die. I don't know why Bobby didn't charge him and 47 other people with conspiracy to kidnap witnesses, because that evidence was not circumstantial. Not in my opinion. That evidence said, no, you definitely did. Whether, you thought about it originally or you were freaking out that your little white ass was sitting in jail with the fellas and you wanted to go home because you're crying and getting beat up. He definitely plotted and schemed that whole conspiracy. So I don't know why he wasn't charged, but he's definitely guilty of that. He's definitely guilty of being a little scared crybaby white boy getting punked in jail and then plotting and scheming to kidnap a witness. That's easy. You're getting smoked over that. Kenosha stumping you over the head on that charge. Let's just go. Let's just stop streaming the trial. Let's just go to Kenosha and let's just go there. Let's just be protesters. Free Mark. Fire Jamboy. Dude, and Jamboy is losing his mind. And Perry's just like, are you there yet? No. It's fine. I'll wait for you. Let me know. Perry just sits there, Your Honor, objection. We got George W. Bush sitting here on 9/11 reading little fairy tale books. Sit down, Bobby. Let the grown-ups talk. Everyone on YouTube thinks that he needs a ski trip. He's in the bathroom right now. He's got his little key. he's doing a ski trip in the bathroom right now with Beverly. I'm sorry, Chad. I gotta laugh. Oh my God. And like, honestly, I don't even care about Mark at this point. You know what I mean? Just because of what I do, which is all this investigating corruption. I don't even care about Mark's innocence or guilt at this point. Like, I forgot Mark was even in the courtroom. You know what I mean? Although at one point I was waiting for Mark to stand up and yell objection. You guys over on Facebook, you missed the whole chat in YouTube. We we were like, oh shit, we need Daryl Brooks in here. We need him in here to object. Grounds, objection, subject matter jurisdiction, Attorney Brooks. We needed Brooks to build a little Fort Brooks around Bobby Boy. Oh God, the chat is spicy. Anyway, all right, sorry. I gotta be on comedy level right now because it's a very exhausting, stressful day for me. So it's all about jokes while they're on this break. Jury nullification. Bring Attorney Brooks down to the courthouse stat. Give him an energy drink of fucking Sierra antifreeze while he's driving down. He could be sipping on it as he's coming down to the courthouse. He could take it like one of those little 5-hour energy drinks, the little ones. It could just be a shot of antifreeze. He could drink it on his way. Have him build a little Fort Brooks around Bobby Boy so we don't have to look at him. And then maybe that camera blocks Matthewson too, so I don't have to keep looking at his stupid ass with his fucking 1970s mutton chops on the side of his fucking face. Fucking goofy ass looking motherfucker. And then he got scary ass fucking Nathan in there sitting next to him. They're over there holding hands and rubbing each other's fucking legs. And then everyone that said, you know, when CJTV comes and he's like, oh, I'm not friends with the right. Really? Why are you fist pumping these motherfuckers in the fucking courtroom? And I don't mean the right. I mean militia. I misspoke there. So sorry if I offended the right now. These fucking goofy ass wannabe toy soldier militia members don't even know what real fucking militia is. I'm surprised real militia don't go and smack these people in their fucking mouth. I'm not friends with them. Okay. Chat. So like I know, dude. So I gotta preface. I gotta say that. So I know Kenosha. I know the people that are sitting in this courthouse. I know the people that we're watching on the camera. So it's just more corrupt, dirty, lying people that defraud people that put other people's lives in danger. So all of us on YouTube, we in the chat over there, we all know who these people are. So we're making fun of them too. Oh, God. A lot of you don't know this. I used to do some stand-up comedy. I might go back to it. That might be a bit more fun than this. I might go back to it. Anyway, let's do the fake reporter voice. All right, guys. Well, thanks for tuning in today. All the new people. Hope you're having fun on our stream. I'm glad you're watching. Welcome. Be sure to share the stream out, everybody. Hit the thumbs up on YouTube if you like what we're doing here. Be sure to share the stream out, like and follow the pages. Subscribe, like, follow, become a member. Check out our new YouTube channel that's trial specific only. You'll miss all the great commentary because we won't do that over there, but you won't have to listen to me. Jennifer says, kind of sounds like I don't want to visit Kenosha. Just forget that town exists. It's a 100,000 person town that all had a massive group orgy together. That's what Kenosha is. There ain't no secrets in Kenosha. You wonder why herpes is so prevalent. It's because of Kenosha. Why do you think I left Kenosha? I don't want that shit. Nope. You know, it's crazy too, because like I'm looking at, if you guys, you remember when the trial first started and we watched Judge Milisauskis like snap on the DA, right? So I obviously clipped that because it's funny. So like I put up some funny clips too for you guys, right? Just for entertainment value, because I am a content creator at the same time. So that video, let me look, because that video, every day that video goes up by like 1,500 views. Let me look at where we're at now. Let me pull this up. This morning it was at like 17,000 something. Say God. Milisauskis snapping. Nobody cares about the penis stuff, but or the lewd picture. But that video has gone like viral at this point. Let me go on my back end. Let me see. That's funny. Kevin said, "Let me go in my back end." Let me look at my stuff. I gotta see how many views this video has, and then I can make my point. Because it's so funny. People that don't, we're at 18,245. So we went up almost 1,000 views since this morning. It's just fucking stupid. Dude, anyone that is not in this chat and watching with us consistently, right? Like there's tens of thousands of people that are siding with old Bobby boy. There's tens of thousands of people that are not listening to this case. And when we all saw Bobby, look, that video too, with Bobby boy snapping on the judge. That was the first clip. That was the first clip I put out. That's got 138 views. This is a great example of why there's so much misinformation and disinformation. It's selective viewing. And then you guys wonder why I get so pissy sometimes when I'm like, that's not what happened. Shut your mouth for a minute and listen. No. 18,000 people said this is what happened. Oh, God. I'm going to start fucking drinking again. I swear to God. Fuck. Oh, my world. 138 people ignored the fact that Bob screamed and yelled at Judge Milisauskis, but 18,245 people loved the fact that Milisauskis screamed at the defense when they were trying to stick up for their client. It's just funny. It's funny to me. Man. All right. Good stuff. We might do a special episode just clipping out all of the times that Bobby boy pouts and stomps his feet and whines and cries, and we're gonna call it. We're just all gonna get wine. We're gonna play Billy Joel, a bottle of red, a bottle of white, and we're just gonna call it the Wine and Wine Stream. Drinking wine while Bobby boy whines, playing Billy Joel in the background. Fucking, dude. And when Bobby boy, I keep making this joke on YouTube, but when Bobby boy finally gets arrested, okay, he can put his clue game in between sorry and trouble in the closet. All right. See, Ma, that's what I think too. Julie has has to be guilty and it went wrong. But creepy Mark totally helped unalive her. I don't think I think maybe unintentionally he helped by giving her the Ambien because he didn't know what she was doing. But he definitely sat and watched her die. But that's not a charge. So I don't know. That's a problem because that's not a charge, which is another thing. Why didn't Bobby charge him with that? Put 76 charges on the guy. You know what I mean? Like, ugh. You can't be, oh man. You're not that confident to charge first degree intentional homicide, right? Unless you are just fabricating evidence.
All right, we are back on the record on Mark D. Jensen, 2002 CF 314. The appearances are the same. Jury is back in the courtroom. I'll ask the state, Mr. Jamboys, what do you wish to do next?
The state would move Exhibit 53, 60, 61, 70, 82, 83, 84, and 87 into evidence, Your Honor.
Do you have all that?
And I think 61. I believe 61 also.
61 and 70.
71 was already.
Oh, I'm sorry. 71 was already received. So 60, 61, 70, 82, 83, 84, and 87.
All right,
And
those will be
53.
received. 53 also received.
Yes.
I would also ask that Exhibit 59 be received.
All right, that'll be received at this time also. Okay, so we have all the state's exhibits that they wish to move in, correct?
Yes, Your Honor.
So what does the state wish to do next?
At this point, Your Honor, the state rests.
All right, the state is resting, folks. Their direct portion has been completed. With that, the defense, do you wish to call a witness, Ms. Krause?
Yes, Judge, we'd call Jolene Bly.
All right.
And Judge, when we take a break, we will have a motion outside the presence of the jury.
Your motion's preserved. I know you called a witness, but I will preserve your motion and we can hear it.
Thank you.
Okay, so we're gonna figure out how to set up this whole jury room stream that we're gonna do. So if you guys want to be part of the jury room and debate your thing, Layla doesn't agree with any of my theory, I'd love to have you in the jury room. If you want to be part of it, let me know. Either write it in chat or send me an email.
Okay.
I want to
you
have a
remain
fake
standing,
jury with
raise
all
your
you
right
guys.
hand. You solemnly swear the testimony of this man to be the truth, whole truth, and nothing but the truth, so help you God. You can have a seat. Get as close as you can to the microphone and spell your first and last name, okay?
My first name is Jolynn, Jollynn. Last name is Bly, Blei.
Thank you. Go ahead, Ms. Krause.
Ms. Bly, I'm going to talk to you a little bit about what you were doing in 2007 as it relates to employment. Okay. Can you tell us where you were working?
I was working at the law firm of Glenn Fitzgerald in Albee.
And how long had you been working for Glenn Fitzgerald in Albee?
Just about 4-ish years, 4.5.
In 2007?
Yeah, I started in 2003.
And do you still work for that firm?
I do not.
When did your employment change?
It changed a couple of times. It changed in 2011 when the firm
Disbanded?
Yeah, and I was with Fitzgerald Law Firm until 2018, and then 2018 I started with Federal Defender Services of Wisconsin.
In 2007, what were your job duties?
I was a legal assistant.
And in 2007, did you know Mark Jensen?
I did.
And do you see him in court today?
I do.
And can you just identify what he's wearing?
He's wearing a dark colored suit, dark colored tie.
All right, the witness has identified Mr. Jensen in open court. Continue.
How did you know Mr. Jensen at that time?
He was a client in our office.
And did you work with his attorney and Mr. Jensen while he was a client?
I did.
And do you know the attorney that was representing him at that time?
I do.
And who was that?
Craig Albee.
And you worked with Mr. Albee?
I did.
What type of information or what were your job duties as it related to the Mark Jensen case?
Reviewing discovery, going through the case, organizing the case, working with Craig, doing any duties that he needed done, drafting correspondence, mailing things.
I want to talk to you a little bit about the mailing thing and drafting correspondence, okay? I'm going to show you what has been marked as Exhibit 94. Do you recognize that document?
I do.
And what is it?
It's a letter that I would have typed to Mark Jensen.
How do you know you would have typed it?
My initials are at the bottom, CWA-JMB.
And that just means that you're the one that typed it for Craig Albee?
Correct.
And is it on specific letterhead?
It is. It's on the Glenn Fitzgerald and Albee letterhead that we used.
Is it signed by an attorney?
Signed by Craig Albee.
And what was the purpose of this letter?
The purpose of this letter was to send Mark some materials from his case.
And does the letter identify what materials are being sent?
It does.
I'm going to refer you to item number 1 on that letter. And what does that say?
Testimony of Ed Klug.
Now, just to be clear, can you tell this jury when you wrote that letter?
It was typed on August 10th, 2007.
So based upon your knowledge of the case and all the help you had been doing, this was after the first hearing in the Jensen matter?
Yes.
It would have been after Ed Klug testified. It said his transcript, correct?
Yes.
I'm going to show you what's been previously marked as exhibit number 70. Do you recognize that as Ed Klug's transcript?
I do.
And does the date correspond with the letter that you sent?
There's no cover sheet.
Let me show you one.
Sorry.
It's Defense Mark 95.
Yes.
Does it have a date of Ed Klug's transcript or the testimony?
It does.
And what date is that?
Monday, July 30th, 2007.
And is that the transcript that was included on August 10th?
Yes, it is.
And that was enclosed with the letter?
Yes.
And item number 2, what is that?
Interview of Mark Jensen on April 21st, 1999.
Okay, I'm going to show you what's been marked as Exhibit 53. Can you tell me what I just handed to you Exhibit 53 is?
It's a transcript of an interview of Mark Jensen that was conducted on April 21st, 1999.
So does the transcript that I handed you, Exhibit 53, correspond to the letter that you sent Mr. Jensen?
Yes.
And that would have been the document that you included in with that letter?
Yes.
And does it say on Exhibit 53, as related to Mark Jensen's interview, who that included?
Yes, it included Sergeant Paul Ratzberg and Detective Heather Berg.
Thank you. Now, item number 3 on the letter, can you tell us what that is?
Exhibits introduced at the forfeiture hearing during the testimony of Rhonda Mitchell.
And so exhibits that were during that hearing.
Yes.
And do you remember what type of exhibit that was?
I don't specifically recall. I thought there was maybe a PowerPoint presentation. I don't recall exactly what was all included.
So it was some type of exhibit. It could have been a PowerPoint presentation.
Yes.
And then item number 4, can you tell us what that was?
Other computer information previously received.
And do you remember what that was?
Not, I don't remember.
Now, prior to July of 2007, Mr. Jensen would come into the office.
Correct.
And would he get the materials from his case when he came in?
Yes.
Is that generally when like police reports would be given to him or witness statements would be given to him?
Yes.
And after July of 2007, Mr. Jensen was no longer out of custody.
Correct.
So if Attorney Elby wanted to send or wanted Mr. Jensen to have materials, how would Mr. Jensen get them?
We would mail them to the jail.
Remember what jail you sent them to?
Kenosha County.
And do you remember sending packages frequently or was it pretty infrequent?
Pretty frequently after he was taken into custody.
Now, as a legal assistant, did you request records or jail records?
Yes.
And do you remember making a request of the Kenosha County Jail in the Mark Jensen case?
Yes.
I'm going to show you what's been marked as Exhibit 91. Is Exhibit 91 one of those requests?
Yes.
And is the request for like prisoner transaction list as it related to Mark Jensen?
Yes.
And that would have been from July 30th to September 24th. Is that correct?
Yes.
And then there was also a request for cell transactions or where somebody was located, both for Mr. Jensen and Mr. David Thompson.
Correct.
And did you also request a roster list of who was in the Kenosha jail on specific dates?
Yes.
I'm going to show you what's been marked as Exhibit 92. I'd like to refer you to Exhibit, I think 92 I just handed you.
Yes.
That's a list of items or things that were sent to Mark Jensen.
Yes.
And does it say the dates at the top as to when those items would have been received?
It does.
And can you tell us what dates those are?
July 30th, 2007 through September 24th of 2007.
And if you look at an entry on August 11th of 2007, does it say what the jail received?
2 LRG large envelopes from Attorney Glenn Fitzgerald.
Is that consistent with the letter that you sent out on August 10th of 2007?
Yes.
And do you remember if it was more than one envelope?
With what's here and with as much as we had on the letter, yeah, I do believe it would have been 2 large envelopes.
And when you look at that exhibit, there are other entries about materials received from the law firm.
Yes.
And that's from that July 30th to just September 24th, 2007.
Correct.
It doesn't have anything after September 24th, 2007.
It does not.
Was Mr. Jensen still in custody after September 24th, 2007?
Yes.
Would you continue to send him items as requested?
Yes.
I'm going to show you what's been marked as Exhibit 93. It's a 2-page document. These are certified records from the Kenosha County Jail. The first page of that document, can you tell me who that discusses?
Mark Jensen.
And does it say where Mark Jensen was housed during his time at the Kenosha County Jail?
Yes.
And does it say where Mr. Jensen was from August 14th to August 17th?
That's not a date on here, but I believe that he was in the same area during that time.
And does it say what area that is?
Cell block J, number 2.
And then if you turn to the second page, it talks about the cell transactions for Mr. David Thompson.
Correct.
And does it say when Mr. Thompson arrived in that same cell block J?
Yes.
And what day is that?
September 6th, 2007.
And does it say when he leaves cell block J?
It looks like he leaves on September 9th, 2007.
And then does he go back?
He does on September 10th, 2007.
It appears that at one point he's kind of out of the jail or
Yes.
out of the cell block.
Yes.
And I think that's September 10th.
Yes.
I'm going to show you what's been marked as Exhibit 96. We are not going to go through this all. It's a certified record from the Kenosha County Sheriff's Department. Ms. Bly, I'm going to ask you to go to the August 14th, 2007 cell block J.
Yes.
And can you tell us who was in cell block J with Mr. Jensen?
Joshua Jerkowski, Mark Jensen, Miguel Mendoza, Michael Smith, Christopher Watkins, Bernard Bush, Jason Whitner, Michael Hale, and Michael Ruiz.
You don't see an Aaron Dillard in the cell block on August 14th. Do you see an Aaron Dillard there on August 14th?
I do not.
And of the individuals outside of Mr. Jensen, how many of those individuals were white men?
Four.
I'm going to ask you to go to August 15th of 2007 cell block J.
Okay.
And how many individuals are listed on that day?
10, including Mark Jensen.
And do you see an Aaron Dillard on that day?
I do.
And outside of Aaron Dillard and Mark Jensen, how many other individuals are white males?
4.
I'm going to ask you to go August 16th. Cell block J. Do you also see Aaron Dillard in cell block J on that day?
I do.
And how many other white males are in cell block J on that day, besides Mr. Dillard and Mr. Jensen?
3.
So a total of 5 with those two. And then I'm going to ask you to go to August 17th of 2007.
Okay.
And do you see a Mr. Dillard in cell block J on that day?
No.
And how many other white males are in there on that day?
Including Mark Jensen?
Not including Mark Jensen, thank you.
5.
5. Including him, it would be 6.
Correct.
And as you looked at those records, you didn't see David Thompson at that point in cell block J?
No.
I'm going to ask you to skip ahead to September 6th of 2007.
Okay.
Do you see David Thompson in cell block J at that point?
I do.
Is Mr. Jensen still in cell block J?
Yes.
And then I'm going to ask you to go to September 10th.
Okay.
Do you see David Thompson in that cell block on September 10th?
No.
And then I think we had testified from the previous exhibit that he was there on the 11th. What about September 12th?
On September 12th, he is not listed.
Now, as Mr. Elby's assistant, you had an opportunity to review a lot of materials in this particular case.
I did.
And when Mr. Jensen was in custody, he wanted to receive those materials.
Yes.
And you made sure that he was provided with whatever transcripts, whatever scientific studies, whatever doctor's reports, or whatever witness statements were provided to Attorney Elby.
Correct.
It was your job to kind of copy those and then get those off to Mr. Jensen.
Correct.
I have nothing further.
Who's going to do the cross?
I am.
Go ahead, Ms. McNeil.
So the exhibit that you've just been testifying off of in front of you, what number is that?
96.
Sure.
And so these are the jail records that you asked for certified copies of, is that correct?
Correct.
Showing where inmates would be located at various times in the jail?
Correct.
Now, in terms of how the jail works, an inmate might be moved during the course of a day, correct?
I'm sure it's possible.
Obviously, inmates are moved within the jail.
Sure. Yes.
And so where an inmate is in a record depends on when that record is during the course of a day, correct?
I would assume so.
For instance, if the record is created to reflect where inmates are at like 8 a.m. in a certain cell block, then that record wouldn't reflect any changes occurring after 8 a.m.
If that's when it was printed, sure. Yes.
So I'm going to direct your attention to, this would be, let's see, page, this is a big document, so I'm going to try to go by page number. So I'm showing you page 6 of that document, although, again, it's a big document. So I think actually printed on the page in the upper right-hand corner would be page 4.
Correct.
But if we're looking at the pile of paperwork, it's page 6.
Okay.
And so then do you see at the top there, the top left hand where it says run 14-August-2007?
Yes.
And then it says 6:20?
Yes.
So it appears that when we're looking at that particular date, it's reflecting what the situation was at 6:20 in the morning?
It doesn't say morning or afternoon.
If I show you a different page, and I'm just going to go to, and again, this is in the big pile, so I can't really give you a page number, but I'll ask you what this page shows. You see there that that reflects in the top left-hand corner, 17 August 2007.
Yes.
correct? And then what cell blocks are shown on that page?
Well, the first couple are cut off. The last one I can read is J. Oh, I'm sorry, H-I-N-J. And I'm assuming there's nothing listed above that.
And then if you look again in the upper left-hand corner, the time there is 22:04.
Correct.
So while the other time, the 6:20, it didn't say morning, it appears that military time is being used.
On this document, it does, yes.
And this is from the same pile of documents, correct?
It is.
Okay, so then 6:20 would be morning, and then 22:04 would be evening.
It does not say that for sure.
Okay, but is that your understanding of these records?
I would have to get clarification from the sheriff's department to make sure that the 6:20 was AM. It's not 0620, like the 22:04.
But you agree that on the page that I'm showing you, it's reflecting military time at
It
the time.
is.
And is there any reason for you to think that military time would not be used through the course of all of these documents?
I don't have a reason to believe that, but I do not know for sure.
Okay. So you agree that Aaron Dillard was housed with Mark Jensen, according to these records, at least as of August 15th, 2007?
I believe that's what it was.
Do you need to see that page again?
Please. Yes, August 15th.
And then also on August 16th of 2007, Aaron Dillard was housed with Mark Jensen?
I believe that's so, yes.
Correct. Okay. And then I think it was your testimony that according to the record on August 17th of 2007, Aaron Dillard was no longer listed as with Mark Jensen in J Block?
Yes.
Okay. I'm just going to show you that page. Do you see that?
I do.
Okay. And then just take a look at that.
Yes, 20, yeah. She was showing me the 22:04 time.
So then just to ask you a question off that, that page from August 17th of 2007 appears to reflect a time of 22:04.
Correct.
And so in military time, that's 10:04 p.m.
Correct.
And then in these records that you were shown, it did show that Mark Jensen and David Thompson were together on September 11th of 2007. Is that correct?
I believe that was one of the dates, yes.
So just to be clear about these records and the times I was showing you at the top, is there any reason for you to doubt that that is in military time?
I don't have a, I can't say that for sure.
And you worked at a law office for years, correct?
Correct.
And then police reports are almost always in military time, correct?
Most of them.
So you would certainly be familiar with that through your work at the law office.
Correct.
And again, the time changes to reflect military time at the top of some of these records, correct?
The time changes to reflect military time?
So the record I showed you showed a time of 22:04.
Correct.
And so the other time being about 6:20, I think it said at the top, you have no reason to believe that at one point the record is not in military time and then within a day or two it is in military time.
No.
All right. Yeah, thank you.
Redirect.
Just quickly, Ms. Bly, when you requested those records, you just requested the records of the individuals in those locations between those dates.
Correct.
And that's what the jail certified and sent to you.
Correct.
And the information that you provided is from those documents.
Correct.
Do you have any knowledge about how the jail works
I
as it
do not.
relates to when they do their count?
I do not.
Or when they put the information from the count into the computer?
I do not.
Or when they update the transfers?
I do not.
Thank you.
Anything on that, Ms. McNeil?
No, Your Honor.
All right, you're excused. Thank you.
All right, give me a sec, chat. I'm just going to drop the thing for a second. Sometimes the internet gets a little funky. I didn't like how miles weren't matching.
92, 93, 94, 95, and 96.
Any objection?
No, Your Honor.
All right, they're all received.
Defense is going to call Lori Brinker.
What number is it?
Sorry, sometimes the internet gets a little wonky, and I don't like feeling like we're watching a karate movie.
Thank you.
Sometimes I got to drop the image. So if you guys end up noticing that, and for some reason I'm not seeing it or something, if you notice an audio issue or there's a problem with the image or I forget to pull the trial back up, just right away let me know. Sometimes I'm off in the other room and I don't see it, or I'm drafting an open records request and not focused on the actual video of what you're all watching. Just let me know if you ever see any issues or hear audio problems so I can correct it for you guys.
Standing when you come up here, raise your right hand. You solemnly swear the testimony in this matter to be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. You want to get as close as you can to the microphone. Spell your first and last name for the reporter.
Lori, Lori, Ranker, Ranker.
Thank you.
Ms. Ranker, did you previously go by Lori Brown?
Yes, ma'am.
Is there something that changed in your life which changed your last name?
I was married.
And can you tell the jury what you do for a living?
I'm a director of human resources for a nonprofit.
And prior to being a director of resources for a nonprofit, what did you do?
I worked at a law firm.
And what kind of work did you do for the law firm?
I was their law firm administrator.
Are you a lawyer by trade?
I am.
Did you go to law school?
I did.
And what year did you graduate law school?
1990.
Do you know a person by the name of Aaron Dillard?
Yes, ma'am.
And how did you first meet Mr. Dillard?
In 2006, I needed work done on my roof, and I contracted with Mr. Dillard to do repairs, roof repairs.
Prior to contracting with Mr. Dillard to do roof repairs, had you met him previous to that?
He was an acquaintance.
Do you remember if you met him on some type of personal site?
I don't recall.
That's fair. And did he, when he, is that on? When he introduced himself to you, was it as Aaron Dillard?
It was.
And you said you contracted with him to do some type of construction work?
Yes, I had a portion of my roof where the decking was, it looked like it was rotting and the shingles were coming off. And I showed it to him and he said, I could fix that. I recommend that you have an entire roof replacement. I've got a crew of guys that are my team and this is what we do. And I could fix that. He was very personable, very knowledgeable, and instilled a lot of confidence in me that he could effectuate the repairs.
Did you contract with him to repair your roof?
I did.
Did you also have a personal relationship with Mr. Dillard?
He was a friend.
And during the time that you contracted with him to do your roof and during the time that you had this friendship, do you have opinion as to the truthfulness and honesty of Aaron Dillard?
I do.
And what is that opinion?
I feel that he was not truthful or honest with me with regards to this project. I ended up being defrauded of.
I'm objecting to this, Judge. She can offer the opinion that is appropriate, but going further than that is not.
Why don't you rephrase the question?
I asked as to what your opinion was as to his truthfulness and honesty.
I did not feel like he was truthful or honest. No.
And was that based upon both the personal and business relationship with Mr. Dillard?
It was based on the business relationship with Mr. Dillard, yes.
Thank you, ma'am. I have nothing further.
We have any questions from the state?
No, I don't. Thank you.
You're excused. Thank you.
At this point, we are going to play a video. It is 3 minutes.
Is it a witness on the list?
It is Deborah Teagle Spears, and I don't know the number.
Number 27.
Thank you.
All right, while this is happening, there's half an hour left on the Facebook stream. Facebook only allows us to stream for 8 hours. We say that every day. Join us over on YouTube. We'll still be live till the end of the trial today. It's how it always happens. The last hour, Facebook gets jam moved. Nothing I can do. Never.Stop.Voices on YouTube. Jump on over there.
That seemed a bit loud.
Give me a sec. I'm going to drop this again. Something's wrong with the cord feed. I checked to see if it's my internet chat. I'm doing stuff on my other computer and it's working out fine. So I'm not sure. It's just the video. I don't know what it is. If it's my fault, I'm sorry. I don't think it is, but it might be. I don't know. I just feel like I'm in a karate movie right now. Or maybe that's just on my end. If it's not happening on your end and mouths are matching up with words, let me know that too, I guess. And then I'll stop freaking out that I'm Mr. Miyagi over here. I feel like I'm watching like a Bruce Lee movie. So just under half an hour left on Facebook. Join us over on YouTube. We're still live over there always. And then at the end of today, I'm not going to do a breakdown of testimony because I missed a bunch of it because I'm doing a bunch of other things. But I'm going to explain what we're going to do for our little pretend jury deliberation, our jury room. It's kind of a new thing that we're going to do here, where we invite the users, the viewers to come on and you guys go in a jury room. So I'm going to explain the rules, how it's set up so that it's fun. Nobody's yelling at each other, talking over each other, disrespecting people. And your cameras are not on. So just like they do in real life, you don't get to see the jury. That's how it's going to be in this too. Your cameras are not on. It's anonymous. I'm going to be the foreman. And basically you guys are going to talk. I'll interject to correct if there's a factual misstatement. But that's it. You guys are going to interject, or you guys are going to deliberate. So that'll be the end of that.
There, Aaron.
Do you remember I said warn me when the mouth is all messed up?
I didn't believe. I wasn't believing what he was saying. So
Just another victim. We didn't miss much. That's my fault. I muted it so I could talk to you.
His wallet one day because things just didn't seem right, and I got his real name. And I found out his name was Aaron Dillard and got his address and ran a check on him and found out he wasn't such a good person.
So how long did you know Mr. Dillard as Kyle Resnick before you realized his proper name?
About 2 weeks.
And then did you know Mr. Dillard for a while after that period of time?
I tried to stay, once I figured out his name, I tried to stay friendly with him in hopes to return some of my money, recoup some of my money back.
Now, based on your contacts with Mr. Dillard, Ms. Teagle, did you form an opinion as to Mr. Dillard's character for truthfulness?
He has no character, in my words. He's not a very truthful, honest person. He's a con man. He uses people and for what he can get out of them, and that I don't have anything very nice to say about Kyle or Aaron.
Thank you, Ms. Teagle.
No further questions, Your Honor.
And then, Judge, we have one more video to show.
What number is the witness?
Frank Quintana.
Thank you.
Same exhibit, item number 3.
And spell your name for.
Oh, sorry. I just wanted to check the volume. I think this is about 11 minutes.
And spell your name for the court, sir.
Frank Quintana, Quintana.
And you're currently in you're in the Walworth County Jail to appear in this court, but you're currently in the Kenosha County Jail, is that right?
Yes.
At some point, did you meet Mark Jensen?
Yeah, in September.
And was that in the Kenosha County Jail?
Yes, it was.
Do you know what dates you were in the Kenosha County Jail in September?
It was September 7th to the 10th.
And do you recall what cell block you were in at that time?
In the J block.
You were in the J block?
Yes.
And did you have occasion to have conversation with Mr. Jensen during the time you were there between September 7th and September 10th?
Yeah, I think I asked if I used his paper, Kenosha paper.
just to read the newspaper? Did you have any more substantial conversation than that you recall?
Not really.
Did you have a chance to observe Mr. Jensen in the cell block during the period of time you were there between September 7th and September 10th?
Yes.
And what did you observe, sir?
A couple guys taking advantage of him.
And when you say you saw a couple guys taking advantage of Mr. Jensen, could you explain that for me?
Well, there was one guy, I was in cell 3, and then there was 2 guys in cell 4. And the bigger guy, I believe was Thompson, kept pretty much bullying Jensen, asking to make a bunch of calls for him, 3-way phone calls. And then Saturday, we have little totes in your room to put your belongings. He threw his in Jensen's room and told him to fill it up with canteen or he's going to put some blood in his mouth. And he'll be drinking out of a straw or eating out of a straw.
Now, this was Mr. Thompson said this to Mr. Jensen?
Yeah.
And well, tell me that last part about the canteen.
Yeah.
What do you mean by canteen?
Saturdays you can order. Well, you order on Wednesday, you get canteen on Saturdays. And Thompson kept telling Jensen he had 2 minutes to give him his commissary, or he's going to put blood in his mouth and he'll be eating out of a straw.
And that's something that you personally heard?
Yeah, I was there.
And do you know how many days after you arrived that you heard this threat?
That was next day. I got there Friday and Saturday. Canteen came.
So you think around September 8th?
Yeah.
Okay. And is Mr. Thompson depicted on Defendant's Exhibit number 5?
He's top right-hand corner.
Is this Mr. Thompson?
Yeah.
And did you see Mr. Thompson engaging in intimidation of Mr. Jensen?
From what I seen, yeah. Jensen was scared of him. Kept telling him, thought he was kidding when he asked about his canteen. Jensen went up to Thompson a couple times and said, "You're not serious, are you?" And he said, "Effing yeah, I am. If you don't do it now, you're going to get blood in your mouth and some eating out of a straw or something like that." And then Thompson threw his little storage container in Jensen's room, and Jensen filled it up and gave it to him.
And what kind of stuff did he fill up the bin with?
From what I see, it was just like chips and candy and stuff like that. And Thompson passed it around to some of his guys in there.
Did Mr. Jensen make any effort to fight back or do anything?
No. He looked scared to me.
And with regard to the phone calls, did it appear that Mr. Jensen was doing that willingly or at the insistence of Mr. Thompson?
Well, I noticed a couple times Thompson was getting mad that Jensen couldn't get through to make them 3-way calls from him. And he kept trying and trying.
And was he engaging in any intimidating tactics?
Well, he kept yelling at him from what I've seen. I mean, the blocks are real small. You have one little table where everybody sits at, so pretty much see what's going on.
Did you make any effort to intervene and assist Mr. Jensen while you were there?
No, I didn't want to catch a case. I didn't want to catch any more trouble. I told the guard when I left Monday that I believe they should get Jensen out of there because he was taking advantage of him.
Now, on Monday, where did you go on Monday?
I went back to STF, Restorative and Transitional Facility.
And that's a different prison?
Yeah, probation and parole.
And, okay, so you went to a probation and parole hold facility. And when you were taken out, you had some conversation with the guards?
Yeah, I don't remember what guard it was, but I told him I felt that he should get Jensen out of there because taking advantage of him. A couple guys were pretty much, Thompson was the leader of them.
Now, had you become friends with Mr. Jensen?
No, I maybe asked him if I could, I believe I asked if I used the classifieds out of the coach paper, if I could read it. That's about all I talked to him in September.
And why is it that you felt you should say something?
I don't know, because I thought it was BS to get taken advantage because there's a lot of that going on. in jail. If you can't defend yourself, they're gonna take your belongings. That's how it is in there.
Did you see anybody else giving Mr. Jensen a hard time?
I think Thompson, Sully was kind of egging Thompson on too about going to get some commissary.
Mr. Quintana, well, it appears because you come to us from the jail, you've been convicted of a crime before. Is that right?
Yes.
And how many times?
Probably maybe nine times, maybe more. I don't know for sure.
Okay. And now, did you ever see Mr. Jensen again after September?
I came back to jail in December. We're in I block together.
Did Mr. Jensen remember you?
No, I had came up to him again, asked him for the paper because he had the Kenosha newspaper. And I told him that I remembered him back in September when they were taking advantage of him back then. And we talked a little bit, and he asked me if I'd come testify what I seen in September, and I said, that's fine. And nothing to lie about it. I told him exactly what happened.
Okay. Thank you, Mr. Quintana. The prosecution may have some questions for you.
Mr. Quintana, did you overhear any specific conversations between Mark Jensen and David Thompson about a problem witness for Mark Jensen?
What? I didn't.
A problem witness for Mark Jensen?
No, what I observed was about the phone calls and Thompson putting his empty tote in there to get Jensen's canteen.
Where was your cell in relation to Mark Jensen's cell?
I was the third cell right next to Thompson's, and Jensen's was the last cell, number 6.
Now, did you ever see Mark Jensen and David Thompson either standing or sitting against the back wall and talking among themselves?
I seen him when he gave him his commissary, and I think Thompson came back and tried to give him, I believe he gave him a couple of the bags of chips back or something. I don't know why, but.
So, and listen to the question carefully, please. Did you see David Thompson and Mark Jensen either sitting or standing against the back wall and talking among themselves?
No, I never seen it.
You never saw that happen?
No, I seen them talking by the telephones and by the TV.
So you did see them talking to each other, but it wasn't by the back wall?
Yeah.
It was by the television set?
Yeah, because Jensen kept asking him if he was serious about 2 minutes to give his canteen to him or not.
But, okay, that was one conversation.
Yeah.
Were there any other conversations that you saw or heard that occurred between David Thompson and Mark Jensen?
Maybe by the phones when he was having Jensen make 3-way calls from it about it.
Now, that conversation that occurred between David Thompson and Mark Jensen about the give me your commissary thing, did that occur earlier on, or was that later in the time that they were staying there?
It was sometime Saturday, I don't know exactly.
Sometime on Saturday?
Yeah.
And you had been in that cell block since Friday?
I think Friday night I got there.
So it was Friday night that you got there, so it was Saturday sometime during the day. It was the first full day that you were there that you saw this conversation. Now, you were there then Sunday and Monday also, correct?
I left Monday morning.
Oh, so you left Monday morning. So you were only there one day after that, and that was Sunday. Now, did you see any conversation that occurred between Mark Jensen and David Thompson on Sunday?
Maybe around the phones. I mean, I stayed in my room, which my room was right across from the phones. So
did you hear what they were talking about on that Sunday? But you did see them talking around the phone?
Yeah, I think it was for 3-way calls because Mark had told him, I heard Mark telling him that he tried to get a hold of whoever and he couldn't get through or something.
Did you ever hear David Thompson and Mark Jensen talking about a witness that was a problem for Mark Jensen?
No, I never heard that.
Did you ever hear the name Ed Clue while you were in that cell block with Mark Jensen?
No.
Did Mark Jensen ever talk to you about his case while you were in that cell block with Mark Jensen?
No.
Did you ever hear Mark Jensen talking to anybody else about his case while you were in that cell block with Mark Jensen?
No, not really, no.
Did you see Mark Jensen reading stuff about his case while he was in the cell block?
I might have seen him going through his papers when I went. His cell was back by the windows. When I walked by the windows, he might have been going through his court case.
Well, so you did see him doing
I've
that?
seen in his cell, I believe I seen him a couple times reading his court case.
Did you ever see him talking to anybody else when he was going through his paperwork?
Not that I seen, no.
Did you ever see him show his paperwork to anybody else while you were in that cell?
Not while I was there, no.
Thank you. Any further questions?
Nothing further.
You may sit down, sir.
And spell your name.
Judge, we would need a break at this point. We don't have an additional witness here. We have a longer video, but it would take up more.
Wait a minute. Are you moving in 104?
I'm going to, yes, Judge.
All right.
There's 2 more videos. There's 1 more video on that exhibit.
Oh, I'm sorry then.
But it's a longer video, so I don't think.
We have a legal issue that we still have to discuss, so we're going to do that now, so then we don't delay you at 8:30 in the morning.
So we're releasing the jury.
They are released. Please don't talk about the case. Come back at 8:30. They can be released.
All right, jury is done. Come over onto YouTube because Facebook's going to end. So you can finish watching us over on YouTube. We're going to break down this jury room idea that we have. And be prepared for the defense to file a motion to dismiss. It's standard in these types of cases. They'll probably get denied. It'd be odd if they didn't do it. But they have to be confident that the state did not prove their case beyond a reasonable doubt. Expect a motion to dismiss. So join us over on YouTube, guys. I know some of you on Facebook usually do jump over. If you're new on the Facebook area, jump over. Never.Stop.Voices on YouTube. You can click on the links that are on the Facebook page too. They are coming through the chat and all that. Never.Stop.Voices on YouTube. Come on over there, chat. Because Facebook just ends
Jury
abruptly.
is outside of the courtroom. We, I believe, have a motion by the defense that was made before the testimony started for the defense. So you can make your motion, Ms. Krause.
Judge, at the,
Oh, I'm sorry, Mr. Perry.
it's fine. She's the one who said there's a motion.
I'm swear to God, she said the motions. So
You're right.
all right. Are you going to make the motion?
I
now?
am, yeah.
All right.
This is at the conclusion of the state's case. The defense moves to dismiss insufficient evidence, insufficient credible evidence pointing towards establishing that Mark Jensen committed first-degree intentional homicide.
All right. I am going to quote.
Told you.
To what the motion is. It's a motion to dismiss at close of the state's case. It says, motion must be denied if, considering the state's evidence in the most favorable light, the evidence adduced, believed, or rationally considered is sufficient to prove guilt beyond a reasonable doubt. So I have to give the state the most favorable light here. And I do have, for the record, 3 notepads already full. We had 38 witnesses for the state. And we will start out with the first witness in this case was Ruth Vorvald, V-O-R-V-A-L-D.
Vorwald, Your Honor, Vorwald.
Thank you. She knew Julie Jensen. She indicated on December 3rd, 1998, she was driving north. She saw Mark Jensen on that day on Lakeshore Drive. Mark waved. It was in the middle of the morning, and she thought it was kind of unusual because Mark worked in Racine. We had Sharon Krause. She testified. She saw Mark on December 3rd, 1998. Indicated that Mark said to her that
Julie was gone, showed no emotions. We then had Teresa DeFazio, who testified under oath. She indicated, Julie said, I cannot use the computer. She would show up every Wednesday to help at the school. There was a statement that Julie made that my husband is going to kill me. She also indicated she told Ms. DeFazio she found a list of drugs, issues of overdose. She also indicated that her husband, Mark, was on the computer off and on, looking up areas. She also indicated, she said that Mark would make it look like a suicide. Carrie Ashley indicated she called Julie December 2nd, 1998. Mark Jensen answered. Mark said Julie was sick in bed. She also indicated she saw Julie's items in the garbage. She also indicated she saw Kelly Labonte in the house within a month. Eric Shore, the young man, testified in December of 1998. He heard David Jensen, the older boy, indicate information about his mother's health, indicated he was very concerned, said his mother was sick. She had heavy breathing. For the record, we talked about the actual breathing that was being mentioned under oath, in that his dad would not take her to the hospital. He also indicated he observed Kelly Labonte in the residence within a very short period of time. Laura Shore, that is the mother of Eric, indicated that she had information that Julie was sick. Angelina Martinelli indicated Julie was an excellent mother. She had the younger Jensen boy in preschool. Joseph Mangi, who at that time was principal of Bradford High School. Julie applied for a job there, sent the resume. They were going to hire her, and sometime December 1st or 2nd, he called Mr. Julie to tell her that she was going to be accepted for the job, and a male answered, and he said that that was Mark Jensen, and the statement by Mark Jensen was, Julie's asleep. She'll be asleep for a long time, and there was a laugh. Kimberly Noble, she indicated that Julie was a happy person. She was a good mother. We had Exhibit 9. It was a tape of Thaddeus Wojcik, W-O-J-T. He talked about conversations that he had with Julie. She was very upset over things regarding the children. And one of the highlighted items I have as to his testimony, he said Mark, meaning Mr. Jensen, was chasing Julie around with a glass of wine, and there was a syringe on the nightstand. She also indicated that this is Julie, that Mark was looking at porn sites when the door was halfway open or closed. Dr. Chambliss, Michael Chambliss, who was an expert, been in the field for 38 years, forensic pathology, indicated the autopsy that was performed, the exhibit was moved into evidence. He talked about the issue of the head on the pillow. That was an issue for him. He talked about ethanol, like glycol poisoning. the suffocation issue, and under oath, Dr. Chambliss said homicide as to Mark Jensen. Poisoning was a contributing factor. Edward Klug worked with Mr. Jensen. He was at this conference in St. Louis at the hotel November 6th, November 7th, 1998. Conversation after a banquet, a night of drinking. They're at the hotel, and Mark Jensen is telling Mr. Klug about poisoning his wife, going to websites, and trying to make it that it was not detectable in a normal autopsy. He would put it in her drinks, and that conversation Mr. Klug talked about. We also had records of phone bills of Mr. Klug calling his wife at that time, right after that. Mr. Klug also told, under testimony, he told Ron Reck, W-C-R-U-K, I believe. We had David Naring talk, a broker who had worked with Mr. Jensen, talked about the conversation again with Ed Klug. Mr. Naring also talked about the alcohol drinking that Friday at St. Louis that he saw. We had notes from Ed Klug. We had the tape of Ron Kosman, who was the original police officer in the case, as to the harassments. He talked about 20 photos that he was given by Julie. He talked about the porno photos. He talked about this extensive calendar that Julie had, all her activities that she had marked. Notes from Julie as to what she was doing. Had some information about purchasing property in November of 1998. There was something also when Officer Kosman testified, and the note that I have is that Mark Jensen said, Klug is stupid. Also, there's a note that Mark Jensen said that Julie was crying about a miscarriage. She locks herself in the bedroom. Mr. Kosman also continued to talk about the suspicious activity that was being reported at the Jensen home in 1992 through 1996, the phone calls, the harassment. Talked about the pictures of the porno pictures of the sexual information. David Naring testified, and Mr. Naring said that he's known Mr. Jensen since 1991. He indicated that Mark Jensen had a personal relationship, a romantic interest with Kelly Labonte. He also indicated divorce had come up and Julie was having some issues. He indicated Mark Jensen was looking for drug interactions on the computer at work. There was a conversation between Mr. Jensen and Mr. Naring whether Kelly should be at the wake, when she should move in, that is Kelly Labonte. Rosemary McNinnis, she worked in the office in Racine at work in summer of 1998. Mark Jensen was the branch manager. She said There were no harassing phone calls that were coming in. The brokers did not open up their own mail. Kelly Labonte Brooks, she married Mr. Jensen in February of 19. She married Mr. Jensen, but the relationship, she said, started prior to that. She met Mr. Jensen April 1998. The summer, Miss Brooks, also known as Kelly Labonte, was engaged to her boyfriend. She developed a romantic relationship with Mr. Jensen September of 1998. We had numerous email messages between Mark Jensen and Kelly Labonte that start in September. And I would indicate a lot of those email messages are flirtation issues as to some sort of romantic relationship. There's no other explanation from all those emails. They used to have letter codes that they used. I want you, I love you, I miss you, on basically every email. And this starts in September 1998, prior to the death of Julie Jensen. David Wilkinson, he's the one that was called to the scene. He indicated he came about 4:32 p.m. to the Jensen residence. Julie was already dead on arrival. EKG was performed, nothing. The phone was off the hook. He looked at the photos of the deceased. He said he was dispatched 4:32 p.m. He arrived 4:35 p.m. at the house. Paul Rasberg, who was, before he retired, was a lieutenant, but he was sergeant of the detectives of Pleasant Prairie at the time in December of 1998. He responded to the Jensen home at 4:30 on December 3rd. He had the video that we saw of the house. He showed that. He had the consent of Mr. Jensen to search. He took the home computer into custody. He recovered the computer and a hard drive. He indicated he gave that to the crime lab December 13th, 1998. He also indicated that he recovered some sort of cigar box from the Jensen home also that items were in. He found the daily planner of Julie. It was received into evidence. The last entry of the daily planner is August 19th, 1998. He had photos of the crime scene. And he did the interview of Mr. Jensen that was recorded, that we watched. There's also a transcript of it. And what's interesting about that interview, he's asking Mr. Jensen about his relationship to Kelly Labonte. And the exact answer that Mr. Jensen said, Kelly is just a friend. That's it. He doesn't say, I've been having sex with her. She's my lover. We've been having a relationship. He also tells Detective Rasberg, Julie did not get out of bed December 3rd, 1998. He also said Julie was in a serious condition. He also indicated I did not call a doctor. They seized the computer. They went. Lieutenant Rasberg also indicated they drove to St. Louis and they got the work computer. They dropped it off at the Department of Justice. So they got the personal computer, they go work computer from Racine. They also got the computer from regarding Kelly Labonte. They also have information, and this is Lieutenant Rasberg indicated that they have evidence of Julie's voice, and it sounded drunk. We had also information as to the searches on the computer, and that is the home computer. That is Jason Ruff, R-U-F-F. Division of Criminal Investigation for the state of Wisconsin. He was qualified as an expert digital evidence. Indicated the search at that time was on Yahoo. And they have searches that were done on this home computer from the Jensen residence as to, in October 12th, 1998, O'Hare Marriott website, somebody searching Morton's Steakhouse, downtown Chicago. And Kelly Labonte testified, that's where we were going to go in Chicago, Morton's Steakhouse, downtown Chicago. Searches for cruises. We got telephone records of Kelly Labonte and Mr. Jensen talking about, hey, maybe we're going to go somewhere else. Maybe we should take a cruise. There's searches of botulism, food poisoning, and they're all at very strange times. They're not during the day. 2 a.m., 3 a.m., 5 a.m. or whatever. They're all searches during the early mornings of the hour. There's searches for nicotine, searches for toxic alcohol, medicine, ethanol, glycol, poisoning, medication, overdoses, poison websites, antifreeze. Even on December 2nd, the day before the death of Julie Jensen, 9:30 p.m., there's a search for antifreeze. There's a search for, on December 2nd, alcohol consumption, rapid breathing, blood pressure issues. There's searches December 3rd, 1998, antifreeze poisoning, information as to shock, cardiac shock. 9:40 a.m., December 3rd, 1998. Searches for poisoning. Videos were watched. It's the home computer found in the Jensen residence. Meredith Perez, she worked at the office in Racine. She said there's no harassing phone calls, there's nobody hanging up, there's no swearing, there's no porno pictures coming in. Stacy Bauer talked about conference in St. Louis. Talked about the information that Ed Klug talked about. And she's the one that said, oh my God, he killed her. Joseph Crivasi, C-R-I-F-A-S-I, took the lab samples, blood tests, The antifreeze, or the ethanol glycol, is in Julie's blood. Perry Tarica. He's the individual that had the affair with Julie Jensen. He denied sending harassing pictures, making the phone calls. He also indicated that Julie is one of the nicest people he ever met. We call back Jason Ruff again, the computer expert. Talked about the searches again. We had a video of Joan Scully. She worked with Mark Jensen. Again, she indicated, I didn't find any porno photos, nothing received at work. Marion Passetti, she was part of the book club. She saw Mark the day that Julie Jensen died. Mark Jensen told her he could not get his wife to the hospital, said she had a bad reaction to medication. Never said anything about depression to her. Aaron Dillard. Obviously, there's a dispute as to his credibility, but he's testified as to what Mr. Jensen told him while they were in custody. Talked about Ed Klug testimony. Ann Lynch, a teacher, she knew Julie Jensen. She worried about Douglas having to go full-time in the fall. This is late 1998. She indicated the marriage was in trouble. Paul Griffin, Julie's brother. Talked about the family, the relationship he had with Julie. But we also have a recorded statement from Paul Griffin to Mark Jensen. And Mr. Jensen, in that recorded statement, he didn't know he was being recorded. Gives some different explanations as to what happened to Julie the last days. Said Julie was sick. She was taking medications. Mr. Griffin also indicated that he went to, which would be his nephew's birthday party, David, who was a young boy in 1999, January 21st. Kelly Labonte was there. This is, 3 weeks after the death of Julie Jensen? And Mark introduced her as a friend from work. And what did Mr. Griffin say? Kelly Labonte looked like she knew where everything was in the house. Very familiar with the house. David Thompson, interesting character. He's the one that agreed to kidnap Mr. Klug. And then when I was listening to him, I'm thinking, well, he's got prior convictions. We're not going to dispute that. But after his credibility was attacked, I was surprised to see what he does today. Pretty successful individual. Turned his life around. There's no dispute as to that. And we got these phone records where we got Mr. Jensen and Mr. Thompson and Mr. Thompson's ex-wife or his mother or his child talking about money being transferred, 500, 575, another 500. We also have Mr. Jensen on some of the phone calls to his mother talking about people sitting on other people. He was talking about his kids doing it, and that's kind of where he was going in those conversations. And he was dancing all the way around, but he was talking about somebody being sat on and something being taken care of, and that's why he needs the money. And then we also go back to the telephone conversation that he had with Kelly Labonte, where he's asking, hey, I need some money. And unbelievable, it's $500. And I need to get it to my parents. And I can't tell you what it's for, but I'll tell you later. So Mr. Jensen's talking about Ed Klug and the sitting and this kidnapping with Mr. Thompson, his wife, and his mother. And they're all recorded. David Ellis, obviously very limited information. He was the investigator that the Jensens had hired, but they canceled it. Gretchen Rosecki, the attorney for Mr. Dillard, talked about the letter that she sent regarding her client. Dr. Mary Mainland, the medical examiner for Kenosha County. She retired November 2020. Pretty impressive resume. She was a medical examiner in February 2005, left in 2008, went to Tampa, Florida. She's done 4,000 autopsies. She didn't perform this autopsy, but she reviewed numerous records, and both sides grilled her of what she reviewed, whether it was a medical record, a police report, photos, autopsy, transcripts. She talked about what her opinion is, and she was pretty clear, even after the cross that Mr. Perry did. She was pretty solid in her opinion. She talked about the phases of poisoning and how they would start, whether it's December 1st, 2nd of 1998, continuing, and what she saw in all the information that she had. She indicated Julie Jensen had 2 doses of this poisoning. It caused her death, and the manner of death is homicide. She talked the bruising on the body. So she was pretty adamant. So I got 2 experts say homicide. I got lots of witnesses that put Mr. Jensen in not a good position. So I think the evidence considered most likely in the state's light, there's sufficient evidence here to prove guilt beyond a reasonable doubt at this point. So the motion is denied. Okay.
Judge, I have one more issue. We have a transcript from Marvin Oakler that we're going to play.
Is he a witness?
He is a witness.
All right. What number is he?
Marvin Oakler.
Thank you. It says deceased transcript.
Yes. So we have generally agreed on all parts that should or should not be played, except for as it relates to him. The prosecution doesn't want us to play the part where Marvin Oakler talks about the Griffins. I have no objection to that. I'll make sure that that's taken out. But they also object to Marvin Oakler talking about his experience as a pastor at funerals. I think that's fair game based upon all the testimony of the prosecution's witnesses about Mr. Jensen's behavior at the funeral.
How long is the portion about the pastor talking about funerals?
Maybe 2 minutes.
I'm going to let it in. It's been an issue brought up by the state's witnesses that Mr. Jensen did not look like he was grieving. There's numerous witnesses. So it's 2 minutes. We'll let it in. And you're not going to play the portion.
That they object to as to the Jensen family? No, I don't have any issue of getting that redacted.
When do you plan to play your videos tomorrow?
Because we have 2 doctors testifying in the morning, not experts, but doctors, the afternoon.
All right.
So I would just request that the defense send me the new transcript of what it should look like, and then I can follow along with that.
Do you have a transcript typed up of the video?
I have his prepared transcript, and then I will get the video prepared. I didn't prepare it because we had to resolve this issue.
We've just been highlighting the transcript, and that's completely sufficient. I just want to be able to follow along.
Get her the transcript. Which doctors are you going to have tomorrow?
The plan is to have Dr. Paul DeFazio and then Dr. Richard Borman.
All right. Let me.
In the morning.
In the morning. Are they going to take up all of the morning, or are we going to go in the afternoon with them?
I'm hoping it's just the morning.
Okay.
But we'll see.
All right. Okay. Anything else from the state?
No, Your Honor.
Anything else from the defense?
No.
All right.
Thank
The
you.
jury has left, right? They're gone? Okay. See you tomorrow, 8:30. We'll give the defendant a call.
All right, chat. We knew it. We knew it. So again, it's a typical thing. You see this all the time. Defense files a motion to dismiss, right? They did it, I believe, during Rittenhouse too. That's another big case that I know you guys are all aware of. They do it in all these big high-profile cases. They have to. It's standard procedure. You know, and especially if a case is surrounding, you know, circumstantial evidence. So kind of expected there. And then we figured they were going to dismiss. I think, you know, realistically, right? Like, let's think about this logically. All eyes are on Milosauskas. All eyes are on this case. This case has gone through multiple judges, multiple appeals, Supreme Courts, all the stuff. Milosauskas would have been dumb to have, you know, granted this motion. That would have been problematic. He would not have been elected next year. His head would have rolled. Kenosha residents would have lost their minds. They'd be out there picketing it right now. So also, so you guys are aware, because I'm sure some of you are sitting there listening to what the judge pointed out, and then all of your theories went right out the window, and now Mark's guilty again. It's on the state to prove the case. So he does, even though we're all joking around about evidence in the chat, the judge is not going to bring up the evidence that the defense brought in during all the state's witnesses, any of the, you know, questionable things that like we've all chatted about. They're not going to do that. So he repeats, basically, you know, summarized, even though that was story time, summarized the evidence that the state put in, and he basically regurgitates their theory. Again, that's common. That's what they do, because he goes with the state, right? The defense doesn't even actually have to say a word ever in a trial. So now, I'm not a lawyer, but I know that much. That's why he just regurgitates what the state's evidence showed, right? So that's that part. It's a very interesting thing. We put a poll up because Holly wanted us to do that. I dropped the ball on that today because it's been a day. But is Mark guilty based on prosecution's case in chief? 42% of you said no. 31% of you said yes. 26% of you are undecided. Interesting. So we've heard a lot of things. We've heard the state. We've heard the defense. And basically, you guys are there's going to be a hung jury. And then Bobby Boy's got to figure out if he's going to retry this, if you guys were the jury. So, and that's based on 19 votes. So kind of similar to, there's 16 jurors, right? Because they have the alternates, but only 12 of them get to go into the room to deliberate. So that pretty close numbers if you guys were the jury, but it would be a hung jury at the end of the day. So they'd have to retry this again. So, what do you guys think? What are your thoughts? Put them in the chat, type quick. What are your thoughts? And then I'm going to talk about this jury room thing. And then I'm getting off because I'm cranky today. I'm kind of behind on editing video. So, what do you guys think? Put it in the chat. Let's address all those comments. If you guys have questions, whatever, type them down. Type. Fast. I put undecided because it's not over yet. You already know what I think. I know the poll was really about what we've heard so far, not about it's not over yet, but what we've heard so far. If you had to deliberate today, so I almost didn't put an undecided in there because of that reason. If you had to make a decision today, what would your vote be? I put undecided because you guys keep yelling at me when I don't put that in there. Jamie says he's guilty. You guys make me nervous if you guys ever sit on a jury. You guys really make me nervous. There's so many distractions in the courtroom too. You guys are missing all kind of stuff. But who knows? I don't know. Maybe he is guilty. Who knows? I don't think so, but whatever. What else? Who else? We got 22 people watching. Type. This is, Jamie, this is exactly like protest days. This is how I started off, chat, is with protest days. I started off literally just correcting people. They'd be like, oh, this happened. And I'm like, no, it didn't. I was there filming it. Go look at my video. And it turned into an argument. That's what this is too. Everyone comes in. Well, this is what they said. This is what they testified. No, they didn't. No, they didn't. Let me tell you what they said. That's not true. Okay. All right. This is why court TV and law and crime don't respond. They be losing their heads too. I just don't think there's enough physical evidence to prove that he's actually guilty. I mean, it looks bad, but the evidence lacks. Yeah, that's what I think too. I mean, they've definitely proven, right, if there were charges for these things, they've definitely proven that Mark's behavior is extremely questionable, right? And some people make, I don't know, they make dumb decisions, right? But I mean, even people that like let's say a loved one did die, right? And it's not on like a weird circumstance. Some people just do throw stuff out immediately because they can't look at it, right? And then maybe down the road they would regret that decision, but some people just do that. And then you have all these, you know, gossiping eyeballs like, oh, why did they throw that out? Like, that's weird. And some of that stuff, like, we don't know how we would be, right, until it happens. And we're also going to behave differently. So that does happen. I do kind of look at that, you know, where it's like, well, I mean, that does happen. But Mark over here, he's just doing a lot of, you know, questionable behavior things. You know what I mean? Questionable behavior things. Moving Kelly in a month later, asking if he should bring Kelly to the funeral, right? It's all stuff that makes us cringe. And, you know, I'm still stuck on the opportunist moment. Well, right. But that's the other thing too, chat. So, like, we know there's a lot of wacky stuff. And if a bunch of us, because I think there's a lot of us for sure that agree that at least in the moment, it's, if he didn't kill her, it's very opportunistic. And Jamie and I talked on the phone, and we could just picture him being real creepy, sitting in the rocking chair in the bedroom, just fucking watching her die. But the problem with that, and if that's why you're voting guilty, the problem is he's not charged with any of this stuff. He's not charged with being the creepy guy in the corner watching his wife die. He's not charged with conspiracy to kidnap. He's not charged with, you know, well, you're a moron with bad behavior and questionable decisions. He's not charged with any of that. So, you know, if you're basing those things on first degree intentional homicide, you're finding somebody guilty of a charge that they probably aren't guilty of. And then we got to call the Innocence Project and get these guys out. Yolanda still has doubt. Yeah, and yeah, you did. So Jamie did say when we talked on the phone that because of the opportunism that, and he may not have done any of the other stuff that he's being accused of, but Jamie also thinks a secondary portion of her theory is that he did jump on her and he was kind of like, fuck it, like, hurry up. Like, let's go. You did this. Like, come on, hurry up already. And that is possible too. So he may not have just, I'm sure he was the creepy guy in the corner. I think he was doing that, but he may have jumped on her at the last moment. Shay says he's not being charged with looking like he did it. The burden of proof is on the mice. I mean, the state. It's so funny. You know, and I put in the chat earlier. I think the biggest problem, and this is where, you know, where every one of us is disagreeing on all types of things, is that if Bob would have just shut his mouth 20 years ago and just let everybody do their job, right? And if we didn't put a rookie detective in charge of a crime scene and he had supervision, there should have been somebody with more experience doing that, and he should have been the secondary detective. He was not qualified to do this crime, right? And then you have Bob telling everybody what happened instead of allowing them to do their job. So we may not have been here today for sure, but we also may not have been here in 2008, right? They may have went with the conclusion that she intentionally unalived herself, which I still think is a wrong theory, but from the defense. You know, Scout said before that maybe that whole Gone Girl theory is too taboo for 1998, right? And maybe it's even though we watch movies now in 2023, and we know that these things happen, and we've seen these things happen. We've seen people stage this. I actually looked it up, and there's some pretty messed up cases of like Gone Girl situations. I even looked up cases about like intentional unaliving to frame people, and there are those cases as well. They do exist. So, but maybe the Gone Girl theory is still kind of too taboo, and it's still a risky, defense. And maybe even with, because we're saying, even though we think like even with the computer searches, right? Like why is Mark looking everything up that he's already talked to Kelly about? That doesn't make sense, right? And then the searches for Kelly's, and then what branch does she work at, right? All these things where it's like, it's very suggestive that Julie is doing this stuff, right? But again, it's just circumstantial that she did it. We can put an inference that it's more than likely her, but there wasn't that like damning evidence. You know what I mean? That says, the fingerprint, that, the password that showed that Julie logged on, right? But there is so much doubt because Julie did have access to the computer. It shows that she did use the computer. And we hear today, I don't know how many of you caught this, we heard today that there was searches for poison. This is another thing. How many of you caught this? There were searches for poison when Mark wasn't home. How many of you caught that? And then a couple of you are going to know what I'm talking about, and I'm going to be a little coded in what I'm saying here. But I made a big deal about the testimony yesterday with Thompson compared to 2008, that all these snitches and everybody is saying that nobody ever went in Mark's cell. Nobody was doing these types of things and blah, blah, blah. And Thompson testifies now that even he went in Mark's cell to go grab stuff. So that contradicts all the snitches, right? They all kind of lied. And they didn't jump on that yesterday, which really bothered me. But today, Attorney Perry got that stuff in through another witness, and they went hard about access to documents. There's a reason for that, chat. There's a reason for that. I think there's 3 of you that know what I'm talking about. That's why I say, chat, I put in the chat too, like, I wish I could share all the behind the scenes things that happen, and I can't. Question, was the judge ruling on record as, yes, of course. He kind of said there was some doubt in Dillard and Thompson. Yes, he does. That all is on the record. Shay says the snitches need to get their shit straight. Yeah, I mean, we've definitely proven that Mark is, probably not just a good human being in general, right? His character is really kind of bad. He's making bad decisions. He talks too much. He's not the most correct person. He definitely at the end there doesn't care about Julie. Because there's some things, Shay, just for legal reasons, I can't talk about. Sometimes there's stuff we can't say until we can say it. Like, I'll put it this way. This way you have your answer. There are certain big things that happen that, you guys, the general public, looks at me like I'm a crazy person. But because of what we actually do here, right? There are things that I am an investigative consultant on. So there's your answer. Once I can talk about those things, then I do. And there'll be something that's coming down the pipes that I'm an investigative consultant on. It's a very big thing, very big. And then you guys would go, oh, holy shit, this guy's not as crazy as he sounds sometimes. So, all right. Let's spend the last 15 minutes here. We're going to cut it right at the 9-hour mark. So let's do the last 15 minutes and talk about the jury room. Okay. Yolanda says, we need the juicy scoop. Yolanda, there's so many juicy scoops. I mean, we couldn't, like, here's some of you know this, some of you don't. So, like, during Kyle Rittenhouse, when he was caught in the bar with the beer, most people don't know it was us that leaked all those photos out. They were sent to us. We leaked them out. That was us. So we're responsible for getting his bond modified. Jump kick man, right? The guy that kicked him, that jumped at him and did the, Karate Kid kick at him. And nobody could identify him. So we identified him 7 months before 2 right-wing outlets came out with it. Unfortunately, the person that was supposed to notify us that they were finally saying the information never told us. And then these 2 outlets picked it up and put it out, which, kind of fucking sucked for us. But we did a stream and I proved that we identified them 7 months earlier, because I say that and people think we're full of shit. We did a stream and we proved it. We showed the emails that we sent it 7 months before. So there's juicy scoop for you. What else? I don't know. What else have we done? I talked about the Theo Edgecombe trial that we, got 50-person jury panel removed, right? That's scoop. I've told you guys some juicy behind the scenes scoop. When I can talk about certain things, I tell you. I do. And this is, I got yelled at for calling you guys baby birds, right? So it's like I'm the mama bird and I feed you little bits, little bits, little bits. That's what that means for anyone that wants to fucking attack me on it. So that's what it means. I just feed you little bits of info because sometimes I can't feed you the whole story yet. So I put it out there knowing that it's coming down the pipe later so that when you hear it, you're like, oh shit, that crazy guy over on Never Stop, he said this 9 months ago. What else did we do? There's another thing specific to Wisconsin, but we had, like the one cop in Wauwatosa, we've talked a lot about Wauwatosa today. He shot and killed 3 people in a 5-year period. And then his lunatic girlfriend, who's also a cop in another department, defrauded the city. And she ended up getting arrested on felonies and they prosecuted her. But we put out, I think it was like 2 days before. It was either 24 hours or 48 hours before. We broke the story that they were going to offer her a deferred judgment and basically drop the charges as long as she paid for she paid the city back and she resigned from the police department. They would drop the charges. So we broke that story. And then it was like a day or 2 days later that's exactly what happened. But that's only because we had an inside source and we got tipped off. Asking for a friend. What was your thoughts on the Casey Anthony? That's the chick that supposedly killed her kid, but she was found innocent, right? That's the big one. So there's a lot of stuff that we break first, and and then and then mainstream media picks it. There's a bunch of stuff too that mainstream media stole from us because they watch our pages, and not just me, but like my buddy Lockhart TV, like he breaks shit first too. Sometimes Mercado Media breaks some shit. He doesn't really do too much like newsy kind of stuff. But there are times he does, and he breaks some shit first. So like there's a lot of independents break stuff first, right? Because we're like nose to the ground and we hear shit. It's kind of weird because it's like, so we're like, we get the street ear, so we can break a story first. But sometimes when it comes to some of the bigger stuff, we don't hear that because sometimes the street doesn't even know. You know what I mean? So, so sometimes it's like that, But yeah, so Casey Anthony, I don't know. That one's super questionable. I wasn't really into these big trials back then. I don't know. She seems super questionable. I'm sure maybe if we tried her again in today's court, there might be some differences. I think certain trials, I think if we did it again today, that's why I really like the forensic computer kid, because he laid out, it was great to see modern technology going after archaic technology. So, but that's why that's what definitively changed my whole opinion. We had theories, but we weren't sure. But that's what definitively changed my entire opinion about who was actually on that damn computer. It's because of that kid and what he showed, the times and step by step what each search was and when it was done. That's why it's like, Mark's not doing this, dude. This is a spouse that thinks her husband is cheating, and she confirms it. And while she, and then she's putting her plan together. But that plan was being put together for, a decade, and then really put in motion in the last 5 years, and then full-blown effect in the last 60 to 90 days before her demise. So her former lawyer has been her sugar daddy since, and she works for him, and he funded the documentary, and she was coached. I do not believe Casey, just like I didn't believe Amber. Yeah. Hollywood cases. Yeah, I don't either. I just watched like a TMZ thing last night. It's probably because that one guy that came in the other night asking me about all these Hollywood cases and mysteries and whatever, and if I investigate those. Still not sure that was actually real, but yeah, I was at a point where I'm waiting on videos to render and all this stuff, and I finally ate for the first time at like 1:00 in the morning, and I popped on the TV and I was searching through the thing, and there was some TMZ biggest lies in like Hollywood, whatever. I think it was only like an hour long, but I watched that just because of that dude that came in the other day. But yeah. Okay, so the jury room. Yeah, you guys got me off on a million tangents. Okay, so here's the jury room. So here's what I want to do. When I get off the stream today, I'm going to go into my back end of the software. I have to see what my plan is, because there's like different levels that you pay for different things. So I have to see what my plan is, because I pay like $25 a month for the streaming software, which is also freaking me out, where it's like, come on, put this case on, hurry up, because we have maybe a week left on this plan, and then I'm fucked. I can't stream anything. So I got to see how many people I'm allowed to bring on the stream, because each plan is different, how many it allows. and I don't want to have to pay $50. First off, I can't, but I don't want to have to pay $50 a month to do this. I will if we can, it makes sense and we can get donations and things, but the idea is to have 11 of you come in, right? And you don't turn your cameras on, so don't be nervous about that. So just like a real jury, nobody gets to see you, okay? And then use your YouTube handles, all right? We fuck it. Let's just do juror 1, juror 2, juror 3. So then nobody even knows who's talking. We'll do that. Your jurors. So don't even like when you set. So like I'll send you a link, okay, and that link, and you can ask, the person that we did the breakdowns with. It's very easy, okay. We send you the link. You just follow the little instructions, and you should be able to change your name in there. So we'll just have you come in as juror 1, juror 2, juror 3, whatever, right? And then even the chat doesn't even know who you guys are, okay? And your cameras are off, so nobody sees you, okay? If we can bring 11, then I'll be juror number 12, and I'm just going to be the juror foreman, okay? Now, I'm not going to talk. I'm going to let you guys deliberate. Because if I talk, I'm going to be screaming and yelling at you guys that you weren't paying attention. So I'm just going to let you guys deliberate like you're a real juror. If I have to kind of jump in, like let's say you have a question, right? Because jurors are allowed to write down a question and send it to the judge or ask for a piece of evidence. So if you have a question like that, that's when I'll chime in and answer it. Okay. Yeah, but I'm very convincing, Shay. So, and I've been doing all these breakdowns, throughout this entire thing. So I want you guys to deliberate. I don't want to influence your decisions in that room. But if you have a question where it's a clarifying question, then I'll answer that to the best of my ability. Okay. I might make a mistake too, because I don't fucking remember everything, but I've got a bunch of notes. But I'll do clarifying answers for you guys. And then I'm going to set back and let you guys chat. Okay. We're going to have a limit on a time frame so that this isn't 5 hours of jury deliberation, because that's going to be insane. Right. And I'm not sure anybody wants to listen to that. So maybe we'll set it for 1 hour. Okay. The rules are going to be, 1, you change your name to juror 1, juror 2, and we'll have that stuff assigned. Okay. That's why I'm saying I want you guys to email me so we can do this behind closed doors and the rest of the chat doesn't know. Because if I'm like, oh, Shay, you're going to be juror 1, then everybody knows who it is. And then what's the point of hiding your thing? I want to try to make it as real as possible. Right. So I want you guys to email me so that I could be like, okay, Shay, you're going to be juror 1, right? And then I'm going to ask you just some fun, silly questions, whatever. You know what I mean? Like how they ask in real life. Like, what are your biases? Where do you work? Where's this? Where's, whatever, right? But I'm going to ask you like silly shit. You know what I mean? Like, what's your favorite food? What's your favorite color? Just silly stuff and I already have some questions written out, but silly stuff just so we can kind of mimic the whole process and to make the stream fun and entertaining. And we'll read off your answers, okay, to everybody. So I'll be like, hey, chat, like I asked juror number 1 these questions. This was their answers, right? It'll be funny, entertaining, whatever. It's going to be one person speaking at a time. There's no talking over each other. Okay, otherwise nobody can hear anything anyway. There's not going to be any rudeness. Nobody's allowed to get ignorant with the other person. If anybody starts doing that, I'll jump in and I'm going to pause and I'm going to say, guys, warning, talking over each other. Warning, you're being rude, whatever it may be. If it happens, we're kicking a juror off, right? So it's about, having fun and respect. So when you guys are in there, If you disagree with the thing, just point out your reasons and be like, well, the evidence actually showed this, or, in my opinion, I think it was this, whatever, right? I don't want you guys in there arguing. Let's not make it that real, right? But just respectful. And yes, it will be live. I'm going to live stream it. Okay. Now we might just do it on YouTube and try to make Facebook come over here. Probably just do it on YouTube. But yes, it will be live. Okay. So what I would like to do, what day is it? Tuesday. I'm just nervous that the defense is going to fucking rest on Friday. Because their big witnesses are coming tomorrow. Those are key. You need alternates. I might. We need people to sign up. I know a few Facebook people wanted to do it. I really just want to do it for YouTube. So they're going to have to kind of come over here. But yeah, so all right. And then let's pretend I can't have 11 of you on, and my level only allows for 6 people. And then we'll make it smaller. So, but those are the rules. There's no talking over each other. There's no arguing. There's no getting belligerent. If you do cuss, because like I cuss when I talk, right? We heard the other viewer when we did the little breakdown on Friday, which we'll do again this Friday. We'll do the breakdown. That they cuss. That's fine. I don't want you guys cussing in the jury room though, just because some people can take that weird, because I get accused of that all the time. Yeah, I don't want to be creating rooms in Facebook. And that's the thing too, is it doesn't allow me to do all this type of shit in my streaming software. It's more, I don't want to create Facebook rooms. It's got to come through the actual stream. Because YouTube, if I create a room in Facebook, I can't, it's too difficult to be streaming and trying to pull up multiple screens. I can't do it. I'm just saying, like, I normally live stream on both platforms, YouTube and Facebook, right? It streams on both. I don't think I'm going to stream it on Facebook. I mean, if you want the reason why, the reason why is because I don't make money on Facebook. Facebook isn't monetized where YouTube is. And I make 60 cents a day streaming this trial. So I need my 60 cents so I can go buy my 2 little packages of ramen. So, I mean, there's your transparency. That's why. Plus, again, with the cross-platform for brand strategy stuff, if I keep giving you guys all the stuff over on every single platform and it's the same stuff, I never get you anywhere else where I could potentially be making money. You know what I'm saying? So there's your transparency. That's why. It's a branding issue, and then it's a financial issue. So, but yeah, so if you want to be on the juror thing, okay, send me your email. And I think what we'll do, you guys tell me right now what you think. I'm nervous that the defense is going to rest on Friday, so that scares me. But if it happens, then we just do this once. But my plan was to do it when the defense or the state rested, and then do it again when the defense rests. And then that's the big, like, holy shit jury room. And then maybe that one's like 2 hours long. But my plan is to do the jury room Friday at 7 p.m. So that gives us time to end the stream for the for the thing on Friday. It gives us time to end it. And we'll do the jury room Friday at 7. So we won't have our viewer come on and do a breakdown Friday, because we'll do the jury room at 7 p.m. on Friday. That gives me time to set this up and you guys to send your emails and me to ask you your silly voir dire questions and all of that. What do you guys think about that idea? So, this is your guys' thing. I think it's awesome. I wanted to do this anyway, and then our viewer was like, "Hey, why don't you try it like this?" And I'm like, "Damn, that's even cooler." So, like, you guys give some really awesome suggestions, and I want to try to do like what you guys think is fun and enjoyable. And so, what do you think? Friday at 7, we do the jury room. Yeah, I don't want to send out notifications, JD, because I just want to talk about it here, just because of the stuff that comes at me. I don't want to be advertising too much on this. And I guess it doesn't fucking matter. They listen anyway. They're in the background listening. But I kind of want to, like, I don't want, like, what I'm saying is I don't want to be posting it on Facebook and, and then we have, like, people that aren't even in the chat every single day. You know what I mean? People aren't even in here watching our stream, and we're just going to have randoms. I want to do it for you guys because you guys are always here. But once we have it picked, like, it's set and ready, I know which ones of you are doing this, then yes, I'll advertise like, hey, we're doing this fun, cool jury room thing, blah, blah, blah. So, and ideally, like some of you are saying, like April's like, I really haven't been following that much. Ideally, it's those of you that, you've watched a great majority of it, not every waking second, but great majority. Not the ones that are coming in here like, I don't know what the fuck happened today, but I want to give you my opinion. Because then the rest of you are going to start acting like me. I don't want that. So, Friday at 7, what do you guys think about that day? Friday at 7. I know you already gave your theory, but nobody else knows why you have your theory. Nobody knows your theory other than what I just said earlier. Like, you'd be a good person. Boss is probably a good person to be in there. Scout is definitely a good person to be in there. But we do have some Facebook people that, they were saying they wanted to come. And, it's kind of interesting, too, because there's several on Facebook that are catching a lot of the same things we're catching and then talk about here on YouTube. But they also think this motherfucker is guilty. So it's kind of interesting, the dynamic there between Facebook and YouTube. So I want Facebook people over here, So I'm just saying I'm not going to stream it on Facebook. That's what I'm saying by that. It's not going to be streamed on Facebook. I'll share the YouTube out, but I'm not multi-platform streaming this. All right, Scout's in for Friday. Darlene said she's in for Friday. Okay, I'll put here's my email. Okay, so for those of you that are here, there's 21 of you, and most of you are lurking in the background. Okay, if you want to be part of this and you've watched a decent, significant amount of this trial, send me an email if you want to do it. All right. And again, we'll have you come in as juror 1, juror 2, no camera, any of that. I mean, you saw with like our viewer that came on and was giving their opinion. They didn't have their camera on. You know what I mean? So we'll do it for like an hour. You don't have to, it doesn't matter about like whether you're new to our channel, Lenora. If you've been watching the Mark Jensen trial and you think you have a pretty good understanding of what you've heard and the evidence and all of that, it doesn't matter if you're new to the platform, if you want to be part of the jury room. We just want people that have really paid attention, because we get, obviously with life, like people are working and they're listening to bits and pieces, and then people just really have no idea what's going on. Rachel says, I don't play well with others. I don't either, Rachel. I'm a lone wolf. Yeah, so it's just a live mock jury, like Scout said. That's all. So, and the idea is that we can just keep, streaming different trials, and then we do this for every trial. I think that's fun. I think it'd be kind of cool. This trial, I think, is obviously very different because we're able to see so much from the first trial. You know what I mean? Where, like, let's say we're doing, like, we do the suitcase murder, right? Or we do the Delphi murder, or we do the Idaho 4 murder. With those, like, sure, I can kind of dig into some stuff a little bit, you know what I mean? But even me, I'm going to be like you, listening intently, and I may not even have an opinion until the end of the case. Like, oh, I don't even know. You know what I mean? Whereas this one, because I'm from Kenosha and I kind of know like a lot about this, and we've had access to all this footage from 2008. You know what I mean? That's why I'm able to give so much background and all this stuff, where I'll probably be more hindered in other cases, but we'll still provide some details. But yeah, the idea is to be able to do this. See, Nightbot is getting crazy. Nightbot's over here timing people out already. I told you, after 5 p.m., Nightbot is on some shit. But yeah, I'd like to be able to just keep streaming trials. That would be wonderful. And then just be able to do this kind of jury room mock juror thing. I think it'd be fun. Be interesting. So let's plan on Friday at 7 p.m. We're going to live stream only on YouTube. Okay. But people from Facebook can, because all you're doing, all I'm doing is sending you a link. You're not, does this make sense? Am I fucking confusing everybody? I'm just sending you a link. So it's like you're joining a Zoom call, right? So obviously you don't need to be on Facebook or Twitter or Snapchat or YouTube when you're joining a Zoom call. Does that make sense? I'm just sending you a link. Right? Friday, 7 p.m. If you want to be part of it, shoot me an email. Okay? And then I'm going to ask you some silly, voir dire questions. Right? Just like they would in real life, but instead of us asking you these revealing, dangerous, sketchy questions where the whole world knows where you work, I'm just going to ask you silly questions. So just play along with the questions so that when I read the questions and give the answers, right, the rest of the chat that's watching, they get to giggle and laugh. Okay, so we're going to make it fun. We're going to make it as fun and interesting as possible. And we'll bring you guys in. And it's just, we're going to be very strict about the way you talk to each other, right? Because we don't want nonsense. So I'm going to be very strict about that. Just be polite and respectful and just tell your opinions and then figure it out. Okay. And we'll set it for an hour. That's the plan. If it is a little juicy and we need to go a little bit longer, we will. That's fine. Okay. If for some reason, because last trial, the state took 5 weeks, and that's because they had witnesses on the stand for like fucking 8 years. Where, we saw in this trial, like they zipped through like 5 witnesses in an hour. Those witnesses were on the stand for like 3 days in the 2008 trial. It was like, oh my God. So this has obviously been a lot faster. I really don't expect the defense to go another 2 weeks. But in the 2008 trial, they went 5 days. That's it. And then it took 32 hours for deliberation. So let's just pretend that Friday the defense rests. Then instead of doing the hour deliberation, we're going to extend it. Just because at that point the trial's over and, you know, whatever. So, and then obviously, again, you guys get more information because you've watched all the 2008 stuff that we've shown. You know, we're highlighting clips of like weird corruption, and I'm giving you so much background details. So it's kind of another fun dynamic to this, that you have more information than the current jury, which I wish they would at this point, but they don't. So if you can use that information too. Okay. But you have to stick to the Supreme Court rule that you are not allowed to talk about the letter, and you are not allowed to talk about the 2 voicemails. That's the one thing you cannot talk about. Okay. Are there any other ideas that you want me to add to this, or are there specific rules you want me to add to this? If you have an idea that you think would add to this little fun dynamic we're going to do, type it in the chat, or if there's a specific rule you want me to enforce. Are you going to give our jury outcome before or after the real one? No, at the end, we're going to, you know, like, again, let's say it's an hour, right? In the last 5 minutes, we're going to have you vote. And then whatever that vote is, that's the outcome. So there's no like, oh, it's a hung jury, let's go back and redo this. And we'll put up a little poll in the YouTube chat. So based off of all of your guys' deliberation that people are listening to, we're going to tell people they can't vote until, well, they can vote as you guys are deliberating and you're giving your little evidences, but we'll see what the YouTube chat vote is compared to what you guys vote for your final thing. But yeah, if you know, we cut it in that last 5 minutes, and I'm going to say, okay, jurors, we're going to take your votes at this point. Juror number 1, guilty or not guilty. And then we're going to tally it down. If you guys are a hung jury, then, you know, and it's, again, to just kind of replicate, like, what are the jurors thinking in the case today, right? And kind of mimic, like, and some of you have been to jury duty, some of you have not been on jury duty. So it kind of gives you a little understanding of what it's about and sort of how these things happen. And, you know, and obviously ours is a little bit more play, but can we do over-unders? Taking bets, setting up the book. But yeah, so by the end of the stream, the chat will know what you guys voted. And if we can do it again when the defense rests, then we'll do it again. And we'll set that one for like 2 hours, a little bit longer of a stream. So you guys have a little bit more time to deliberate. So, and it's fine. We can have like some of the same jurors come back, and maybe there's some other people that want to do it this time, right? Because I know some of you are freaking out and you're a little nervous and whatever. And that's fine. That's cool. That's why I'm saying, like, no cameras, not even your YouTube or Facebook names. You just come in as juror numbers. That's how they do it in real life too. Juror numbers. Forget what you saw in this trial where they're telling the entire world people's names. I don't know what that is about. Which reminds me, I did ask my buddy, like, did you go check to see if this was done? My corporate media buddy. And they have a request in. They're waiting on an answer. I didn't send one. I didn't send one on this, but I did follow up with him when I told the YouTube chat. I'm sorry, I missed the whole statement. about the doctor. I was on the phone. And that's the other thing too. So when the real trial, when the jury has a verdict, so like media finds that out, like we know, right? Like with Brooks, the jury, like they decided at 9:45 in the morning. I knew it at 9:45 that they were coming back at, I think it was like 10:45. So like I immediately, messaged Peter Tragos and I was like, bro, get your shit ready. Like they're coming at 10:45. I messaged Mercado Media and said, bro, get your fucking stream ready. They're coming at 10:45. They have a verdict. So the same thing will happen for us. We have somebody there and they're gonna let us know as soon as the jury has a verdict. And then, that's not going to be a scheduled stream because we're not going to know. And I'm not going to sit here for 14 hours waiting for the jury. And it's just us chatting and doing nothing for 8 hours. So that's why I'm saying, make sure you guys are subscribed everywhere and, all that stuff, because that's going to be we're just going live immediately as soon as we get that text message. So Ryan Scout says it's just for fun. We ain't freeing people. So, but yeah, it's just, you guys have been watching. I want to see what you guys think. And I'm actually curious on what pieces of evidence you picked up on and what your arguments are, because it is hard to type all this stuff. You know what I mean? It's hard to type when you're trying to like pinpoint like I do. It's hard for you guys. So I want you guys to be able to chat and talk and whatever. Jamie says, I believe this time the jury is going to be quick. As opposed to 32 hours? I don't know, dude. I don't think so. I think it'll be quicker. Well, you figure 4 days of deliberation, right? If they're doing 8 hours and it took 32 hours. I'm going to say 2 days. It's not going to be as quick as Brooks. They you know damn well they made their decision in the Brooks trial before they made that decision, the first time they heard him open his mouth. I think, and I'm kidding about that, but it was probably what happened. But I think what they did is they all got in that room. They said, look, the evidence is overwhelming. This guy did it. He's guilty. They took a vote. Everyone agreed. And because there was so much damn paperwork, I think that's what took them the most time. Because then the following morning, 9:45, they had alerted the court. So I think they were finalizing paperwork in the morning. And are we still in agreement? Yes. Great. Let's be done with this. Juror demographics is hard to pinpoint. Verification predictions, 9 men, 7 women. Who knows alternates, but men are usually less emotional. And I think they could do a not guilty. Yeah, that's kind of true. I will tell you from being in the courtroom at the Brooks case, the men could care less about anything that was being said. They looked bored out of their minds the entire time. And the women were intently paying attention. And I saw more men crying than I did women. So while probably what you're saying is statistically true, I think it differs for all trials. I was really surprised by that, being in the courtroom for Brooks. That was something I didn't expect. JD says they made it. Yeah, I believe they made their decisions. That could be something with this case too, because this is a popular case. Kenosha County, these are Kenosha residents, Pleasant Prairie residents, Somers residents. These people, I would have to safely assume that these people are looking at Jensen the same way Waukesha looked at Darrell Brooks. Because Kenosha County residents are pissed this case came back. And everybody listened to the first trial and thought he was guilty. So, and from like literally all the comments that are on my videos and everything, and I, you know, while we're sitting here, I do pop in court TV and law and crime, and I watch what people are saying. And fucking, I'd say 95% of people still think he's guilty. So, but all right, last chance. You guys have anything else to say? Any other comments, statements, questions, rules for the jury thing, ideas for the jury thing, comments in general, questions in general? Last chance. I'm going to have one more cigarette and I'm getting off. I got to go. So that's my timers. When my cigarette is out, I got to go. I will try to not be crabby tomorrow. Some of you missed what happened and thought I was just freaking out on people for having a difference of opinion. It wasn't. It's because I was immediately getting attacked and personally attacked. It wasn't just talking about our theories. It was personal attacks. People came in here on bullshit this morning. My mods were messaging me within 3 minutes saying, do you want me to block this person? I just kept trying to let it go, let it go, let it go. So hopefully tomorrow we don't have that. If that happens again, first thing before I even say, hey, everybody, welcome to the stream. We're just blocking people. I don't care anymore. I'm not going to have that. Really screwed up the first 4 hours of the stream, and I missed half the goddamn day of testimony. So you guys got till the end of my cigarette. So what else do you want to, and if you want to ask about anything else or make comments about anything else, now's the time for that too. It's kind of a end of chat, like whatever, 5 minutes of whatever you want to talk about. That's why I texted you, Jamie. But when you texted me, that's why I texted you. I was like, well, did you see all the shit that happened immediately? Lenore, how do you subscribe? So there's on the homepage of the Facebook, there's you'll see like all these tabs and all these things, and there's a subscribe button. And then the little bell, you'll see an icon for a bell. And you can click all notifications. So it should notify you when we go live. There is a little bit of trickiness to that too, because sometimes you got to make sure your back end of YouTube also the toggle is switched that you get notified. And sometimes though too, it depends on your phone. You may have to change that in like your app settings. So even if you do subscribe to my channel, some people are not being notified because it's not turned on in the back end of their YouTube and on their phone. But try it with just the subscribe and hit the bell for all notifications. And then we also have our Facebook page, which is NSM News Updates. So you can like and follow the Facebook page if you still have a Facebook page. A lot of people have deleted Facebook. And then we just created another YouTube channel that we're only going to put trial content on, because I do a lot of investigative journalism and I'm trying to like separate the different content. So we just created that channel yesterday morning. So same thing, you can go there and subscribe. We can't go live on that channel yet because we have to have 1,000 subscribers and 3,000 hours of you guys watching. So a great way to do that is, I know you've seen a lot of these videos that we've popped up, but when you're in the shower, turn your Wi-Fi on your phone and play the video over there to boost up our watch time hours. Because even if we have 1,000 subs and we don't have the watch time hours, we can't go live. So we're just trying to, like, I'll still stream the trials over here on this page too, but some people just don't like, you know, they don't care about protest world. They don't care about police corruption, which is fine. That's cool, right? And we don't want to we don't want to force those people onto the page if they don't really care about those things and they just really only want to watch trial stuff. So that page is only for trials, you know. Like there's also another YouTube page for just our Kenosha riot videos. I haven't even told you guys about any of that, but I also have another page that is specifically about Kenosha too. So I just don't really advertise that because I have so much content over here. But just trying to create things that kind of break up the content for different, you know, because each person has a different of like what they're interested in. You know what I mean? But yeah, on our homepage, and then, you know, there's all these buttons and all these things. Here, I guess I can show you. Let's pull up. So like, especially if you're on your computer, but it does show you on the phone as well. So here, I'll just screen share so you guys can see what I'm talking about. I think things are easier on the computer than it is on your phone. Okay, so on the YouTube page, if you pull it up on your computer, you guys won't have the customized channel and the managed videos. That's what my page shows. But somewhere over here, it'll say subscribe. And then this little join button that's here, this button's important too. So if you want to support the platform for a monthly membership, because some of our videos are for members only, and we want to do live streams for, you know, supporters. So it's 99 cents, $2.99, and $5.99. Okay, and we have a bunch of videos that are for 99 cents, and then some of our more highbrow things are $5.99. Okay, so that's that. And then you'll see these tabs whether you're on your computer or your phone that say videos, home, playlists. So if you only want to watch Mark Jensen stuff, then you can just hit the playlist for Mark Jensen trial and just watch that. If you want to watch, you know, Kenosha body cam footage, you hit the playlist for the different police departments that were there. You want to watch the Travis Ryan King trial, you know, that's all under playlists, right? So you'll be able to see that stuff. And there's all these different, you know, specific playlists. Videos. This shows you the videos that we uploaded. Okay, and there's hundreds and hundreds. If you click on live, this shows you our live streams that we've uploaded. Some of them are for members only. So if it's not letting you watch, it's because you're not a paid member. The community tab. So this is like where we do some posts. So we'll post like little quick update things about stuff, or like if I wrote a new article, we post that stuff here. But our Facebook page, NSM News Updates, that's more like kind of daily news. So it is still like kind of centrally focused around the topics that we talk about on this channel. But I do kind of post some other things as well. You know, we're like our old channel, our old Facebook page was just all very police corruption and civil rights. Whereas the new Facebook page is, we've posted helicopter crashes. We've posted we've posted about factory explosions, stuff like that. A little more newsy over there. But yeah, that's that. So if you guys want to be on the jury room thing, I think that's going to be cool. I think that'll be really fun. And then we can do it for all the trials. Send me the email before Friday. I'll ask you the silly questions and we'll assign a juror number to you. The link we'll email you the link out that day when we're doing it. Because I can't send you a pre-link until I start the stream. So the link will come when we go live. I'll email out the link and we'll get you guys all in here and we'll do all that. Okay, sound good, everybody? Tomorrow, 8:30 again. I'll go live, 10 or 15 minutes before. So it depends on, usually I go live at 8:15. But the last couple days I've gone live at 8:10, or I'm sorry, 8:20, just because I've been a little behind on the video editing. So my plan is to get a bunch of videos up and edited today, and we'll try to do 8:15, but it might be 8:20 we'll go live. But the trial is supposed to be 8:30. Okay. All right, chat. That's it for me today. I'm out. I'm going to get to editing, deal with some other stuff we got going on, and I will see you guys tomorrow morning at 8:30.